in this context is that the legal machinery of lawyers, judges, prosecutors all came from the same stock as before, that is, of same caste, class, attitude, and orientation. Hence, this is one of the major reasons why the judiciary did not adopt a very progressive approach. Even some of the experts went on to call the Supreme Court before the 80s as a rich man's court. This is because alleged turning of the Supreme Court to an economic activist to protect the status quo that led to judicial passivism. Some of the important decisions of the court are as follows. 1. In Vage Ravelo vs. Special Deputy Collector, Air 1965 SC 2017, the Supreme Court held that a differentiation or rates of compensation awarded for compulsory acquisition of private property between one for public purpose and another has no relation to the object of the act, disputed in the case. 2 LC. Golak Nath vs. State of Punjab, Air 1967 SC 1643, is a landmark case. A special 11-judge bench was constituted to determine the validity of Constitution, 17th Amendment, Act, 1964. The court, speaking through Subbarao CJ, declared that, a constitutional amendment is a legislative process. b. Amendment is law within the meaning of Article 13 of the Constitution. c. Parliament has no power from the date of the decision to amend any provision of Part 3 of the Constitution so as to take away or abridge the fundamental rights enshrined therein, etc. This judgment had secured the paramountcy of fundamental rights and established that even the constitutional amendment was subject to judicial review on the ground of violation of the fundamental rights. This has also laid down the doctrine of prospective overruling for the first time. 3. Kesavayan Dabarathi vs. State of Kerala, Air 1973 SC 1461, also called the Fundamental Rights Case, a 13-judge bench of the Supreme Court dealt with the validity of the constitutional 24th Amendment, 25th Amendment, and the 29th Amendment Acts. The summary of the verdict delivered by the majority 9 out of the 13 is as follows. A. Golak Nath's case was overruled. b. Article 368 does not grant power to amend the basic structure or framework of the Constitution. c. The first part of Section 3 of the Constitutional, 25th Amendment, Act, 1971 is valid. And the second part, wherein no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy, is invalid, etc. Basic structure. The court did not define what constitutes the basic structure, rather they chose to provide the various features as basic features of the Constitution. They include: I. Constitution is supreme. 2. Republican and democratic form of the government. 3. Secular nature of the Constitution. 4. Separation of the powers between legislature, executive, and the judiciary. 162 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary 163. V. Federal character of the Constitution. 6. Fundamental rights and freedom. 7. Sovereignty of India. 8. Mandate to build a welfare state and an egalitarian society. 9. Any of the fundamental rights. The above list is only illustrative and not exhaustive. Thus, the court has now given to itself unprecedented power which has unparalleled anywhere in the world to test the validity of a constitutional amendment. 4.7.6 Judicial activism in India post-1980s. The following are the trends that emerged after the 1980s and are presently continuing. 1. Expanding the scope of Article 21, in the Maneka Gandhi vs. Union of India, Air 1978 SC 597, the Supreme Court delivered an epoch-making judgment. Justice Bhagwati expanded the scope personal liberty under Article 21. He declared that the expression personal liberty in Article 21 is of the widest amplitude, and it covers a variety of rights which go to constitute the personal liberty of man, and some to them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. Another important aspect of this judgment is that it established the requirement of reasonableness of procedure in Article 21 through Article 14. This led to the conversion of procedure established by law to due process of law as given in the American Constitution. Since this judgment, the Supreme Court has rendered a number of judgments expanding the scope of Article 21 to include social rights, economic rights, human rights, and legal rights which enable a man to lead his life with basic human dignity. Right to privacy, right to education, right to fair trial, right to health, right to gender equality, right against torture, right to livelihood, right to medical treatment are some of the various rights which are now included under the scope of Article 21. Right to life. 2. Curative petition. The Supreme Court has invented a new tool for rendering complete justice called the curative petition in the case of Rupa Ashokara vs. Ashokara, 2002, 4 SCC 388. Justice Shah Mohammad Quadri in this case observed, the petitioners in these writ petitions seek reconsideration of the final judgments of this court after they have been unsuccessful in review petitions, and in that these cases are different from the cases referred above. The provision of the Order XL Rule 5 of the Supreme Court rule bars further application of review in the same matter. The concern of the court is now whether any relief can be given to the petitioners who challenge the final judgment of this court, though after disposal of review petitions complaining of the gross abuse of the process of the court and irremediable injustice. In a state like India governed by rule of law, certainty of law declared and final decision rendered on merits in a list between the parties by the highest court in the court is of paramount importance. The principle of finality is insisted upon not on the ground that a judgment given by the apex court is impeccable, but on the maxim interest republici ut sit finus litium. The upshot of the discussion in our view is that this court, to prevent abuse of its process and to cure a gross miscarriage of justice, may reconsider its judgment in exercise of its inherent power. 163 16 hours 37 minutes and 17 seconds. 164. 3 Fake encounter killing by police. The Supreme Court in Praskash Kadam vs. Ram Prasad Vishwanath Gupta, 2011, 6 SCC 189, observed that this is a very serious case and this cannot be treated like an ordinary case. The accused, who are policemen, are supposed to uphold the law, but the allegation against them is that they functioned as killers. That in cases where a fake encounter is proved against policemen in a trial, they must be given death sentence, treating it as the rarest of rare cases. Fake encounter are nothing but cold-blooded, brutal murders by persons who are supposed to uphold the law. In our opinion, if crimes are committed by ordinary people, ordinary punishment should be given, but if the offense is committed by policemen, much harsher punishment should be given to them because they do an act totally contrary to their duties. 4 Honor killing. In Bhagwandas vs. State, NCT of Delhi, 2011, 6 SCC 396, the Supreme Court, speaking through Justice Markanda Ekajua, strongly disapproved the honor killings and advocated death penalty for those who are responsible for such killings. The court observed as follows. Before parting with this case, we would like to state that honor killings have become commonplace in many parts of the country, particularly in Haryana, Western Uttar Pradesh and Rajasthan. Often young couples who fall in love have to seek shelter in the police lines or protection homes, to avoid the wrath of kangaroo courts. We have held in Lata Singh case that there is nothing honorable in honor killings, and they are nothing but barbaric and brutal murders by bigoted persons with feudal minds. In our opinion, honor killings, for whatever reason, come within the category of rarest of the rare cases deserving death punishment. It is time to stamp out these barbaric, feudal practices which are a slur on our nation. This is necessary as a deterrent for such outrageous, uncivilized behavior. All persons who are planning to perpetrate honor killings should know that the gallows await them. 5 Caste System, in Arumugam Survey IVS. State of Tamil Nadu, 2011, SCC 405, the court called the caste system as a curse on the nation and observed as follows. In the modern age, nobody's feelings should be hurt. In particular, in a country like India with so much diversity, we must take care not to insult anyone's feelings on account of his caste, religion, tribe, language, etc. Only then we can keep our country united and strong. 6 Election Duty and Education, in the Election Commission of India vs. St. Mary's School, 2008, 3 SCC 390, the Supreme Court held that the legal requirement to provide staff to the Election Commission should be read with restricted meaning to use teachers for this purpose. Because holding of election should not result in neglect of education of children due to absence of teachers from the schools. 7 Privileges of the Parliament, in Raja Rampal vs. Honourable Speaker, Lok Sabha, 2007, 3 SCC 184, based on a sting operation which showed the MPs demanding money for asking questions and an MP asking for money for letting a NGO work under the 164 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary 165. MPLAD's scheme. A 5-judge constitutional bench held that the court has jurisdiction to deal with such cases even though they may relate to legislative privileges. 8. Role of judicial activism in unearthing black money. The Supreme Court has exhibited extraordinary spirit of judicial activism in the absence of little or no action by the government in order to unearth the black money. In Ram Jethmalani vs. Union of India, 2011, 8 SCC 1, the court speaking through Justice B. Sudarshan Reddy directed the government to appoint a special investigation team, SIT, to probe the issue of black money. 4.8 Judicial Reforms. 4.8.1 Rural Courts. One of the most important practical reform would be to constitute rural courts. The rural courts function within the territorial limits of the panchayats. If we see our structure of the judiciary, we can clearly see that there are too many judges to decide the constitutional matters both in Supreme Court and High Courts, but there is a dearth of local judges administering judges in the districts. Thus, there is an imbalance. Not all people can approach the High Court and their first resort is the local court, and thus local justice delivering mechanisms should be strengthened and a new kind of courts called as rural courts should be set up in the villages to address the local issues and thus enabling people and bringing them closer to justice. The procedures of this kind of court should be simple and uncomplicated so that rendering of justice is made flexible. These courts moreover should operate in the local language and they should be empowered to visit villages and hear cases and record such evidence locally. Specific time frame should also be fixed for delivering the verdicts. The Law Commission in its 114th report advocated setting up of Gram Nyayalaya which had the following setup. Degree the rural courts should be appointed with special magistrates having jurisdiction over a town, or a part of a city or a group of villages. Degree these special magistrates should be appointed by district judges for a term of 3 years. Degree they should have exclusive civil and criminal jurisdiction. In civil cases disputes up to 1 lakh should be taken and for criminal cases up to an imprisonment of 1 year. Degree apart from these other matters related to certain civil disputes arising out while implementing the agrarian reforms, certain property and family disputes and other disputes as entrusted by the Law Commission should also be covered by the courts. Degree in civil cases the revision of judgment can only be made by a district judge and that too on the grounds of improper application of law and nothing else. Degree in criminal cases where imprisonment is awarded, the appeal lies with the sessions judge. Degree the procedures are to be made simple and the verdict should be delivered within 90 days from receiving the complaint. 165 16 hours 37 minutes and 17 seconds. 166. 4.8.2 Indian Judicial Service. The subordinate courts are functioning with inordinate delays and lower efficiency. It is high time that Indian Judicial Service is set up as an All India service under Article 312 of the Constitution. All the offices of the district and the sessions judges should be held by persons recruited under such service after such adequate training and exposure. It should be a meritocratic service with competitive recruitment, having high quality and given uniform training. It will make sure that there are high standards of probity and efficiency which will ensure speedy and impartial justice delivery. A good number of judges for the High Court can also be drawn from this service. 4.8.3 Judicial Procedure. The Criminal Procedure Code, the Civil Procedure Code and the Evidence Act have to be revised in order to address the present-day judicial problems. In practice, these laws have become burdensome, tardy, and counterproductive. The right to get justice for criminal case within a year and for civil cases within 2 years should be guaranteed by the Constitution. All the laws should be amended to reflect such constitutional right. The appeals should also be strictly limited and only one appeal should be allowed for civil cases. Such appeals should be heard and verdict delivered within 3 months for a criminal cases and 6 months for a civil case. All the stays should be prohibited except in exceptional circumstances, and also reason for such stay should be given in writing. And no stay should exceed 15 days. The time limits specified for adjudication should be strictly adhered to, even in cases involving stay orders. 4.8.4 Higher Courts. The number of judges both in the Supreme Court and the High Courts should be substantially reduced and their appellate jurisdiction severely restricted. The jurisdiction of the Supreme Court should only cover matters related to interpretation of the Constitution and other matters of dispute arising between center and the states or between two states. Thus, the Supreme Court has to function like a constitutional court and a federal court. The High Courts should only interpret the Constitution to matters relating to the state legislature. The appellate powers of the High Court should also be restricted in order to reduce its caseload and for ensuring the sanctity and authority of the High Courts. Matter relating to service, taxation, disciplinary action against employees and other labor disputes should be dealt with special tribunals constituted for the same. Appeals. 166 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary. 167. Should lie to the High Courts only on grounds of interpretation of the Constitution, and thus the verdict of the tribunals should be final as such cases. The writ jurisdiction, which has now become all-encompassing, should be restricted and focused on right to life, liberty, and equality before law. And the courts should have unfettered powers in such cases to enforce their directions. 4.8.5 Judicial Commission. The mechanism of appointment of judges has become very problematic and ineffective. The Supreme Court, taking upon itself the complete power of appointment, has made the remedy worse than the disease. Nowhere in the world has the judiciary taken such role, undermining the institutions and functions of both the legislature and the executive. This practice of judiciary appointing itself is both selfing and counterproductive. Thus, a judicial commission of high standards has to be appointed from members drawn the executive, legislature, and the judiciary. Such recommendation should be made binding on the President. The removal of judges has become non-functional as under Article 124(4). The impeachment process is complicated and cumbersome, and hence no judge has ever been impeached. Such a situation whereby inefficient and corrupt judges functioning with impunity will lead only to judicial terrorism, causing disaster to governance process and people in the society. Hence, such judicial commission should be empowered to try such errant judges, and upon its recommendation the President should remove judges guilty of high crimes and transgressions. 4.8.6 Crime investigation. All the functions including crime investigation, intelligence gathering, law and order control, security of state and various other functions are all carried out by a single entity, the police. Hence, they are overburdened with numerous functions and not be able to do justice to any of them. Thus, the criminal justice system, which is wholly dependent on the police department, is very ineffective and inefficient. Hence, there is need to revamp the criminal justice system completely. The courts should hold the police force accountable for their overall functioning. The police force should be insulated from the politics by placing the investigation process under direct control of the prosecutors, who should be appointed as independent constitutional functionaries. By making the police force accountable to the judiciary, various inhuman practices of torture, third degree, and extrajudicial and fake encounters can be curbed. 167 16 hours 37 minutes and 17 seconds. 168. 4.8.7 Reinstatement of Values, Judicial Code of Conduct. In the Conference for the Chief Justice of all High Courts held in 1999, the following Code for Restatement of Values for Judicial Life was adopted. These would serve as guiding principles essential for functioning of an independent, strong, respected and impartial judiciary. These are not exhaustive but only illustrative of what is expected of the judges. These codes have been described as restatement of the pre-existing and universally accepted norms, guidelines, and conventions observed by judges. There are complete code canons of judicial ethics. It is given as follows: degree justice must not merely be done, but it must also be seen to be done. The behavior and conduct of members of the higher judiciary must reaffirm the people's faith in the impartiality of the judiciary. Accordingly, any act of a judge of the Supreme Court or a High Court, whether in official or personal capacity, which erodes the credibility of this perception, has to be avoided. Degree a judge should not contest the election to any office of a club, society, or other association. Further, he shall not hold such elective office except in a society or association connected with the law. Degree close association with individual members of the bar, particularly those who practice in the same court, shall be eschewed. Degree a judge should not permit any member of his immediate family, such as spouse, son, daughter, son-in-law or daughter-in-law or any other close relative, if a member of the bar, to appear before him or even be associated in any manner with a cause to be dealt with by him. Degree no member of his family, who is a member of the bar, shall be permitted to use the residence in which the judge actually resides or other facilities for professional work. Degree a judge should practice a degree of aloofness consistent with the dignity of his office. Degree a judge shall not hear and decide a matter in which a member of his family, a close relation or a friend is concerned. Degree a judge shall not enter into public debate or express his views in public on political matters or on matters that are pending or are likely to arise for judicial determination. Degree a judge is expected to let his judgments speak for themselves. He shall not give interviews to the media. Degree a judge shall not accept gifts or hospitality except from his family, close relations, and friends. Degree a judge shall not hear and decide a matter in which a company in which he holds shares is concerned unless he has disclosed his interest and no objection to his hearing and deciding the matter is raised. Degree a judge shall not speculate in shares, stocks, or the like. Degree a judge should not engage directly or indirectly in trade or business, either by himself or in association with any other person. Publication of a legal treatise or any activity in the nature of a hobby shall not be construed as trade or business. Degree a judge should not ask for, accept contributions or otherwise actively associate himself with the raising of any fund for any purpose. 168 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary. 169. Degree: a judge should not seek any financial benefit in the form of a perquisite or privilege attached to his office unless it is clearly available. Any doubt in this behalf must be got resolved and clarified through the Chief Justice. Degree: every judge must at all times be conscious that he is under the public gaze and there should be no act or omission by him which is unbecoming of the high office he occupies and the public esteem in which that office is held. 4.8.8 Judicial Standards and Accountability Bill. This bill will replace the Judges' Inquiry Act. This will be headed by former Chief Justice of India, and complaints of erring judges including the Chief Justices of High Courts and Supreme Court can be lodged by the public themselves. The 5-member committee will be appointed by the President on recommendation of 3-member panel consisting of the Prime Minister, any minister, and the Leader of Opposition Lok Sabha. On receiving, the complaints are forwarded to the Scrutiny Committee which has the powers of a civil court. If the charges are proved, the committee can request the concerned judge to resign. If the judge does not resign, the committee can forward such recommendation to the President for taking appropriate action. The bill also mandates that the judges should not have any close association with the members of the bar. All the details concerning the investigation of the judges should be put up on the websites of the respective courts. 4.8.9 Judicial Restraint against the activism. The activism is not validated as the courts should be concerned with the legality of law only. This also raises the question of accountability as the judges are not elected representatives of the people and they are also not answerable to the executive or the legislature. The decision taken by the bench too is not predictable. The role of activism by the judges encroaches upon the powers of other institutions of democracy and it is in violation of separation of powers. There should be a clear-cut procedure for acceptance of the cases filed under public interest litigation. Frivolous cases should be rejected and only cases of substantial public importance should be taken up. It will reduce the burden on the judiciary. Hence, there is need for restraint by the judiciary which will help in maintaining the balance of the democratic and constitutional system. April 8, 10 Amendment of Contempt of Courts Act. The Contempt of Courts Act needs to be amended. It should reflect the present condition of the society and curb the unwielded power granted to the courts to punish anyone. Some of the few recommendations in this connection are as follows. 169 16 hours 37 minutes and 17 seconds. 170. Every accused punished under the contempt of court should be given a reasonable opportunity to be heard. The courts themselves should not try such contempt cases. The cases should be handed over to independent commission of the district concerned. The words in the Act defining criminal contempt as scandalizing the court or lowering the authority of the court should be amended. April 8, 11 Alert Civil Society. The civil society has become the guardian of the democracy and it acts as the check against the transgressions by the state. The civil society thus has an active and vigilant role to play in the times of growing power of the judiciary. Literally, there is no check against the judiciary. None of the other democratic institutions could be able to check its growth. Hence, only public and the real people working and reflecting the wishes of the people manage to curtail its unbridled rise. The civil society can educate the public and raise in public opinion will have a great impact on the courts as the judges themselves are first members of the society. Thus, the civil society can act as a check against active judiciary and it can be able to protect the rights of the people and gives voice to the populace. April 8, 12 Role of media. The media, being the fourth pillar of the democracy, has a very active role to play in reforming the judiciary. The opinion of the masses can be taken to the ivory towers of the courts only with help of the media. Earlier the media was silent because of the threat of contempt of court. But since it has now been amended, the freedom of expression will not be infringed upon. Honest and credible media can indeed bring massive change in the democratic system. It not only reflects the opinion but also can shape up opinions. In the present era of governance, the media has immense role to play. The people depend more on the words of the media. The focus of the media can indeed bring about change. This can be seen from the focus the media gave to the Nirbhaya rape case, whereby the trial was expedited and the accused were convicted to be hanged within a shorter period. The role of media should also be appreciated for focusing on various other cases also, such as the Jessica Lal murder case, BMW accident case, Arushi Talwar murder case and numerous other corruption-related cases of high-profile ministers. 4.9 Bangalore Principles of Judicial Conduct. The following principles are intended to establish standards for ethical conduct of judges. They are designed to provide guidance to judges and to afford the judiciary a framework for regulating judicial conduct. They are also intended to assist members of the executive and the legislature, and lawyers, and the public in general, to better understand and support the judiciary. 170 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary. 171. These principles presuppose that judges are accountable for their conduct to appropriate institutions established to maintain judicial standards, which are themselves independent and impartial, and are intended to supplement and not to derogate from existing rules of law and conduct that bind the judge. Value 1 Independence Principle. Judicial independence is a prerequisite to the rule of law and a fundamental guarantee of a fair trial. A judge shall therefore uphold and exemplify judicial independence in both its individual and institutional aspects. Application 1.1 A judge shall exercise the judicial function independently on the basis of the judge's assessment of the facts and in accordance with a conscientious understanding of the law, free of any extraneous influences, inducements, pressures, threats, or interference, direct or indirect, from any quarter or for any reason. 1.2 A judge shall be independent in relation to society in general and in relation to the particular parties to a dispute that the judge has to adjudicate. 1.3 A judge shall not only be free from inappropriate connections with, and influence by, the executive and legislative branches of government, but must also appear to a reasonable observer to be free therefrom. 1.4 In performing judicial duties, a judge shall be independent of judicial colleagues in respect of decisions that the judge is obliged to make independently. 1.5 A judge shall encourage and uphold safeguards for the discharge of judicial duties in order to maintain and enhance the institutional and operational independence of the judiciary. 1.6 A judge shall exhibit and promote high standards of judicial conduct in order to reinforce public confidence in the judiciary, which is fundamental to the maintenance of judicial independence. Value 2 Impartiality Principle. Impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself but also to the process by which the decision is made. Application 2.1 A judge shall perform his or her judicial duties without favor, bias, or prejudice. 2.2 A judge shall ensure that his or her conduct, both in and out of court, maintains and enhances the confidence of the public, the legal profession and litigants in the impartiality of the judge and of the judiciary. 171 16 hours 37 minutes and 17 seconds. 172. 2.3 A judge shall, as far as is reasonable, so conduct himself or herself as to minimize the occasions on which it will be necessary for the judge to be disqualified from hearing or deciding cases. 2.4 A judge shall not knowingly, while a proceeding is before, or could come before, the judge, make any comment that might reasonably be expected to affect the outcome of such proceeding or impair the manifest fairness of the process, nor shall the judge make any comment in public or otherwise that might affect the fair trial of any person or issue. 2.5 A judge shall disqualify himself or herself from participating in any proceedings in which the judge is unable to decide the matter impartially or in which it may appear to a reasonable observer that the judge is unable to decide the matter impartially. Such proceedings include, but are not limited to, instances where a. The judge has actual bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceedings. B. The judge previously served as a lawyer or was a material witness in the matter in controversy. Or C. The judge, or a member of the judge's family, has an economic interest in the outcome of the matter in controversy, provided that disqualification of a judge shall not be required if no other tribunal can be constituted to deal with the case or, because of urgent circumstances, failure to act could lead to a serious miscarriage of justice. Value 3. Integrity. Principal integrity is essential to the proper discharge of the judicial office. Application 3.1. A judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer. 3.2. The behavior and conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done but must also be seen to be done. Value 4. Propriety. Principal propriety, and the appearance of propriety, are essential to the performance of all of the activities of a judge. Application 4.1. A judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities. 172. 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary. 173. 4.2. As a subject of constant public scrutiny, a judge must accept personal restrictions that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly. In particular, a judge shall conduct himself or herself in a way that is consistent with the dignity of the judicial office. 4.3. A judge shall, in his or her personal relations with individual members of the legal profession who practice regularly in the judge's court, avoid situations that might reasonably give rise to the suspicion or appearance of favoritism or partiality. 4.4. A judge shall not participate in the determination of a case in which any member of the judge's family represents a litigant or is associated in any manner with the case. 4.5. A judge shall not allow the use of the judge's residence by a member of the legal profession to receive clients or other members of the legal profession. 4.6. A judge, like any other citizen, is entitled to freedom of expression, belief, association, and assembly, but, in exercising such rights, a judge shall always conduct himself or herself in such a manner as to preserve the dignity of the judicial office and the impartiality and independence of the judiciary. 4.7. A judge shall inform himself or herself about the judge's personal and fiduciary financial interests and shall make reasonable efforts to be informed about the financial interests of members of the judge's family. 4.8. A judge shall not allow the judge's family, social or other relationships improperly to influence the judge's judicial conduct and judgment as a judge. 4.9. A judge shall not use or lend the prestige of the judicial office to advance the private interests of the judge, a member of the judge's family or of anyone else, nor shall a judge convey or permit others to convey the impression that anyone is in a special position improperly to influence the judge in the performance of judicial duties. 4.10. Confidential information acquired by a judge in the judge's judicial capacity shall not be used or disclosed by the judge for any other purpose not related to the judge's judicial duties. 4.11. Subject to the proper performance of judicial duties, a judge may a. Write, lecture, teach, and participate in activities concerning the law, the legal system, the administration of justice or related matters. B. Appear at a public hearing before an official body concerned with matters relating to the law, the legal system, the administration of justice or related matters. C. Serve as a member of an official body, or other government commission, committee, or advisory body, if such membership is not inconsistent with the perceived impartiality and political neutrality of a judge. Or D. Engage in other activities if such activities do not detract from the dignity of the judicial office or otherwise interfere with the performance of judicial duties. 4.12. A judge shall not practice law while holding the judicial office. 4.13 A judge may form or join associations of judges or participate in other organizations representing the interests of judges. 4.14 A judge and members of the judge's family shall neither ask for, nor accept, any gift, bequest, loan or favor in relation to anything done or to be done or omitted to be done by the judge in connection with the performance of judicial duties. 4.15 A judge shall not knowingly permit court staff or others subject to the judge's influence, direction, or authority to ask for, or accept, any gift, bequest, loan or favor in relation to anything done or to be done or omitted to be done in connection with his or her duties or functions. 173 16 hours 37 minutes and 17 seconds. 174. 4.16 Subject to law and to any legal requirements of public disclosure, a judge may receive a token gift, award, or benefit as appropriate to the occasion on which it is made, provided that such gift, award or benefit might not reasonably be perceived as intended to influence the judge in the performance of judicial duties or otherwise give rise to an appearance of partiality. Value 5 Equality principle ensuring equality of treatment to all before the courts is essential to the due performance of the judicial office. Application 5.1 A judge shall be aware of, and understand, diversity in society and differences arising from various sources, including but not limited to race, color, sex, religion, national origin, caste, disability, age, marital status, sexual orientation, social and economic status and other like causes, irrelevant grounds. 5.2 A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice towards any person or group on irrelevant grounds. 5.3 A judge shall carry out judicial duties with appropriate consideration for all persons, such as the parties, witnesses, lawyers, court staff, and judicial colleagues, without differentiation on any irrelevant ground, immaterial to the proper performance of such duties. 5.4 A judge shall not knowingly permit court staff or others subject to the judge's influence, direction, or control to differentiate between persons concerned, in a matter before the judge, on any irrelevant ground. 5.5 A judge shall require lawyers in proceedings before the court to refrain from manifesting, by words or conduct, bias or prejudice based on irrelevant grounds, except such as are legally relevant to an issue in proceedings and may be the subject of legitimate advocacy. Value 6 Competence and diligence principle. Competence and diligence are prerequisites to the due performance of judicial office. Application 6.1 The judicial duties of a judge take precedence over all other activities. 6.2 A judge shall devote the judge's professional activity to judicial duties, which include not only the performance of judicial functions and responsibilities in court and the 174 16 hours 37 minutes and 17 seconds. Issues concerning the judiciary. 175. Making of decisions, but also other tasks relevant to the judicial office or the court's operations. 6.3 A judge shall take reasonable steps to maintain and enhance the judge's knowledge, skills, and personal qualities necessary for the proper performance of judicial duties, taking advantage for that purpose of the training and other facilities that should be made available, under judicial control, to judges. 6.4 A judge shall keep himself or herself informed about relevant developments of international law, including international conventions and other instruments establishing human rights norms. 6.5 A judge shall perform all judicial duties, including the delivery of reserved decisions, efficiently, fairly and with reasonable promptness. 6.6 A judge shall maintain order and decorum in all proceedings before the court and be patient, dignified and courteous in relation to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. The judge shall require similar conduct of legal representatives, court staff, and others subject to the judge's influence, direction or control. 6.7 A judge shall not engage in conduct incompatible with the diligent discharge of judicial duties. Implementation. By reason of the nature of judicial office, effective measures shall be adopted by national judiciaries to provide mechanisms to implement these principles if such mechanisms are not already in existence in their jurisdictions. 175 16 hours 37 minutes and 17 seconds. 176 16 hours 37 minutes and 17 seconds. In this, you will learn about federalism, emerging pattern of center-state relations, impact of new economic and developmental policies on federalism, governor as factor in federal relations, introduction, impact of emergency on federal relations, coalition politics and its impact on federal relations, judiciary as a factor in federal relations, national security and its impact on federal structure, reinvention of self-governing institutions and decentralization, federal fiscal relations. Conclusion. 5.1 Federalism. 5.1.1 Federalism. Introduction. Federalism is a harmonious system of government, in which the powers are distributed between a union government at the national level and several provincial governments at the subnational level. It requires a minimum of 2 levels of government to create a federal state, i.e., the union government, which takes the responsibility for subjects of law that have a common national interest, and 2. The provincial or state governments that look after subjects of regional or provincial interest. Issues and challenges pertaining to the federal structure. 5. 177 16 hours 37 minutes and 36 seconds. 178. In a true spirit, these governments act independent of each other, when it comes to federalism. This is guaranteed by the proportionate division of subjects and their ratification through a written constitution. It is done so as to ensure a constitutional sharing of sovereignty that prevents the accumulation of unbridled power with the union government or vice versa. Notable examples of federal countries include the United States of America, Canada, Australia, Germany, Switzerland, and India. National government. States. Federation. 5.1.2 Types of federalism. A. Classification based on nature of federalism. The concept of federalism has evolved since its inception and has developed into different models. These models can be decoded as the following types: I. Dual/layer cake federalism. 2. Cooperative/marble cake federalism. 3. Competitive federalism. 4. Permissive federalism. V. The new federalism. I. Dual/layer cake federalism. In this model, the union government takes control of crucial subjects such as foreign policy, defense, communication, etc., leaving the rest to the provincial units. The domains of both governments are usually exclusive in nature. This characteristic feature gives it the name layer cake federalism. An important point to note here is that the union government hardly interferes into the domain of the state governments. The best example of dual federalism existed in the United States prior to the Civil War years. 2. Cooperative federalism. This form of federalism insists on the 2 levels working together as a team. The intergovernmental relations are mostly cooperative in nature, while the autonomy of the states in their spheres is not infringed by the union government. There is a confluence of powers, resources, and programs between and among the union, provincial and local governments. There are, however, possibilities of influencing the policies and decision-making of the state governments. The process of cooperation is ensured through several means. Usually 178 16 hours 37 minutes and 36 seconds. Issues and challenges pertaining to the federal structure. 179. It is done by creating vision documents in planning, dialogues in several center state fora, etc. For instance, the 15-year vision document being prepared by the NITIIIG in consultation with the states is a notable example. Similarly, the Goods and Services Tax Council includes representatives of both the Government of India and the state governments. As there is no watertight separation of domains between the Union and the states, this form of federalism is also called marble cake federalism. 3. Competitive federalism. It is a type of federalism in which the Union government, states, and local bodies compete with each other. This competitive spirit is held in order to provide a better delivery of services and inclusive growth to their citizens. The competition is visible in spheres such as investment opportunities, social welfare schemes and infrastructure development. It is to be noted that competition is not the opposite of cooperation. While through cooperation the units try to seamlessly operate and find solutions, through competition, they try to effectively implement these solutions as against their peers. 4. Permissive federalism. It is a quasi-unitary concept. As part of a federal setup, the states are provided with certain powers through the Constitution. However, they depend on permissions from the Union government to administer and take decisions with those powers. This form of federalism is found in instances where the states derive their existence and authority from the Union government. The new federalism. The concept of new federalism was a result of the advocacy that anything that falls outside the division of powers in the Constitution shall be entrusted to the state governments. The primary objective of this model is to reduce the disproportionate accumulation of power with the Union government. An example of this is the call for restoration of autonomy and power that the states had lost to the federal government of the United States of America following the New Deal of President Franklin Roosevelt. Through new federalism, the state governments receive block grants for nonspecific purposes or in general policy areas. Classification based on nature of formation. Federations can also be divided based on the nature of formation. The two common forms are, coming together model. Here, a number of independent states unite to form a larger unit so that they can increase their security while maintaining sovereignty. The constituent states hold equal power and are stronger in comparison to the Union government. 2. Holding together model. In this case, a Union government creates a second tier of government for the purpose of administrative convenience, especially when a larger scale of diversity in the population is involved. The model follows the principle of indestructible union with destructible states. 179 16 hours 37 minutes and 36 seconds. 180. 5.1.3 Importance of federalism. Protection of rights and liberties. The fundamental aspects of the Constitution cannot be amended arbitrarily by one level of government alone. Such changes require the acceptance of both levels of government. Judicial oversight. Courts have the responsibility to interpret the Constitution and codify powers of different levels of government, from time to time. Where there is a dispute among them, the apex court takes the role of a neutral arbitrator. Financial autonomy. Sources and proportion of revenue allocation for each level is clearly specified to ensure the financial autonomy of the units. Dual objectives. The federalism offers a grand design of living together. Its two important objectives are to safeguard and promote unity of the country, while accommodating the regional diversity. Opportunities for decentralization. These opportunities are based on the concept of self-rule and shared rule. It strives to make the governance efficient, swift, and ensures grassroots involvement in the political process. 5.1.4 Why India opted for federalism? Although the Indian constitution nowhere uses the term federal, it has provided for a governance model, which is essentially federal in spirit. Federalism in India should be studied in the context of its pluralities of culture and its socio-economic conditions on the eve of independence. With a large population spread across a large pluralistic framework in terms of ethnic, linguistic, religious, and other diversities, it was necessary to implement a system of polity that would accommodate these pluralities. This was to be done without compromising on building a unified nation. In order to serve the objective, the constitution makers decided on a democratic structure based on federal system of government with a unitary bias. While democracy ensures freedom to the citizens, a federation would ensure the protection of pluralities. This, when managed by a strong union government, ensures the principle of unity amidst diversity in order to march ahead to progress. The perils of colonial rule made India a land of severe economic disparities and chronic underdevelopment. As the immediate goal for the newly born nation was to turn around the economic conditions, it was necessary to bring in an administrative system that would combine regional management and centralized supervision. It was thus decided that a federal polity with an empowered union government will best fit these requirements to achieve the goal. 5.1.5 Features of Indian federalism. There are certain unique features in Indian federalism. They are as follows. 1. Supreme and single constitution. Constitution is the most supreme law of the land in India. It contains several components that together act as a rule of thumb in framing policies of the government. It guarantees a set of fundamental rights to the citizens. Similarly, it demarcates the domains of power of executive, legislative and financial powers of both the Government of India and the states. 2. Dual government. The Constitution has distributed powers between the Union and the states. Through this distribution, it seeks to accommodate the diversity of India. By 180 16 hours 37 minutes and 36 seconds. Issues and challenges pertaining to the federal structure. 181. Providing certain powers to the state governments, the Constitution allows the states to take decision with flexibility and according to local needs. 3. Authority of the courts. Legal supremacy of the Constitution is an essential feature in the federal system. It helps in maintaining the division of powers between the Union and Centre. Courts have the final power to interpret the Constitution and nullify actions on the part of the federal and state governments or their different units, which violate the provisions of the Constitution. 4. Mode of formation. Unlike the United States, which was formed as a result of coming together of a group of states, Indian federalism was born out of the need for administrative convenience. 5. Position of the states in the Federation. In the United States, since the states had existed much before the formation of federation, they held their own sovereignty vis-a-vis the federal government. Therefore, their constitution had several safeguards for the protection of states' sovereignty. Whereas in India, there was no such history of states holding a higher sovereignty. Thus, our states do not enjoy a higher authority in comparison to the Union government. 5.1.6 Criticism of Indian federalism. Though the founding fathers of the Indian Constitution have done their best to imbibe a federal character into our polity, there are a number of criticisms against it. 1. Not a truly rigid constitution. The amendment process to the Constitution of India follows a blend of rigidity and flexibility. Some of its provisions can be easily amended by the Parliament and some require ratification from the states. While it is challenging to pass amendments that affect the federal provisions, it is not as difficult as the amendment process in the United States. Powerful union government. The Union holds more power as against the states. This can be understood by the number and importance of subjects under the Union list under Schedule 7 of the Constitution. Even regarding the concurrent list, the Constitution empowers the Parliament to override any law made by the state legislature in case of a conflict with a Union law on the same subject. Additionally, all residuary powers are also vested with the Parliament. Besides this, it empowers the Parliament to legislate in certain cases to legislate on subjects in the state list. 2. Unequal representation of states in the upper house. In bicameral legislatures of federal countries, it is a basic feature to have equal representation for states in the upper house. India has deviated from this principle and has opted for proportional representation based on the population of the respective states. 3. Executive is a part of legislature. Separation of powers is yet another essential part of a federal polity. In India, though, the political executive is an integral part of the legislature. 4. Lower house enjoys greater power than upper house. The role of the upper house in a federation is quite significant as it features representatives from the states. In the Indian Parliament, however, the lower house enjoys greater powers compared to the upper house. For instance, money bills can only be introduced in a lower house. A no-confidence motion against the government can only be initiated in the lower house. Interestingly, the upper house as well enjoys the unique 181 16 hours 37 minutes and 36 seconds. 182. Power such as to initiate a bill for the creation of an All India service. Such unequal distribution of powers among the Houses of Parliament is contrary to the principle of federalism. 6. Emergency powers with the Union. The Constitution has vested all the emergency powers with the Union government. By enforcing an emergency, the Union government virtually takes complete control of the country, superseding the autonomy of the state governments. 7. Integrated judiciary. Though independent, the judiciary is integrated. This means, India does not have a separate judiciary at the union and at the state level. 8. Single citizenship. Indian citizens hold only one citizenship that is issued by the Union government, whereas in United States of America, concept of dual citizenship exists. 9. Appointment process of governor. The power of appointing a governor lies with the President, who executes this power based on the advice of the Council of Ministers. As a result, the governor acts as an agent of the Union government. 10. All India services. The Union government through the All India services such as the Indian Administrative Service, IAS, Indian Police Service, IPS, and Indian Forest Service, IFS, veers into the governance of states and controls the executive functions. Though the immediate authority of these services lie with the state, the ultimate powers lie with the Government of India. These services provide efficiency and uniformity in administration throughout the country. 11. Destructible states. A state's name, territory, or its very existence can be changed by the Parliament by passing a law to that effect. All of this can be done following the procedure of an ordinary bill. 12. Veto over states' bills. The governor of a state has the power to reserve certain bills for the President's consideration. The President, on the other hand, is provided with absolute veto on these bills. At times, he also holds the power to reject bills, when they come after reconsideration and are still found wanting. As the President follows the advice of the Council of Ministers in this respect, this power can be misused to keep the state legislatures under the hold of the Union government. 13. Integrated election machinery. Elections in India, at both the centre and states, are conducted by the Election Commission of India. Though the body is independent of political intervention or influence, the chairman and the members of the commission are appointed by the President. 14. Integrated auditing. Similar to the conduct of elections in India, auditing of accounts of the states and the Union are done by the Controller and Auditor General of India. The holder of this office is also appointed by the President. 15. Removal of key functionaries. The state government is hardly empowered to remove government functionaries, even at the state level. This includes judges of the High Court, state election commissioners, etc. 5.1.7 Stages of federalism in India. Towards the end of the British Raj, the founding fathers of India were facing questions on the type of polity that the new nation will take up. Considering the diversity of the country, they decided to go for federalism, as it would ensure the protection of regional, minority and 182 16 hours 37 minutes and 36 seconds issues and challenges pertaining to the federal structure 183. Community interests. However, as the security at both external and internal spheres was threatened by various forces, they were left with no choice but to compromise on the level of federalism that was chosen for the country. It was decided to make India a strong, cohesive state, by giving more power to the national government at the centre as against limited spheres for the state governments. Moreover, it was felt that resolving the problem of economic development was comparatively easier when planning can be made in a centralized manner. Evolution of Indian form of federalism can be classified into 4 waves: wave of single-party dominance, pre-1967, wave of confrontational federalism, 1967-1990, wave of cooperative federalism, 1990-2013, wave of cooperative and competitive federalism, since 2013. A. The first phase, single-party dominance. The initial years since independence saw the formidable power of the Indian National Congress Ministry as they ruled at both the centre and state levels. Jawaharlal Nehru, the then Prime Minister, was very much involved in promoting the federal relationship with the state governments. He maintained regular written communication in order to keep them informed of the developments at the national level and to take in suggestions from them in order to build a better nation. The roots for this federal organization were laid back in 1920, when the INC organized itself on the basis of provincial Congress committees. B. The second phase, confrontational federalism. The era of dominant rule by the INC began fading away with the 4th general elections, 1967. This election witnessed rooting of the INC by regional parties in nearly half of the states. They had little choice other than coexisting with opposition parties. This was once again lost with the split of 1969, and slowly the style of governance was moving towards a centralized leadership of the country by Indira Gandhi, the then Prime Minister. As a result, the federal principles of organization were set aside. And the regional accommodation, which was nurtured since the early years of the 20th century, was subsequently eroded. With the Congress obtaining near 2/3 majority in the 1972 parliamentary elections, reaping on the success of the Bangladesh Liberation War, the federal government started arguing the case for a strong centre, not only to serve the interests of balanced development but also to safeguard the unity and integrity of the country. This was to hit a nadir with the imposition of national emergency in 1975-77. The draconian regime was an era in which the state was almost reduced to a unitary dictatorship. The Union government was more than happy to intervene into the state's administration, and Article 356 was arbitrarily applied to ward off governments that weren't in its good books. A remarkable event of this era is the passing of the 42nd Amendment to the Constitution, which placed the already power-heavy Union government on higher ground compared to the states. This led to several non-Congress parties in unison demanding for state autonomy. C. The third phase, cooperative federalism. This wave of federalism had its advent towards the end of the 1980s. The system of coalition governments at the national level led to the strengthening of regional parties such as the Dravida Munnetra Kazhagam, DMK, in Tamil Nadu, Rashtriya Janata Dal, RJD, in Bihar, 183 16 hours 37 minutes and 36 seconds. 184. Etc. With this newfound importance, they have been able to assert their interests more vocally since this era. Thanks to this development, even when a centre-right party such as the Bharatiya Janata Party, BJP, came to power in the centre as part of the National Democratic Alliance, NDA, for the first time, they tread cautiously, hardly ruffling feathers with their coalition partners and counterparts at the state level. The Union government had little choice but to listen to the requirements of the states and make policy formulations accordingly. D. The fourth phase, cooperative and competitive federalism. On returning to power for the second time in 2014, the NDA has been rooting for a judicious mix between cooperative and competitive federalism. The foundation stone for this was laid by replacing the decades-old Nehruvian brainchild, the Planning Commission, with the National Institution for Transforming India, NITI. According to the government, while cooperative federalism will ensure an inclusive strategy towards achieving development, competitive federalism will help in realizing the same with maximum potential. 5.1.8 Cooperative federalism to competitive federalism. Cooperative federalism implies that the Union and states share a horizontal relationship, where they cooperate in the larger public interest. It's visualized as an important tool to enable states' participation in the formulation and implementation of national policies. Sharing of powers and responsibilities between the three levels of government is a key element of the concept, which involves participative policymaking. This is particularly important in areas of concurrent responsibility, where the center has had a tendency to ride roughshod over the states by occupying the common legislative space. A reform of the seventh schedule lists in the direction of greater empowerment of states would be consistent with the logic of increased financial transfers and cooperative federalism. Locating the right level for making and implementing policy is a central feature of the cooperative responsibility matrix. A key element in fostering cooperative federalism is the respect for the mandate of elected governments, even those run by opposition parties. In an era where the party system is fragmented along federal lines, the need is still felt to include state parties in federal coalitions, even when technically not necessary. Competitive federalism can refer to the relationship between the central and state governments, vertical, or between state governments, horizontal. Post the 1990s economic reforms, this idea of federalism gained prominence. In a free market economy, the spirit of competition is developed through the provision of endowments to states, their available resource base and their comparative advantages. States not only need to compete with the center but also among themselves for gaining these benefits. Increasing globalization, however, has made the already existing inequalities and imbalances between states much wider. Hence, there is concern about the states' freedom to formulate their own growth policies. With the onset of globalization, there have been new economic roles for the government. There has been complex power sharing and multi-level relationship. 184 16 hours 37 minutes and 36 seconds Issues and challenges pertaining to the federal structure. 185. There is raise of identity-related issues, e.g. Telangana, and resource-based issues, like Kaveri and Narmada. Hence, in a multi-party system it is important to forge effective federal coalitions. Fiscal constraints of the states have led to the proliferation of central schemes and national missions. Because of responsive and participative democracy, we get asymmetric federalism, the acceptance of inequality of states, leading to decline in inequality, tensions, and dissatisfactions. 5.1.9 Steps to achieve cooperative federalism. A. Institutions. 1. Interstate Council. Article 263 provides that the President may by order appoint an interstate council if he/she is of the opinion that public interest would be served by its establishment. This council shall be used to promote a cohesive relationship among the federal units of the Union. The organization, procedure, and duties of the council shall be defined by the President. 2. Zonal councils. They were created as a result of the States Reorganization Act, 1956. These councils function as forums that would bring the states of a particular region in close conformity with each other. Currently these are 5 in number. They act as instruments of intergovernmental consultation and cooperation primarily in socio-economic fields and also to curb the growth of particularist tendencies among various states. B. Policies. 1. Recommendations of the 14th Finance Commission, the 14th Finance Commission report is a landmark report in terms of fiscal allocation. Besides several important recommendations, the Commission recommended a statutory increase in the share of divisible tax pool from 32% to 42%. As the Union government has also raised the non-statutory share from 21% to 26%, about 68% of the division pool is to be transferred to the states. These imply that nearly half of the total receipts of the Union government will be transferred to the states. The larger allocations are accompanied by significant reduction in the central schemes and rationalization of remaining schemes to give greater flexibility and control to the individual states. 2. The establishment of the NITI Aayog. The NITI Aayog was established as the replacement to the Planning Commission. Unlike its predecessor, NITI Aayog aims to include the state governments into the planning process and give them a better say at decision-making. The forum has a good potential to facilitate coordination between the states and the Center. 3. Goods and Services Tax and the GST Council. By creating a uniform regime of taxation, the devolution of revenue receipts to the states would get much easier and efficient. As the introduction of this new tax regime replaces several existing revenue resources for the states, a council for better managing the process and allocation of revenue has been set up as the GST Council. 185 16 hours 37 minutes and 36 seconds. 186. May 1, 10 steps to be taken to improve cooperation reforms in the 7th schedule. As India is consciously promoting cooperative federalism, it needs to focus on greater empowerment of states by shifting more subjects into the state list or at least into the concurrent list. On issues that have a global effect, such as treaties and multilateral conventions, the Union should set up a mechanism to implement these agreements with minimal or no infringement into the sovereignty of the states. These include WTO obligations, INDC recommendations, etc. May 1, 11 Indian federalism in the age of globalization. As India is constitutionally referred to as a union of states, the states have a large significant role in implementing the agenda of globalization. However, the effect of globalization on our federal polity has produced a paradoxical outcome. The economic reforms of the 1990s gave state governments lot more freedom to make policies independently. For instance, while the national government still decides on investment policies and trade tariffs, state governments are free to provide incentives to investors of foreign capital to enter their jurisdictions. By opening their markets to globalization, states have been regularly engaging in a fierce competition among themselves in order to attract more and more foreign direct investments. As a result, the political autonomy of states has been greatly reduced in favor of investments and markets. This has exposed local governance to direct or indirect influence by global and multinational corporate entities. As a few of the states cannot compete at a major level, it leads to an unequal development and therefore paving the way for the categorization of states as developed and special category states. From the point of view of an Indian state, capital from another country or from another state can be seen through the same lens, and must be treated equally on par in typical policy environments. The final impacts of the entry of capital will therefore depend also on the internal mobility of capital and labor within the subnational government. Hence, attention must be paid to internal mobility of goods and other factors, in addition to external liberalization in the federal system. The tax and regulatory policies of the subnation can assume greater importance in a scenario of economic reform under globalization. Another federal aspect of India's reform is that the decade of the 1990s has seen an increase in regional inequality in some dimensions. While inequalities may have widened within states as well, for example, the coastal and urban areas of Maharashtra and Gujarat versus their interior rural regions, the main focus has been and will be on widening disparities across the states themselves. This is natural, given the size and political importance of the states, and the fact that the states are the direct and indirect channels for significant financial transfers from the central government. We also consider whether aspects of economic reform, larger global economic forces, and state-level initial conditions and policy responses are increasing regional inequalities within the country, and whether the mechanisms that exist within India's federal structures for managing regional inequalities are adequate. 186 16 hours 37 minutes and 36 seconds Issues and challenges pertaining to the federal structure 187. The growing literature on globalization and Indian federalism, mostly written though from the standpoint of political economy, suggests that Indian federalism has been drastically changed so that it needs to be redefined. May 1, 12 Federalism in the fiscal sphere. The fiscal relations between the center and the states have been defined under the constitutional provisions of distribution of revenues between the Union and the states. Based on this scheme, the Union gets its revenue from the following sources such as taxes on income other than agricultural income, customs duties including export duties, excise duties on goods manufactured in India except alcohol and liquors for human consumption, taxes on capital value of the assets, exclusive of agriculture land, of individuals and companies, taxes on the capital of companies, estate duty and succession duty in respect of property other than agricultural land, etc. The revenue sources allocated to the states, on the other hand are, land revenue, taxes on agricultural income, succession duty in respect of agricultural land, estate duty in respect of agriculture land, taxes on land and buildings, taxes on mineral rights, excise duties on alcoholic liquors for human consumption, sales tax, professional taxes, taxes on the consumption of electricity, taxes on advertisements, etc. Though the allocation of resources is limited, the states hold greater responsibilities for social, educational, and economic development of citizens. It is for this reason that the Constitution provides for intergovernmental transfers through the establishment of Finance Commission, once in every 5 years. This body recommends the proportion at which transfer of central revenue has to be made to the states. Besides this, central plan transfers and funding for central sector and centrally sponsored schemes are also made to the states. While the proportion of funding has been climbing at a fast rate over the past few years, the states find them inadequate to meet their responsibilities. May 1, 13 Green federalism. In the context of environmental and climate change issues, it is becoming increasingly important for governments to formulate policies and guidelines to effectively address hazards and ensure sustainable growth. As a federal country, India needs to work out a plan among its different levels of government to come up with a comprehensive strategy to tackle these challenges. The federal provisions of the Constitution of India generally remain silent on the environmental issues. At present there is no dedicated subject for the purpose of environmental legislation. Originally, in the 7th schedule of the Constitution, all the natural resources land, water, forests, and minerals were assigned to the states, while the central government was given the responsibilities to regulate the development of mines and mineral resources. Later this was amended to push forests and wildlife protection to the concurrent list. But the process of green federalism doesn't end with just specifying the jurisdictional ambit of legislation alone. There are larger challenges in terms of research, governance, resources, and capacity building to deal with the complex issues of environment. When the states and the Union come together to play specific roles in relation to these areas, it is then that the objectives of green federalism can be effectively realized. 187 16 hours 37 minutes and 36 seconds. 188. May 1, 14 Issues in Indian federalism. Union's influence over concurrent list. One of the main accusations on Indian federalism is the problem of pseudo-centralization. A number of states have accused the Union government of extending a dominance over the concurrent list. Article 200, it relates to the state bills which are reserved for the assent of the President. This provision has been abused numerous times with impunity. Anandpur Sahib Resolution by Punjab in 1973, West Bengal Memorandum in 1978 has demanded centre to restrict itself to defence, external affairs, currency, and general communication. Arbitrary imposition of President's rule. Article 356 is one of the most misused provisions by the Union government to restrict the proper functioning of states under the control of opposition parties. However, following the Sr. Bommai case, the Supreme Court has largely reduced the scope for the imposition of President's rule. Removal of governor, as the governors are appointed by the Union government. A change of ruling party will lead to the removal of governors appointed by the preceding regime. Though the governor doesn't hold a security of tenure, the practice of removing governors for political reasons does not act as a healthy indicator of cooperative federalism. All India services, state governments have time and again called for the abolition of the All India services. Though the officers under these services come under the immediate supervision of the states, their service conditions are primarily managed by the Government of India. Delhi Case Study. Delhi is a peculiar case, neither being a state, nor a union territory. So, Article 239, which deals with union territories, does not apply to Delhi. Instead, Delhi is governed by Articles 239AA and 239AB, introduced by a constitutional amendment in 1991. The problem with the Home Ministry notification is that while it conflates Delhi as a union territory to suit its own interests, at other times, it treats it as a state. Partial statehood, Delhi's peculiar constitutional situation, has posed challenges before every government that has ruled the national capital since 1993. The year an elected Vidhan Sabha was reinstated in Delhi. Central to this is the prickly issue of an elected government being forced to share powers with a non-elected lieutenant governor. Article 239, AA and AB, of the Constitution appears to grant the LG more discretionary powers than governors in other states. Clause 4 of this article says that there shall be a council of ministers in Delhi to aid and advise the LG except in so far as he is, by or under any law, required to act in his discretion. Such a situation created many conflict situations between the elected government of Delhi and LT. Governor. 188 16 hours 37 minutes and 36 seconds. Issues and challenges pertaining to the federal structure. 189. May 1, 15 recommendations of various commissions. The constitutional arrangements of center-state and interstate coordination and cooperation functioned smoothly during the first 25 years of the working of the Constitution of India, due largely to single-party rule at the centre and in almost all the states, and presence of stalwart national leaders like Pandit Jawaharlal Nehru, who played prominent role in the drafting the Constitution. The end of the era of single-party rule since the late 60s and emergence of regional parties and coalition governments with diverse ideologies, priorities, and programs brought sharp focus into various issues of coordination in center-state relations and constitutional governance. In order to study these issues and recommend measures for improving the system, a few commissions/committees have been set up since mid-60s. These are: A. First Administrative Reforms Commission. The First Administrative Reforms Commission was constituted by the Government of India on January 5, 1966 for reviewing the public administration system of India and recommending measures for making administration fit for carrying out the social and economic policies of the government and being responsive to the people. The commission was chaired initially by Morarji R. Desai, MP, and later on by K. Hanumanthaya, MP, when Morarji R. Desai became the Deputy Prime Minister of India. The Commission submitted its reports in 20 parts containing 537 major recommendations till the mid-70s. The 13th report of the Commission covered the issues of center-state relations. With regard to interstate council, the Commission made the following recommendations: I. establishment of an interstate council under Article 263, b, and c, of the Constitution, which would discuss all issues of national importance in which the states are interested. 2. Saddling the Council with functions under Article 263, a, to inquire into and advise upon disputes between the states would prevent it from giving full attention to the various problems of national concern which it ought to consider. 3. This body should replace the National Development Council, the Chief Minister Conference, the Finance Minister Conference, the Food Ministers Conference and the National Integration Council. 4. The Council will be wide-embracing and will provide a standing machinery for effecting consultations between the Centre and the States. Only issues of real and national importance need to be taken up there. Others should be settled by conferences convened by the ministries concerned, at a lower, preferably official level. v. The Council should have an appropriate secretariat. The Secretary of the Council should be an officer having the knowledge, experience, and status that will enable him to work effectively. b. Rajamannar Committee. The Centre State Relations Inquiry Committee was set up by the Government of Tamil Nadu on September 2, 1969 under the chairmanship of Dr. P. V. Rajamanna to consider the entire question regarding relationship that should subsist in a federal setup between the centre and the states. The other two members of the committee were Dr. A. Lakshmanaswamy Mudalai Iyer and Mr. P. Chandra Reddy. 189 16 hours 37 minutes and 37 seconds. 190. With regard to the Interstate Council, the committee made the following recommendations. A. The Interstate Council should be constituted immediately. The proposed council may consist of the chief ministers or their nominees, all the states having equal representation, with the Prime Minister as the chairman. No other minister of the Union Cabinet should be a member of the council. B. Every bill of national importance or which is likely to affect the interests of one or more states should, before its introduction in Parliament, be referred to the Interstate Council and its views thereon should be submitted to Parliament at the time of introduction of the bill. C. No decision of national importance or which may affect one or more states should be taken by the Union Government except after consultation with the Interstate Council. Exception may be made to subjects like defense and foreign relations. But even on such matters the decision of the central government should be placed before the Interstate Council subsequently without any avoidable delay. D. If the Interstate Council is to be really effective, its recommendations should be made ordinarily binding on both the centre and the states. If for any reason, any recommendation of the Interstate Council is rejected by the central government, such recommendation together with reasons for its rejection should be laid before the Parliament and state legislature. C. R.S. Sarkaria Commission. In the wake of the increasing strain in the centre-state relations, the Parliament, in June 1983, appointed a commission under the chairmanship of Justice R.S. Sarkaria to go into details of the centre-state relations and to recommend measures to make the relation efficient and cooperative. The Commission submitted its report in January 1988. The Commission did not call for any structural change, but preferred to continue the existing arrangement because the disintegrative forces are active in the country. However, the Commission recommended the need for restructuring the provisions of the centre-state relations. To begin with, it suggested the centre, to relax its financial hold over the states and to provide them more autonomy. This would make the regional powers more responsible and accountable. Major recommendations of the Sarkaria Commission. 1. A permanent interstate council called the Intergovernmental Council should be set up under Article 263. 2. Article 356, President's Rule, should be used very sparingly, in extreme cases as a last resort when all the available alternatives fail. 3. The institution of All India services should be further strengthened and some more such services should be created. 4. The residuary powers of taxation should continue to remain with the Parliament, while the other residuary powers should be placed in the concurrent list. 190 16 hours 37 minutes and 37 seconds. Issues and challenges pertaining to the federal structure. 191. 5. When the President withholds his assent to the state bills, the reasons should be communicated to the state government. 6. The zonal councils should be constituted afresh and reactivated to promote the spirit of federalism. 7. The center should have powers to deploy its armed forces, even without the consent of states. However, it is desirable that the states should be consulted. 8. The center should consult the states before making a law on a subject of the concurrent list. 9. The procedure of consulting the chief minister in the appointment of the state governor should be prescribed in the Constitution itself. 10. The net proceeds of the corporation tax may be made permissibly shareable with the states. 11. The governor cannot dismiss the Council of Ministers as long as it commands a majority in the Assembly. 12. No change in the role of Rajya Sabha and Centre's power to reorganize the states. d. Second Administrative Reforms Commission. The second ARC was set up by the Government of India on August 31, 2005 under the chairmanship of Shri M. Veerappa Moily with the directive to suggest various measures to achieve a proactive, responsive, accountable, sustainable and efficient administration for the country at all levels of the government. The Commission submitted its report in 15 parts during June 2006 to May 2009. Part 7 of the report, titled Capacity Building for Conflict Resolution, Friction to Fusion, made the following 2 recommendations regarding the Interstate Council. I. The Interstate Council must be given the complete role provided to it under the Constitution, that is both conflict resolution and better coordination of policy and action in matters of interest to the Union and states. For resolution of conflicts, whether interstate or Union state, the mechanism of inquiring and advising, even without having the power to adjudicate, envisaged by Clause A of Article 263 can be an effective method to resolve disputes. 2. The Interstate Council should be constituted as and when the need arises, and that the Council need not exist in perpetuity. The Council could best serve its purpose as a pro tem body with a flexible composition suited to its term of reference. The present Omnibus Council may be dissolved. There should not be any bar or impediment for constituting more than one council at a given time with different composition for each to consider different disputes or other matters of concern to different states and the Union. This approach would also facilitate meaningful, result-oriented discussions by parties directly interested in an item and facilitate time-bound solutions. E. Justice M. Punchhai Commission. The Commission for Center-State Relations headed by Justice Madan Mohan Punchhai has submitted its report to the central government without much fanfare. This is a contradiction to the Liberhan Commission report, which was full of sound and fury, signifying nothing, and which wasted 15 years. 191 16 hours 37 minutes and 37 seconds. 192. A comprehensive review of center-state relations was undertaken by the Sarkaria Commission in the mid-80s. In the 2 decades that have gone by, both the polity and economy have undergone profound changes, posing new challenges for government at all levels and calling for a fresh look at the relative roles and responsibilities of each level and their interrelations. The present Commission has been entrusted with this task and asked to make recommendations that would help to address the emerging challenges. Major recommendations may be enumerated as follows. 1. There should be an amendment in Articles 355 and 356 to enable the Centre to bring specific trouble-torn areas under its rule for a limited period. 2. The Commission has proposed localizing emergency provisions under Articles 355 and 356, contending that localized areas, either a district or parts of a district, be brought under governor's rule instead of the whole state. Such an emergency provision should, however, not be of duration of more than 3 months. 3. The Commission however supports their right to give sanction for the prosecution of ministers against the advice of the state government. 4. To make an amendment in the Communal Violence Bill to allow deployment of central forces without the state's consent for a short period. It has proposed that state consent should not become a hurdle in deployment of central forces in a communal conflagration. However, such deployment should only be for a week and post facto consent should be taken from the state. 5. Among the significant suggestions made by the Commission is, laying down of clear guidelines for the appointment of chief ministers. Upholding the view that a pre-poll alliance should be treated as one political party, it lays down the order of precedence that ought to be followed by the governor in case of a hung house. A. Call the group with the largest pre-poll alliance commanding the largest number. B. The single largest party with support of others. C. The post-electoral coalition with all parties joining the government, and last D. The post-electoral alliance with some parties joining the government and remaining including independents supporting from outside. 6. The panel also feels that governors should have the right to sanction prosecution of a minister against the advice of the Council of Ministers. However, it wants the convention of making them chancellors of universities done away with. 7. As for qualifications for a governor, the Punch High Commission suggests that the nominee not have participated in active politics at even local level for at least a couple of years before his appointment. It also agrees with the Sarkaria recommendation that a governor be an eminent person and not belongs to the state where he is to be posted. 8. The Commission also criticizes arbitrary dismissal of governors, saying, the practice of treating governors as political football must stop. There should be critical changes in the role of the governor, including fixed 5-year tenure as well as their removal only through impeachment by the State Assembly. It has also recommended that the state chief minister have a say in the appointment of governor. 9. Underlining that removal of a governor be for a reason related to his discharge of functions, it has proposed provisions for impeachment by the state legislature along 192 16 hours 37 minutes and 37 seconds issues and challenges pertaining to the federal structure 193. The same lines as that of President by Parliament. This, significantly, goes against the doctrine of pleasure upheld by the recent Supreme Court judgment. 10. Endorsing an NCRWC recommendation, it says appointment of governor should be entrusted to a committee comprising the Prime Minister, Home Minister, Speaker of the Lok Sabha and Chief Minister of the concerned state. The Vice President can also be involved in the process. 11. Unlike the Sarkaria report, the Punch High report is categorical that a governor be given fixed 5-year tenure. The Punch High Commission report also recommends that a constitutional amendment be brought out to limit the scope of discretionary powers of the governor under Article 163, 2. Governors should not sit on decisions and must decide matters within a 4-month period. 12. The creation of an overriding structure to maintain internal security along the lines of the U.S. Homeland Security Department, giving more teeth to the National Integration Council. 13. For the National Integration Council, NIC, the Commission has proposed that it should meet at least once a year. In case of any communal incident, it has said that a delegation of 5 members of the Council, who would be eminent persons, should visit the affected area within 2 days and submit a fact-finding report. 14. The Commission, however, rejects a suggestion from some stakeholders as well as the Librehon Commission that the NIC be accorded constitutional status. 15. The Commission has also studied new set UPS like the National Investigation Agency, and recommended procedures to ensure smooth cooperation of the states in terror investigations entrusted to NIA. One can say that the extreme politicization of the post of governor must be decried and certain specific norms for the appointment and removal have to be evolved. 14th Finance Commission. The Finance Commission is a constitutional body created under provisions of Article 280. One of its important functions is to make recommendations regarding the devolution of taxes between the center and the states. Fiscal federalism deals with the division of governmental functions and financial relations among various levels of government at the central, state and local levels. Implications of the 14th Finance Commission, FFC, 2015-16 to 2020-21 Recommendations for Fiscal Federalism. 1. The total increase in FFC transfers in FY 2015-16 from FY 2014-15 is estimated to be about 2 lakh crores, with all states standing to gain in absolute terms. 2. The FFC transfers have more favorable impact on the states, among the general category states, which are relatively less developed, which is an indication that the FFC transfers are progressive, that is, states with lower per capita net state domestic product receive relatively larger transfers per capita. 3. Also, due to a change in the horizontal devolution formula which now gives greater weight to a state's forest cover, some states are to gain more than others. 4. There would be more fiscal autonomy for states by increasing their share from 32% to 42% of divisible pool. 193 16 hours 37 minutes and 37 seconds. 194. 5. But there could be commensurate reductions in the central assistance to states, CA, to secure centers' fiscal space. 6. However, CA being discretionary and only mildly progressive, implementing FFC recommendations would entail even more progressivity. In sum, the far-reaching recommendations of the FFC will further the government's vision of cooperative and competitive federalism. However, all the recommendations will only prove fruitful only if following measure are given priority: administrative reforms, particularly the bureaucracy at the state level, strengthening the center-state coordination networks. Technical capabilities of states must be augmented, monitoring and audit must be given renewed thrust, CAG may be engaged. May 1, 16 Important Supreme Court decisions: State of West Bengal vs Union of India, 1962. The case involved the question of sovereignty of individual states in India. The Supreme Court held that the Indian Constitution does not provide for absolute federalism. It provides to decentralize the authority, so that the large territory of India can be governed efficiently. 2. The individual state has no power to amend the constitution, which is vested only in the parliament. 3. The constitution has divided powers between the center and the states in such a way that the national policies and local governance could be executed by the center and the individual states, respectively. 4. The constitution provides supreme power to the judiciary to invalidate any law made by legislature if it violates the constitution. Sr. Bhamai vs. Union of India, 1994. In this case, the Supreme Court discussed about the provisions of Article 356, President's Rule. It laid down the conditions under which it can be imposed, so that the misuse of Article 356 can be checked. The Supreme Court laid down certain principles regarding Article 356. President has power to impose Article 356, but the decision is not immune from judicial review. The judiciary can examine whether the proclamation was justified or it was imposed with mala fide intention. 2. The Supreme Court or the High Court can strike down the proclamation if it is found to be mala fide or based on irrelevant grounds. 3. It was held that the President has conditional power and not absolute power in regards to imposition of Article 356. 4. It was held that the Article 356 is an extreme power and is to be used as a last resort in cases where it is manifest that there is an impasse and the constitutional machinery in a state has collapsed. 194 16 hours 37 minutes and 37 seconds Issues and challenges pertaining to the federal structure 195. May 1, 17 Conclusion The Constitution of India is neither purely federal nor purely unitary but is a combination of both. It enshrines the principle that, in spite of federalism, the national interest ought to be paramount. It is emphasized that the centre wants to empower the states with finances, with technology, and knowledge so that they are able to plan better and execute even better. For federalism to work well, states must also fulfill their role in promoting the shared national objectives. The critical element for cooperative federalism to flourish is that states commit to the path they choose within the context of the shared national objectives and then deliver on that commitment. To conclude, the adoption of innovations involves altering human behavior, and the acceptance of change. There is requirement to promote the spirit of cooperation and harmony between all the level of governments in India to usher in a powerful and inclusive India. 5.2 Emerging pattern of centre-state relations. 5.2.1 Introduction The most important aspect of any federation is the power-sharing arrangement made between the centre and the states. The modern conditions have created a scenario whereby all federal systems are ultimately biased towards the centre. The Constitution has deliberately granted extraordinary powers to the centre, and since independence these powers have been freely exercised in a state adopted to planned economy. It is understood that any consideration to be given to Indian federal system should first acknowledge the fact it is centre-centred. But enormous changes have indeed taken place in the federal setup since the adoption of the Constitution. The Constitution itself was tilted in favor of the centre. During the initial decades after independence, the Union dominated the federal setup. The government under the leadership of Nehru and with active support from the Congress Party, defended the adoption of strong centre stance in order to maintain national integrity and unity. The dominance of Congress Party during the initial years paved way for centralization of all major activities concerned with politics, economics, and including government. 5.2.2 Era of Nehru gave constitutional legitimacy to the centralized planning by bringing such matters under the purview of Entry 20 of the concurrent list in the 7th schedule, which deals with distribution of powers between centre and the states, and thus came to de facto control the whole economy. 1. Nehru's ideological leaning towards democratic socialistic pattern of the society made him to adopt the centralized planning for the whole country. 2. From the initial stages, the Planning Commission, an extra-constitutional body, took care of the dispersal of the funds and approval of the development plans of the states. 3. Hence the states were pushed to the margin and their economic consideration became secondary. They were now largely dependent on the centre for the funds. 4. The centre also took control over all industries by enacting the Industries Development and Regulation Act 1956. 195 16 hours 37 minutes and 37 seconds. 196. 5. The state's powers were also curbed by forming of All India and specific boards for individual industries such as coffee, tea, rubber, etc. 6. During the period of Nehru and Indira, some of the important subject matters in the state list of the 7th schedule was amended and encroached upon by the centre. 7. The centralization of the economy had several consequences, most importantly the identification of key industries and their location within the territory of the states. 8. It also involved nationalization of the insurance and aviation industries, culminating in nationalization of the major commercial banks in 1969 by Indira Gandhi. A. Nature of federalism. Nehru's phase had a strong centralizing tendency, but the centre took no effort to politically destabilize the state governments. The emergency was minimally used, and Nehru consulted with powerful state leaders before taking major policy decisions. 1. The centre-state relation during this period was relatively peaceful as the governments in the centre and in the states were of one single party and Nehru was its unquestioned leader. 2. It is understood that the initial phase of Indian politics after independence was based on elite consensus. It went uncontested because of its nearness to the national freedom movement, and the people had implicit trust on the leaders. 3. The federal structure functioned within the federal setup of the Congress Party itself and not through constitutional channels. 4. During the time of Nehru and Shastri, the demands of the state were generally confined to federal fiscal matters and to other operational aspects of federalism, and center states' disputes hovered around sharing of national revenue, and states' discontent was over the overarching power of the Planning Commission vis-a-vis the Finance Commission. B. Language movement. During this initial phase, the language movement became more prominent. As per the provision of the Constitution, English was allowed to continue as official language of the Union for a temporary period of 15 years. Accordingly, after the end of the period, a review had to be made for further continuation of English language as the official language. But by mid-1950s, debates around adopting Hindi as the official language and the link language between Union and the states started coming to the fore. Nehru in fact constituted the official language commission under B.G. Kerr in 1955. This commission submitted its report in 1956, and since then the language divide started to grow between the Hindi and non-Hindi speaking states, especially in South India and West Bengal. 1. The Kerr Commission recommended various steps for eventual replacement of English with Hindi. 2. The members of the commission from Tamil Nadu and West Bengal had submitted their dissenting notes against the recommendations. 196 16 hours 37 minutes and 37 seconds Issues and challenges pertaining to the federal structure 197. 3. A parliamentary committee was constituted under Pandit Govind Ballabhai Pant to study the Kerr Commission report, in order to address the growing dissent for compulsory use of Hindi by many state leaders and academic institutions. 4. Committee under Pant came out with its recommendation in 1959. It recommended that Hindi be used as the primary language of communication while English be made subsidiary one. 5. However, the anti-Hindi agitations did not subsidize, and it in fact became stronger, and in South India, strong movements were launched against any possible move to make compulsory use of Hindi. 6. The movement was so strong in Tamil Nadu that, despite the assurances given by Nehru and Shastri, the Dravidian parties continued with their agitations, which led to eventual fall of the Congress government in the state. 7. Despite having a strong pro-Hindi lobby, the Parliament adopted the Official Language Act of 1963 and subsequently the Official Language Amendment Act of 1967, which allowed for continuation of English as the official language and as a link language between the Union and the states. 8. There was no option before Nehru, but to continue make use of English as the official language. 9. He was also interested in maintaining the federal balance in order to accommodate the demands made by the non-Hindi speaking states. Nehru's comment on the introduction of Official Language Bill 1963 in the Parliament is as follows. This is a bill, continuation of what had happened in the past, to remove a restriction which has been placed by the Constitution on the use of English after a certain date, i.e. 1965. It is just to remove that restriction that this is placed. As per the Official Language Rules 1976, framed under the Official Language Act, 1963, communications from a central government office to state/union territories or to any person in Region A comprising the states of Uttar Pradesh, Uttarakhand, Himachal Pradesh, Madhya Pradesh, Chhattisgarh, Bihar, Jharkhand, Rajasthan, Haryana, and Utts of Andaman and Nicobar Islands and Delhi shall be in Hindi. Communications from a central government office to state/Utts in Region B comprising of states of Punjab, Gujarat, Maharashtra, and the UT of Chandigarh, shall ordinarily be in Hindi, but communication to any person in Region B may be either in English or Hindi. Communications from a central government office to state government office in Region C comprising of all other states and UTs not included in Regions A and B or to any office, not being a central government office, in Region C to a state or a UT of A and B or to any office, not being a central government office, or persons in such state may be either in Hindi or English. 10. Though the Official Language Act and the Official Language Rules allow continued use of English, there are still provisions in the Constitution which give importance to the promotion of Hindi language. 11. For example, the Article 343, 1, still contains provision that says the official language of the Union is Hindi. 197 16 hours 37 minutes and 37 seconds. 198. 12 In respect to the language used in the Parliament, Article 120, 1, says notwithstanding anything in Part 17, but subject to provisions of Article 348, the business in the Parliament be transacted either in English or Hindi. Provided that the Chairman of the Council of States or Speaker of the House of People, or the one who is acting in that capacity, as the case may be, may permit any member to address the House in his mother tongue, who cannot adequately express himself in Hindi or English. 13 Article 351 states, it shall be the duty of the Union to promote the Hindi language, to develop it so that it may serve as a medium of expression for all elements of the composite culture of Indian and to secure its enrichment by assimilating without interfering with its genus, forms, style and expression used in Hindustani and other languages of India specified in 8th Schedule, and by drawing, whatever, necessary or desirable, for its vocabulary, primarily on Sanskrit and secondarily other languages. 5.2.3 First wave of coalition politics. The very tendency that initially created a desire for a stronger central authority, created this counter-current by the states demanding greater autonomy. During the initial 2 decades after independence, Nehru and his government had to concede to create several states based on the linguistic reorganization basis. By end of 1960s and early 1970s, regional political parties started to emerge, successfully challenging the domination by the Congress Party. 1. The first wave of coalition politics government radically altered the center-state relations. In fact, several coalition governments were formed during the election of 1967. 2. Leftist parties formed coalition government in West Bengal and Kerala. Coalition governments with non-Congress parties formed government in Uttar Pradesh, Bihar, Punjab, Haryana, Madhya Pradesh, and Orissa. 3. In Tamil Nadu, DMK got elected, which was a state party government, predominantly based on strong Tamil identity. 4. As a result of these developments, state leaders started to question the dominance of the centre. 5. The left-led government of Kerala, DMK-led Tamil Nadu, Swatantra-led Orissa emphasized right from the beginning that the authority of the centre should be curtailed. 6. Some of the states even asked for more taxation powers. Cn. Annaju Ray, Chief Minister of Tamil Nadu, expressed his views on the central planning as follows. The powers which the central government has assumed in regard to mobilization, allocation, and pattern of utilization of resources for the plan have reduced the states to a status of supplication from the centre. Though the Constitution of India is described as a federal one, the balance is tilted towards the central and hence the states are not able to function freely in the administrative and financial spheres. Only such powers are necessary for the centre to preserve the strength of India should be assigned to the centre, and all other powers should be left to the states without impairing the ideal of a strong India. 198 16 hours 37 minutes and 37 seconds Issues and challenges pertaining to the federal structure. 199. 5.2.4 Interregnum period of Shastri Nehru's death in 1964 brought into prominence the state party leaders of the Congress Party. These state leaders took the important decision of placing Lal Bahadur Shastri as the successor Prime Minister after Nehru. 1. By the time Nehru fell ill, and question about his successor was raised, the state units of the Congress Party had become more powerful. 2. The selection of successor of Nehru had no parallel anywhere in the world. 3. The President of the Congress Party consulted with the senior cabinet ministers with political backing, the chief ministers of states, members of Congress Parliamentary Party, and all of them along with the Congress Working Committee constituted the Electoral College, which included the so-called cadre of state leadership, which was a first in Indian Federation. 4. And again when question of succession came after death of Prime Minister Lal Bahadur Shastri in Tashkent, the Congress chief ministers issued a joint statement to the Congress President Kamaraj to sponsor Mrs. Indira Gandhi as Shastri's successor. A. Period after the 1967 elections. Strengthening of regional parties. The states in India gradually started to challenge the centre by the mid-1960s. After the 1967 elections, some of the strategically and politically important states came under the rule of non-Congress government, which strengthened the regional voice. 1. The Congress power had been curtailed and many states saw formation of coalition governments either with a central party or together with support of other regional parties. 2. This signaled the weakness of the centre and increasing strength of the states. This phase has been described as the adulthood of the Indian Federation. 3. The states under the control of the non-Congress governments by the end of 1960s started demanding structural changes in the Indian federal structure. I. Initiatives by Government of Tamil Nadu. The Rajamanar Commission. The Government of Tamil Nadu constituted a committee under P.V. Rajamanar in 1969, to examine the working of the Constitution of India and recommend changes for reallocation of powers between centre and the states. 1. The terms of reference of the committee was clear and it wanted to examine the question regarding the relationship that should subsist between the centre and the states in the federal setup, with reference to the provisions of the Constitution of India, and to suggest suitable amendments to the Constitution so as to secure to the states the utmost autonomy. 2. The committee under Rajamanar favoured autonomy to the states and suggested abolition of several articles of the Constitution, such as 344, 6, 356, 249, 357, 360, etc. of the Constitution. 3. It recommended for immediate constitution of the Interstate Council. It also sought to remove the directions given by the centre to the states under the Article 256, 257 and 339, 2, and instead these directions have come from the Interstate Council. 199 16 hours 37 minutes and 37 seconds. 200. 4. It also suggested that any bill of national importance should be placed before the Council and its views should be submitted to the Parliament when the bill is introduced to be passed. 5. The committee under Rajamanar recommended that some entries in the Union list such as power to levy some excise taxes, entry 84 in Union list, non-vital industries, entry 52 in Union list, etc. should be transferred to the state list. 6. While making further recommendations about this issue, the committee recommended that a high-power commission should be set up to effectively redistribute entries in List I and List 3 in the 7th schedule of the Constitution. 7. It also gave suggestion for increasing the revenue base for the states, constitution of Planning Commission without any members from Government of India in it, appointment of governor in consultation with the state cabinet. 8. Regarding Article 3, the committee was of the view that the territorial integrity of the states should not be interfered without the consent of the states. Another suggestion was equal representation of the states in the committee based on their population. 9. In addition to these, the committee suggested to amend Article 297 of the Constitution, so as to make the state the sole controller of all lands, minerals, and other valuable things underlying in the ocean falling within the territorial extent of the state concerned. 10. The important point to highlight here is that the state of Tamil Nadu has been, for a long time arguing for autonomy of the state. 11. The DMK party in Tamil Nadu has in fact, consistently and repeatedly raised the question of federal autonomy and greater powers to the states. 12. Even in its 2009 election manifesto, the DMK had included a section of federalism which is read as follows. It is DMK's consistent stand that the Constitution should be amended for the creation of a wholesome and genuine federalism with fuller autonomy for the states. A resolution on state autonomy was passed in the Tamil Nadu Legislative Assembly way back in 1974 itself by DMK. DMK will continue to insist on the abolition of Article 356, which empowers the dismissal of state governments. It will continue to strive for the suitable constitutional amendments that will empower the states to function freely and effectively. 2. Initiatives by the government of West Bengal. The leftist government in West Bengal since mid-1960s had also started to call for revision of the center-state relations. The West Bengal government in December 1977 came out with a report on center-state relations which made the following suggestions. 1. Replacement of the word union by federal in the Constitution. 2. Repealing of Articles 356,357 and 360. 3. Mandatory consent of the state government for formation of new states and alteration of area, boundaries, or names of existing states. This memorandum was submitted to the then Prime Minister Morarji Desai by the West Bengal Chief Minister Jyotha Basu to review the center-state relations. 216 hours 37 minutes and 37 seconds. Issues and challenges pertaining to the federal structure. 201. 5.2.5 Emergence of new regional elites. The Green Revolution of 1960s created a new crop of elite farmers who became a powerful lobby. These farmers from some of the progressive states started to play an important role in the center-state dynamics. From the states of Punjab, Haryana, Uttar Pradesh, an interest group of rich and middle-class peasants emerged, and they started to have great impact on the regional and national politics. 1. New demands were raised by the emergent elites from the rural areas with respect to federalism and economic development. 2. Apart from lobbying for farmers' issues, they started to lay out regional demands and advocated state autonomy. 3. They started to influence the policy of the center in areas such as food procurement and agriculture marketing. 4. However, they represented the rural local dominant castes, also referred as peasant castes and now officially known as the other backward classes, OBCs. 5. Thus, the rich and land-holding farmers turned the table in their favor, the rural landless poor peasantry were marginalized further. 5.2.6 Era of Indira Gandhi. The center-state relation reached to its climax during the tenure of Prime Ministers Indira Gandhi. Imposition of emergency in 1975, the move towards over-centralization went unchallenged till the second wave of coalition era started to emerge in 1989. 1. The offices and institutions of the state governments were used as platforms to implement the ideas and policies of the central government leadership. 2. Indira Gandhi deviated from the leadership style of her father Nehru. 3. The central leadership became irrational and authoritarian, and it became intolerant to any kind of dissent from the opposition and even from within its own party. 4. Coercive techniques were used by the central government to tame and control the state governments. 5. The 42nd Amendment enacted during the emergency further tried to enhance the power of the center. 6. Education, which was previously on the state list, was transferred to the concurrent list. 7. Other nationalizing measures carried out by Ms. Gandhi before and after emergency are: I. Nationalization of the banks. 2. The political role played by the state leaders were curtailed. 3. The chief ministers of the Congress-ruled states were selected by Ms. Gandhi in consultation with her kitchen cabinet. 4. unilateral deployment of CRPF and BSF to any part of the country, v. unreasonable imposition of President's rule in several states. A. Janata interregnum. Even the Sarkaria Commission constituted in 1988 on center-state relations mentioned the underlying theme was over-centralization. Even the subsequent Janata Party government, which made a promise in election manifesto to revert the centralizing tendency, did not reverse the trend. 201 16 hours 37 minutes and 37 seconds. 202. A. It removed several state governments with the use of President's rule. B. In fact, in no time after it assumed power after the 1977 general elections, the Janata government dismissed/dissolved state governments and legislative assemblies of 9 Congress-ruled states, namely, Haryana, Madhya Pradesh, Punjab, Uttar Pradesh, Bihar, Orissa, West Bengal, Himachal Pradesh and Rajasthan. C. The Janata government at the centre was a weak coalition with partners having divergent political backgrounds. D. The following joined together: Bharatiya Jana Sangh, Socialist Party, Swatantra Party, Congress, Rebels, Congress, O. Congress for Democracy and Bharatiya Lok Dal, as Janata Party under one symbol. E. This coalition could not survive for long, and again the Congress led by Indira came back to power in 1980 with an overwhelming majority. F. Still, non-Congress governments in the states had a re-election. All such non-Congress governed states started to put up a united front, demanding more administrative and fiscal autonomy for them. G. Non-Congress governments in the states of Punjab, Tamil Nadu, Andhra Pradesh, West Bengal, and other states in Northeast have been demanding to review the overall scheme of the center-state relations. B. Second phase of Indira Gandhi 1980s. During Indira's reign in 1980s, chief ministers of the non-Congress-ruled states held several conclaves at various places questioning the centre's negligence of states' development program and eroding of the autonomy of the states. They also urged to review the center-state relation. 1. In 1982, the chief ministers of the 4 southern states met and agreed to form a Council for Southern Region to restructure and negotiate the center-state relation to ensure a more equitable distribution of the resources. 2. The second phase of Indira's rule was also authoritarian. Like the previous regime's president's rule was misused through improper use of the office of the governor, and state governments got dismissed. This continued until her death in 1984. 3. Once again the chief ministers of the states were handpicked on her will and wishes. 4. She still thought that the policy of centralization would work in her favor. But this centralization tendency faced a strong counter from the states during the second phase, unlike the first. 5. This resulted not only in regionalization of the state politics but also the party system. 6. The demand for structural change to federalism received a sudden boost after the elections of 1983, whereby a number of non-Congress state governments came into existence, especially in South. 7. They mobilized support for bringing in changes in constitutional provisions affecting the powers of the state. 8. The political leaders of the state and the elites demanded greater powers and autonomy to the states. 9. As mentioned earlier, the DMK government in Tamil Nadu and notably the government of West Bengal always protested against the over-centralized federal structure. 10. The Telugu Desam Party in Andhra Pradesh also revolted against the centralization policy of Mrs. Gandhi. This party was formed in 1980s to counter the hegemony 202 16 hours 37 minutes and 37 seconds issues and challenges pertaining to the federal structure 203. Of the Congress in the state, as many chief ministers were replaced continuously by Mrs. Gandhi, and the party became a laughing stock in the state. The rise of regional sentiments in Assam can be seen from the sprout of Assam Gana Parishad party in the state. 11. Indira's authoritarian and dictatorial rule was one of the major reasons for the rise of Khalistan movement in the state of Punjab. 12. In 1973, Anandpur Sahib resolution of the Akali leaders asserted that the Sikhs are a separate nation and demanded that the political structure has to be changed by devolving more powers to the state from the centre in all areas except defence, foreign affairs, currency, and communications. 13. This resolution was used by both the extremists of the Congress and the Sikh to sabotage the attempt made by the moderate Akalis to reach a settlement on the issues of Punjab with the centre. 14. The government of West Bengal too passed a resolution suggesting that centre play only a limited role except that pertaining to defence, foreign affairs including foreign trade, communication, currency, and economic coordination. Moreover, all these have to get approved by the National Development Council. 15. Chief ministers of several non-Congress-ruled states walked out in the session of National Development Council opposing centre's dissolution of democratically elected government in Jammu and Kashmir. 5.2.7 Sarkaria Commission recommendations. In the wake of severe criticisms faced by Indira Gandhi on her centralisation moves, she announced in the Parliament a proposal to appoint a commission on centre-state relations to be headed by R.S. Sarkaria, or retired judge of the Supreme Court. Subsequently, the commission was constituted vide notification 4/11017/1/83 CSR dated June 9, 1983. Further, 2 more members were included in the commission, namely B. Sivaraman and S.R. Sen. In order to resolve the centre-state rivalry, the Commission recommended several measures, including role and selection process of the governor and a strict procedure to be followed for imposition of emergency. The Sarkaria Commission made the following recommendations. 1. Setting up of Intergovernmental Council under Article 263, comprising the Prime Minister, Chief Ministers of all states and Union Cabinet members to discuss all major problems, other economic and development issues between the Union, state, and local governments. Though the council was set up, it could not do much to change the centre-state relation. 2. It also recommended decentralization of powers, and centre should restrain itself from occupying subjects in the concurrent list. 3. An informal convention should be established whereby, whenever centre decides to legislate of matters pertaining to the concurrent list, it has to consult the state governments concerned, except in cases of extreme emergency of urgency. The consultation should not only be done with the individual states but also with the collective of all states in the Intergovernmental Council. 203 16 hours 37 minutes and 37 seconds. 204. 5.2.8 Role of Governor. The controversial role played by the governor came into prominence during the blatant use of the president's rule during the regime of Indira Gandhi and Rajiv Gandhi. 1. The states raised voice against the role played by the governor. 2. The appointment process too was questioned as it was largely political and had no rationale, but it had a significant impact on the centre-state relations. 3. In the era of coalition regimes also, the office of governor was misused to bring about the president's rule. 4. The intervention by the judiciary reversed this trend. The Sarkaria Commission recommended certain measures to be taken before the imposition of president's rule in the state, but the Supreme Court in 1994 in the landmark S.R. Bommai case brought in the proclamation of emergency within the purview of the judicial review. 5. It also laid down certain guidelines for imposition of the president's rule in the states. 6. This unhealthy trend of imposition of president's rule came under fire from the Supreme Court in its Constitution Bench decision in Bihar Assembly dissolution case, 2006, which put a stop to misuse of Article 356. In this judgment, the court quashed the imposition of president's rule in Bihar by the centre. 7. Even in other several occasions too, the judiciary has played a vital role in dissolving the center-state conflicts. 5.2.9 Federalism in era of coalition politics. In the second wave of coalition era beginning in 1989, the coalition governments have become more prominent in center than in the states. It has thus changed the federal dynamics of the center-state relations. 1. The federalism debate became more vibrant and exciting. In the elections of 1989, the National Front in its manifesto talked about true federalism. It promised to reverse the centralizing tendency of the ruling government. 2. State-level parties in the present times have played prominent role in dictating the agenda of the national government. In addition to the role played by the judiciary in restraining the imposition of president's rule under its judicial review, the rise of regional parties in the national politics has also led to the review and reassessment of use of president's rule, Article 356, by the center. May 2, 10 Effect on policies of state. The economic liberalization policies in the 1990s had their own impact on the center-state relations. The center's role has undergone a radical change after a new industrial policy was formulated in the 1990s. 1. Many of the leaders of the state started to play a progressive role in external trade, commerce, and investment opportunities. 204 16 hours 37 minutes and 37 seconds Issues and challenges pertaining to the federal structure. 205. 2. The state governments now also play important role in shaping foreign and diplomatic relations. 3. The structural adjustment program of the WTO could not be carried out without the cooperation of the states, hence they were to be brought on board. 4. The central government's legislative initiatives in areas such as agriculture, rural employment, education, social welfare, healthcare etc. in the recent times have also changed the federal dynamics. 5. In order to implement the progressive social welfare schemes, the central government is now resorting to the concerned ministries/departments to sign Memorandum of Understanding, MOU, with the concerned state governments. 6. This is important as center is dependent on the resources of the state government in order to implement major decisions and policies. Thus, real decentralization of power and authority presently taking place instead of mere transfer of administrative and functional powers, is now setting the outline for center-state dealings. May 2, 11 Views of Dr. Ambedkar. The emergence of coalition governments at the center has strengthened the role of regional political parties and elites, but it has created an atmosphere where the governance of the country is suffering. At present there is a competitive blackmail-type bargaining between the center and the states, and this is making the governance system more inefficient and corrupt. At this juncture, it is worth quoting the visionary leader Dr. Ambedkar's argument for a strong and unified India, way back in 1939. The existence in the country of one government which can speak and act in the name of and with the unified will of the whole nation is no doubt the strongest government that can be had. Only a strong government can be depended upon to act in an emergency. The efficiency of governmental system must be very weak where there exists within a country a number of governments into which different parts of the nation's strength flows and whose resistance to the will of the central government is likely to be more effective than could be the resistance of individuals, because such bodies are each of them endowed with a government, a revenue, a militia, a local patriotism to unite them. May 2, 12 Three phases of coalition era. A. Phase I. Looking into the center-state relations in the post-independent India, we can see that it can be separated into three distinct phases. First, during the first 2 decades, most particularly under Nehru-Shastri, the center-state relations can be termed as cooperative with leaning towards centralization. The center-state relations were centralized in the areas of economic planning and national development. Otherwise, Nehru maintained politically balanced and cooperative federal relations. B. Phase 2. In the second phase, after Nehru, especially after the 1967 general elections, Indira Gandhi turned the cooperative federalism of Nehru-Shastri into coercive federalism. The center-state relations became unidirectional initially, and later became reactionary. This kind of coercive federalism was marked by over-centralization of both political and economic power. The states 205 16 hours 37 minutes and 37 seconds. 206 were virtually ruled over by the center. Even the Janata government, elected to power on basis of discontent against the policies of Indira, did nothing to reverse the centralization trend. In the second phase of Indira after the 1980s election, many of the state governments started to react sharply against the authoritarian and over-centralization measures of Indira. Rajiv Gandhi, while trying to become cooperative with the states initially, took upon his mother's over-centralization and authoritarian measures to take political decisions. Again, the state's leaders reacted sharply to such measures. This coercive and over-centralized decision-making process in center-state relations continued unabated till 1989, when a new era of coalition regime started to emerge. C. Phase 3. The third phase of the center-state federal dynamics started after the emergence of the coalition regimes, was marked simultaneously with confrontation and cooperation between the center and the state governments. If the bargain worked in favor of cooperation, then center and state cooperated, otherwise the confrontation between them became obvious. A continuous phase of coalition politics has given enormous power to some of the state political parties and their leaders to work the federal bargain in favor of their respective states. Political bargain was also carried out by the central government for its own sustenance. This bargaining has led to uneven development because of trying to accommodate the interests of states. Valid demands have been marginalized, and center has become weak to carry forward any strong reform, including much talked about economic liberalization measures and national security concerns. May 2, 13 Punch High Commission. The UPA government in 2007 constituted a commission on center-state relations under the chairmanship of M.M. Punch High in order to address the emerging concern of center-state federal dynamics. In a lengthy report in April 2010, in Volume I, the Commission commented as follows. With ever-growing aspiration of the states and in some cases the concerns of the central government, it was felt by the Government of India that time had come to have another comprehensive look at the entire gamut of center-state relations so that a further positive headway can be made on this important subject. It is clear that the center's concern about the emerging federal dynamics in center-state relations was the main reason in constitution of the Commission under Punch High on center-state relations. In fact, constitution of previous Sarkaria Commission and the present Punch High Commission was based on two different considerations. In the case of Sarkaria Commission, it was constituted under the pressure from the state governments, while Punch High Commission was constituted by Government of India on its own initiative. May 2, 14 Conclusion. Analysis of federal dynamics influencing the center-state relations in post-independent era may lead us to concur with the argument of J.A. Corey, that if centralization pushed too far in any federation, it will break down in its own weight. This is particularly so because the states in a federation have territories of their own. If the territories in a federation are not well defined, 206 16 hours 37 minutes and 37 seconds issues and challenges pertaining to the federal structure 207. Then it does not constitute a true federation. In a federal structure, the center has to be accommodative of the states. Constitutionally, powers might be granted to the center to discipline the states, but in a democratic federal polity, the center cannot unilaterally use its constitutional power to impose its dictates. The center is dependent on the states, particularly in present time, where the state political leaders play an important role in forming of coalition government in the center. In the era of coalition governments, it will be difficult for the center to resort to any kind of centralization of power and authority. But in coalition regime, if the states are allowed to follow its own way, without recognizing the need for interdependence, it will destroy the unity and integrity of the federation. There is a constant need for reappraisal of center-state relations due to changing dynamics, hence a parliamentary committee on center-state relation may be constituted for this purpose. 5.3 Impact of new economic and developmental policies on federalism. 5.3.1 Introduction. In 1991, India brought in some significant economic reforms in order to overcome a severe crisis and to align itself to the neoliberal conditions as suggested by the World Bank and the WTO, allegedly on behest of the developed nations. India thus liberalized and opened its economy to the world by removing strict government barriers, rules and regulations, and easing the norms for foreign investment in the country. This reform led to substantial decentralization of powers and functions, with larger decision-making power to the state governments in bringing in the investments to their respective states. This was a major boost of investments to the states, and some of the states exploited the opportunity to the maximum and brought in investments to their own states. However, things changed. The economic reforms did not spill over and it could not bring in the changes for which it was intended. Down the line, major economic reforms could not be brought in because of the reluctance of many state governments. It seems that there is an organic linkage between federalism and growth of modern market economy. According to some scholars, in 1990s India experienced de facto, not de jure, decentralization of its policy management. This decentralization was not carried out in planned or systematic manner. Another impact of this neoliberal policy combined with the coalition politics of 1990s is that the federal relations among states became more intense and competitive. 5.3.2 Impact of the Enron deal. Direct negotiations were carried out with the state governments immediately once the economy was liberalized, by the multinational foreign companies and other global financial institutions like the World Bank. It was perceived that states had become important centers of economic decision-making, including that of the foreign entities. One such example of this is when a historic agreement was signed for power purchase between the Maharashtra government and the Texas-based energy giant, the Enron, in 1993. Sovereign counter-guarantee was given by the center due to the pressure given by the Maharashtra state, in order to enter into the said agreement with Enron. However, the project could not see light of day as it was flawed and had to scrapped after strong lobbying and protests against it. Though the project was scrapped, 207 16 hours 37 minutes and 37 seconds. 208. It had left denting revelations that the new economic reforms had on the center-state federal fiscal matters. 1. This episode with the Enron did not prevent center and state from carrying out other externally funded projects. 2. In fact, the sovereign guarantee given by the center to Enron became the basis for giving guarantees to several other external loans and funding to the state, including the ones granted by the World Bank, Asian Development Bank and other agencies. 3. The World Bank has been funding development projects in some states under its structural adjustment programs. This has caused some tension because, as per Article 292 of the Constitution, the states can borrow only within the territory of India. 4. The states were enthusiastic in getting funds from outside, hence the central government thought over the issue because the fiscal deficits were also on the rise. 5. The central government therefore directed the lending agencies and other international finance institutions to make sure that the funds they allocated to the states were not misused to meet revenue deficits and utilized only for the purpose it meant. 6. It also gave freedom to these institutions to discontinue funding if the state is not performing up to the standards. 5.3.3 The deal with WTO. One of the most significant aspects of the post-1991 reforms is the negotiation carried out by the government with the WTO and how this impacted the center-state relations. Under Article 253 of Constitution of India, the central government has a sovereign and exclusive right to enter into international bilateral and multilateral treaties/agreements/convention. But when the center was making such negotiations with the WTO, they had to face stiff challenges from the states. As the usual practice, the Government of India, without consulting the states, signed the agreement with the WTO in 1994. And when the treaty had to be operated in the country from January 1995, various voices were raised by the state governments against the contentious issues of the WTO provisions already signed. 1. As per the Constitution 7th Schedule, the subject matter of agriculture belonged to the state list, hence falls under the legislative purview of the state government, but the central government, taking advantage of powers under Article 253, had already made several negotiations with the WTO with various matters pertaining to the subject matter of agriculture, including agriculture production, marketing, and pricing and distribution of agricultural products. 2. The WTO treaty had a far-reaching consequence on the Indian federalism. Though a broad reading to the Constitution may seem to confer all the powers to the central government to enter into such negotiations, but in reality this move went directly against the spirit of federalism. 3. Very recently, the center's move to introduce foreign direct investment in multi-brand retail was stiffly opposed by the states on the fact that it would impact small retailers and farmers, and thus they were able to force the center to revisit its policy in the same. 4. The states were given option to decide whether to allow retail investments in their states or not. 208 16 hours 37 minutes and 37 seconds. Issues and challenges pertaining to the federal structure. 209. 5.3.4 Impact of state government on center's policy. There are also other instances where the states have played de facto role in determining the decision of the center on foreign policy of Government of India. For instance, the state of Tamil Nadu has very often been directing the central government on how it should maintain relations with the neighbouring country of Sri Lanka. The Legislative Assembly of the state of Tamil Nadu has even passed resolutions dictating on its own terms for the Indo-Sri Lanka relations. Recently, because of the stand taken by the government and political parties of Tamil Nadu, the Prime Minister of India had to cancel his participation in an important meeting of the Commonwealth Heads of Governments meeting, COGME, in Sri Lanka. As far as the river water sharing agreement with Bangladesh is concerned, the government of West Bengal has its own stand. In the issue of sharing the water of Teesta River, the action of West Bengal government embarrassed the government of India recently. There are various other instances where the states have played a role in influencing the foreign policy matters. States with international borders have always had a say in foreign policy matter, either directly or indirectly. 5.3.5 Impact of neoliberal economic policies. Coming back to the impact of the neoliberal economic policies on the center-state relations, it is important to highlight that such policies have created growth and development of numerous new central agencies and regulatory bodies in order to boost the liberalized market economy. Some of the Pan-India central agencies like the Competition Commission of India, the Securities and Exchange Board of India, the Telecom Regulatory Authority of India, the Insurance Regulatory and Development Authority of India, the Central Electricity Regulatory Commission, etc. have started to play important roles, and all these have far-reaching federal implications. In addition to this, the National Commission to Review the Working of the Constitution, NCRWC, has recommended that for the purpose of carrying out the objectives set out in Articles 301,302,303 and 304 of the Constitution, and for other purposes relating to needs and requirements of interstate trade and commerce and to eliminate barriers preventing them, the Parliament should by law constitute an authority called as the Interstate Trade and Commerce Commission, ITCC, under the Ministry of Industry and Commerce. 1. While the neoliberal economic policies have had made significant impact on the center-state relations, developmental issues are also increasingly tend to impact this relationship. 2. These development issues broadly cover a wide range of issues pertaining to governance and service delivery of some of the major areas of public concern, including agriculture, social welfare, education, health, family planning, rural development, etc. Most of these are under either the state jurisdiction or under concurrent list as per the Constitution. 3. However, due to lack of sufficient funds and expertise, the states are not taking much initiative in these major areas of concern. 4. Though it is in the hands of the state governments to take initiative, they tend to look at the center for directions in these matters. Taking education, for example, it was initially under state list and then brought to the concurrent list by the 42nd Amendment of the Constitution in 1976. 209 16 hours 37 minutes and 37 seconds. 210. 5. And since then all major legislative and policy decisions involving the field of education has been made by the central government. Even in the case of subject of agriculture, all major policy initiatives have been taken by the center. 6. The center is thus playing a dominant role in the areas of state concern. 7. It has brought in several major policies and legislations in the field of agriculture, social welfare, health care, family planning, education, housing, rural development, etc. 8. All these areas have been covered by the central planning, and under one or the other centrally sponsored schemes, all these factors have soured the center-state relationship. 9. All these acts by the center have eroded the responsibility and initiative of the states, even their constitutional accountability has been diminished. 10. The more the center forms policies on the state subjects, the more damaging effect it has on the center-state federal structure. 11. This is so because majority of these schemes were formed without the consultation of the state governments, and their views were not sought while framing the guidelines for their implementation. 12. Sarkaria Commission on Center State recommended that the central schemes should be kept to a minimum and there should be maximum decentralization of plan formulation. 13. Rather than decreasing, the center continued to increase the centrally sponsored schemes with clear disregard to the federal system. 5.3.6 Inequality between the states. According to scholars, India is a federation of states, but its regional developmental process was relegated to the background in the clamor for fulfilling national growth objectives. This led to significant inequality gap between the states based on infrastructure and development. Though the liberalization and the reforms after 1991 put India on the fast track of growth, inequality is prevailing among the states. Hence, the several states have started demanding flexibility in their planning and growth strategies. The issue of regional disparity and inequality prevailing among the states were put forth by the backward states long before the reforms of 1991 got initiated in the country. The Third Five-Year Plan in 1961 explicitly stated that the location of new enterprises, whether government or private, due consideration has to be given to create a balanced economy in different parts of the country. The central government addressed this issue of states by issuing special category status to some states based on their backwardness, presence of hilly region. Even some of the bigger states like Bihar, Orissa, and Bengal are now demanding the special category status. 1. In short, the neoliberal policies and reforms of the 1991 have radically transformed the Indian economy to a market economy, and presently corporates and industries now play a dominant role in restructuring the political economy of the country. 2. Despite this, the autonomy of the state still remains an important factor for consideration. 3. It would be difficult to carry forward the growth and development agenda without addressing the concern of the states and their autonomies in their own sphere and jurisdiction. 210 16 hours 37 minutes and 38 seconds Issues and challenges pertaining to the federal structure. 211. 5.3.7 Impact of corruption. Another major cause of concern for the center-state relations is the fight against corruption and criminalization of politics, which has now become a predominant feature of the Indian political system. The criminal law enforcement system is heavily tilted in favor of the center. Organizations like Central Bureau of Investigation, which is responsible and accountable to the Office of the Prime Minister, is the principal agency in combating high political and bureaucratic corruption not only at the center but also in the states. Rather than combating the menace of corruption, this agency has been used discriminately against the states. 5.3.8 Subject of education. As far as sphere of education is concerned, it seems that the center is taking overall responsibility. Since the time of emergency, when the subject of education was moved from the state list to the concurrent list, the central government has started to bring in major legislations in that subject. Moreover, the states also follow the guidelines set by the center in this regard. This centralized control of education by the center can be traced back to the British era. The Central Advisory Board of Education, CABE, established in 1920 by the colonial government, marked the beginning of the centralized coordination of education in the country. Despite education being subject matter of the state list, the matters of higher education always came under the purview of the central government. Apart from creation of University Grants Commission, UGC, the central government created several other bodies to regulate and implement its policies in the sphere of education. The All India Council for Technical Education Act, 1987 and the National Council for Teacher Education Act, 1993 have both given the control of technical and professional education to the Centre 1. The central government has in fact completely intruded into the sphere of education and have recently enacted many legislations pertaining to it, and the most important of those legislations is the Right to Free and Compulsory Education Act, 2009. 2. States are presently trying to attract more central institutions, such as IIT and AIIMS, to their states. In order to maintain the federal balance, the central government has created central universities in almost all states. 3. Federal consideration is now becoming an important factor in determining the strategic location of various other central government institutions of higher and professional education. 4. Views of members of Constituent Assembly. Members of the Constituent Assembly understood the significance and hence supported the central control of the education. Some scholars such as Frank Antony proposed that the education throughout the country has to be under the control of the center after getting approval and endorsement of people of eminent domain associated with the sphere of education. Others such as Renuka Ray stated that in the nation-building services the unifying force has to be strong, hence the center should be given power to regulate and coordinate services, especially education and health. Basanta Kumar Das stated that center should have enough power to carry out a uniform policy of education and to give financial assistance to the states so that such uniform standards 211 16 hours 37 minutes and 38 seconds. 212. Be reached. Phul Singh was also in favor of uniform education policy as elaborated by the center and states receiving adequate financial assistance from the center. 5. The above-mentioned debates in the Constituent Assembly was reflected in the contemporary educational policies in India. 6. The Sarkaria Commission on Center-State Relations was of the opinion that the best way forward in the sphere of education is that actual norms and standards of performance are set by the union and bodies such as UGC set up under central legislations, but the actual implementation should be left to the states. 7. The Commission was also of the opinion that a system of monitoring has to be established by the Union. Further, it suggested that states and their universities/institutions have to be taken into confidence through close collaboration and cooperation between the center and the states. 8. From an overall perspective, it is clear that the states do not have adequate infrastructure and resources to carry forward the burgeoning educational requirements. Thus, the states have to rely on the center, which has taken de facto responsibility to control and regulate the sphere of education in almost every aspect. In establishing central universities and institutions within the jurisdiction of the states, it should follow certain minimum/uniform standards and regulations. However, modification and changes might be required so that specific and peculiar problems of each state is addressed in effective manner. 5.3.9 Conclusion. The beginning of independent India was with a unitary federal state under a highly centralized constitution, which defined India as union of states. This term obviously meant federation, though the term was deliberately avoided in the constitution. The federalism was an inevitable necessity. Though the constitution was in favor of the center, it did make provisions for maintaining the federal characteristics. In due course of time, the federalization had strengthened as recognition was accorded to federal diversity of ethnic, regional, linguistic, and other cultural communities. The process of federalization had happened through unionization and regionalization, which are expected to provide for the stability of the nation as a whole. The Constitution grants enough power to states to give representation and protect the identities and interests of the minority communities, including territorial and non-territorial communities. India, though a multinational state, is increasingly tending towards a nation-state system. The states are looking toward one government that is at the center, which is playing a dominant role in almost all aspects. Centralized political authority is considered to be the most suitable for any effective governance system in the country. This effectively curbs the mischief of the regional leaders and parties. Perhaps time has come now to recognize districts as constituent units of governance. The Constitution might delegate specific power and responsibility at the district level, including the criteria to create new districts. The central government should stop its dependency on the states for implementation of its policies. Instead, it should deploy its own officers and set up the effectiveness of the districts so that they become the center of implementation. The center can also promote the local elites. There should be no other state than that of the nation-state with governance structure based in the districts. This may essentially solve many of the problems faced by various smaller minority and unrepresented communities. 212 16 hours 37 minutes and 38 seconds Issues and challenges pertaining to the federal structure 213. 5.4 Governor as factor in federal relations. 5.4.1 Introduction. Long before independence, the office of governor has been functioning as the head of the provinces. The office is still playing a pivotal role in the center-state federal relations. Article 153 of the Constitution provides that there shall be governor for each state, and Article 154 says that he shall be the executive head of the state. The Constitution also provides that the same person can be the governor of two or more states. The important provision given in the Constitution has been highlighted by the Sarkaria Commission. Three important facets of the governor's role is as follows: A. The constitutional head of state operating normally under a system of parliamentary democracy. B. A vital link between the union government and the state government. C. An agent of the union government in a few specific areas during normal times, e.g. Article 239, 2, and in a number of areas during abnormal situations, e.g. Article 356, 1. Though the position of governor in post-independent era is considered to be symbolic, he has often played a very controversial role in the relations between the center and the state. As per the Constitution, the post of governor is not an elected one, rather it is appointed by the union government. Though he/she plays a very vital role in relations between the center and the state has no role in the appointment process. Governor is appointed on recommendation of the central government by the President. He can continue for a term up to 5 years and holds office at the pleasure of the President. This shows that the governor is an agent of the center, but Constitution nevertheless bestows upon his office important and vital powers which is central to the functioning to the state government. 5.4.2 Origins Office of Governor. As mentioned earlier, the post of governor is not a new one, it had its origins long before the independence of the country. Under the auspices of the British Empire, the office of governor was created. In fact, the governor had a very important role to play under the Government of India Act, 1935. But these powers granted to the governor of the province under the 1935 Act were significantly reduced in the Constitution after the independence. 1. Serious debate took place when the powers to be granted to the governor came up before the Constituent Assembly, which was given the responsibility to frame the constitution of the country. 2. Various arguments for and against were made regarding the election/nomination of the governor and his/her role, authority, and power. 3. The Provincial Constitutional Committee had formed and submitted a model provincial constitution, and based on this in July 1947 the Constituent Assembly had accepted the principle for the election of the governor for all the provinces based on universal adult suffrage. 4. There were some difficulties in proceeding with direct election of the governor with limited responsibilities. 5. Hence, the Constituent Assembly later in the discussion of the draft constitution decided to do away with the system direct election of the office of governor. 213 16 hours 37 minutes and 38 seconds. 214. 5.4.3 Views of Leaders on Governor's Office. Constitutional Debates. A. Alladai Krishnaswamy IR. Alladai Krishnaswamy IR made arguments rejecting an elected governor. He supported the concept of presidential appointment on consultation with the cabinet. According to him, the expenses involved in process of election was disproportional to the powers vested to the office by the Constitution. Like other leaders, he saw that there would be a danger of clash when both governor and the chief minister are elected by the people. Most of members of the Constituent Assembly at the time of debate thought that the post of governor will be just a mere figurehead as he/she will not be interfering with the day-to-day administration of the provinces. B. P.S. Deshmukh. According to P.S. Deshmukh, if the position of governor is going to like that what were provided under the 1935 Act, and similar provisions were adopted in the draft constitution also, then the post of governor has to be appointed by the president and no election process is to be involved. Like many other leaders like IR, Deshmukh too had his own apprehensions about the office of elected governor coming in conflict with the provincial government. As the debate went on further, many of the members of the Constituent Assembly were against the direct election based on universal adult suffrage. C. B.G. Kerr. According to B.G. Kerr, the direct election was not advocated by anyone not just because it incurred huge expenses, but also to the fact that there is already a post elected chosen by all the people of the state and the whole power was bestowed upon this office of the chief minister. If another person is chosen directly by the people, there would be confusion in allocation of the responsibility and authority of the state which would further lead to conflict, and this conflict has to be avoided for smooth functioning of the administration. However, Kerr disagreed with the argument that governor is just a mere figurehead. To quote Kerr, "So far as the governor is concerned, we have given him very few powers. But, I do not agree with the comment that he is mere a figurehead. A figurehead is capable neither of good nor of bad. I wasn't to submit to the House, sir, that a governor can do a great deal of good if he is a good governor and can do a great deal of mischief, if he is a bad governor, in spite of the very little power given to him under the Constitution we are now framing. The powers that we purpose to give him, and the functions that we assign to him are very few, such as summoning and dissolving the Assembly, to give assent to the bills passed by the State Assembly, to act as representative of the state, to nominate the Premier after the general election of the resignation of the ministry, to represent the province on ceremonial occasions, and such power is given to act in the emergency. He is the symbol of the state, and we have found in actual practice that if he is an active governor, a good man, he can, by all means of getting into touch with opponents of the party which is in power, reconcile them to good number of measures, and generally, by tours and other means make the administration run smoothly. Similarly, he can do a great deal of mischief. I believe, therefore, to have as a governor a person who is elected on a wider franchise, to have at the head of the province a person who is supposed to be more representative that the premier, would be a mistake. The only insurance for smooth government in the provinces is to allow the president of the country to nominate a person who enjoys his confidence, which clearly means the confidence of his cabinet as also the cabinet of the province, to be the governor or the province any other mode. Whether by election on adult suffrage or by election by the representatives of the people in the House, will give rise to considerable friction. 214 16 hours 37 minutes and 38 seconds. Issues and challenges pertaining to the federal structure. 215. B.R. Ambedkar made it clear about the powers of the governor. He stated in the Constituent Assembly as follows: the real issue before the House is really not the nomination or election, because, as I said, this functionary is going to be purely ornamental functionary. How he comes into being, whether by nomination or by some other machinery, is purely a psychological question. D. H.N. Kunz-Rue. According to H.N. Kunz-Rue, the ultimate power with regard to any serious problem in the province will rest with the president, but he will not act without consulting the governor of such province. Constituent Assembly at the time of discussion about the general principles of the Constitution agreed that there has to be some provision for its breakdown, something similar to the Section 93 of the Government of India Act, 1935. It was proposed that if the governor feels that the setup provided by the Constitution for administration of the province breaks down, then the governor should have the power by proclamation to take over the administration of the province for a fortnight and communicate the same with the president, that since constitutional machinery had failed in the state, he, the governor, had proclaimed and taken over the administration to himself. This shows the dominant role played by the governor in the provinces. There were also other voices calling for increased power to governor and his direct election by the people. E. Jawaharlal Nehru. At the time of final discussion of the draft constitution, the Constituent Assembly accepted the provision to have a nominated governor. On May 31, 1949, Jawaharlal Nehru stated as follows: I feel that if we have an elected governor, that would to some extent encourage separatist provincial tendency. There will be far fewer common links with the centre. Apart from the tremendous burden of these elections for the provincial and the central legislatures, to add another election on this major scale would mean not only spending a tremendous deal of energy and time of the nation, but also money of the nation, and divert it from far more worthwhile projects. Apart from this, it would undoubtedly mean, I think, encouraging that narrow provincial way of thinking and functioning in each province. I think it would be infinitely better if he was not so intimately concerned with the local politics of the province, with the factions in the provinces. He must be acceptable to the province, he should be acceptable to the government of the province, and yet he must not be known to be a part of the party machine of that province. He may be sometimes, possible, a man from that province itself. We do not rule it out. But on the whole it probably would be desirable to have people apart in politics. There may be an eminent educationist or persons eminent in other walks of life, who would naturally, while cooperating fully with the government and carrying out the policy of the government. I think that an elective governor is almost invariably not only likely to be that province, but is likely hardly ever to represent any of the numerous minority groups that exist in the country. 5.4.4 Role of Governor. Constitutional debates. Majority of the members in the Constituent Assembly felt that the governor has to play the important role of the agent of the centre. 1. They wanted the governor to help the central government in implementing its policies and agenda throughout the country. 2. Many of the senior-most leaders were unconcerned about the autonomy of the provinces. Their main agenda was to unite and integrate the country, and they felt that it can 16 hours 37 minutes and 38 seconds. 216. Be achieved by nominating the governor by the Union, rather than having him elected directly by the people. 3. This nomination will enable the central government to effectively control its policies and agendas. 4. They wanted the provincial government to be subordinate of the central government. The chairman of the drafting committee of the Constitution, Br. Ambedkar clarified this position in the Constituent Assembly on June 1, 1949. He stated as follows: because the provincial governments are required to work in subordination to the central government, and therefore in order to see that they do act in subordination to the central government, the governor will reserve certain things in order to give the president the opportunity to see that the rules under which the provincial government are supposed to act according to the constitution or in subordination to central government are observed. Towards the end of the Constituent Assembly debates, Br. Ambedkar further highlighted the constitutional role of the governor as follows: the governor under the Constitution has no function which he can discharge by himself, no function at all. While he has no function, he has certain duties to perform, and I think the House will do well to bear in mind this distinction. A distinction has been made between the functions of the governor and the duties which the governor has to perform. My submissions is that although the governor has no functions still, even the constitutional governor, that he has certain duties to perform. His duties, according to me, may be classified in two parts. One is, that he has to retain the ministry in office. Because the ministry is to hold office during his pleasure, he has to see whether and when he should exercise his pleasure against the ministry. The second duty which the governor has, and must have, is to advise the ministry, to warn the ministry, to suggest to the ministry an alternative and to ask for reconsideration. I do not think that anybody in this House will question the fact that the governor should have this duty case upon him, otherwise, he would be an absolutely unnecessary functionary, no good at all. He is the representative not of a party, he is the representative of the people as whole of the state. It is in the name of the people that he carries on the administration. He must see that the administration is carried on at level which may be regarded as good, efficient, honest administration. I submit that he cannot discharge the constitutional functions of a governor which I have just referred to unless he is in a position to obtain the information. It is to enable the governor to discharge his functions in respect of a good and pure administration that we propose to give the governor the power to call for any information. 5.4.5 Role of Governor. After independence, the Constitution of Independent India has vested some very important powers, roles, and responsibilities on the office of the governor. 1. The governor plays an important role in the legislative sphere of the state concerned. 2. He may or may not give consent to the bill passed in the Assembly. In this regard, Article 200 states that when a bill is passed in the Legislative Assembly of the state or, in case of states having legislative council, by both the houses of the legislatures, it shall 16 hours 37 minutes and 38 seconds issues and challenges pertaining to the federal structure 217. Be presented to the governor, then he either gives assent, or withholds it, or he sends the bill again to the legislature for its reconsideration, or he withholds his consent and reserves the bill for the consideration of the President. 3. Further, Article 200 provides that when the reconsidered bill is again submitted before the governor with or without amendments, he has to give his assent and cannot further delay its passage. 4. Also under Article 201, the governor is given power to reserve the bill for the consideration of the President. 5. Article 161 of the Constitution bestows power to the governor to grant pardons, reprieves, respite and remission of punishment or to suspend, remit or commute sentence of any person convicted of any offense to which the executive power of the state extends. 5.4.6 Controversial role of governor. The most controversial role of the governor, which has serious repercussions on the center-state relations, is when he submits reports to the central government recommending the president's rule in the state. 1. Emergency. Under Article 356 can be proclaimed even without the report of the governor by the president if he is satisfied that such situation exists. However, most of the president's rule in states have been proclaimed on basis of the reports of governors. 2. The central government, in order to avoid controversy for taking unilateral decision on imposing emergency, relies on the report of the governor to impose it. 3. Since the governor, being an appointee of the center, generally complies and cooperates with the center and provides with reports as required by the center, in this case recommendation report for imposition of president's rule. 4. There are also few instances where the governor refused to comply with the directions to the center and the union government had to unilaterally impose the president's rule. 5.4.7 Examples. Excesses by governors. The report of the governor based on which the president's rule was imposed was unchallenged until the landmark Supreme Court's judgment in S.R. Bamai's case. There was no one single way or guideline based on which the report has to be submitted for recommending president's rule. A. Kerala, for example. The imposition of the president's rule in the state of Kerala in 1959 was based on the recommendation of the report of the governor, who had felt that the ruling party had lost support of the majority of the people. This doctrine can become a dangerous weapon in hands of the governor and the central government, who can dismiss constitutionally elected government in the state. Even personal conviction of the governor became grounds for dismissal of the state government and for imposing the president's rule in the state. In the above case, the governor did not bother to realistically analyze whether the communist government enjoyed majority or not in the assembly. 217 16 hours 37 minutes and 38 seconds. 218. B. Andhra Pradesh. In another incident of imposition of president's rule, the governor of Andhra Pradesh, in 1984, dismissed the non-Congress chief minister allegedly based on some information that he had lost majority in the assembly. A minority government was then installed and was given an unusual long time of a month to prove majority on the floor of the House, which it failed to do. Rather, the previous dismissed chief minister N.T. Rama Rao of the Telugu Desam party successfully proved his majority. This shows that how governors arbitrarily dismiss, without any genuine reasons, a constitutionally elected government based only on political considerations. In the case of Andhra Pradesh, the governor and the central government came under intense public pressure, and were compelled to set aside their earlier order and had to replace the governor. Also, there were raising calls for abolition of office of governor itself. 5.4.8 Governor and agent of center. The discretionary powers granted to the governor were in reality used by the central government, using the governor as the proxy. 1. The office of governor was used frequently by the center to install government of its choice in the state. 2. The controversy starts right at the beginning, with the appointment of governor. The office of governor has to be neutral as envisaged by the constitutional makers, but in reality defeated and active politicians were appointed to the office, thereby politicizing the post of the governor, who then took active part in the politics. 3. Non-political persons such as retired bureaucrats too were appointed as governors, even they were loyal to the government that had appointed them. 4. The frequent use of president's rule and the role played by the governor in it, particularly in coalition situation, created a unique practice of parading the supporters before the governor of state to convince him of the majority for forming the government. 5. The political role of the governors can be clearly seen from the fact that they never stick to a fixed time for proving the majority. Some selected leaders and parties were given extraordinarily long time to prove majority while some others were denied the same. The governor's office was so politicized that when the National Front government led by VP Singh took over the central government, the president, in January 1990 called for resignation of 18 governors to facilitate the reshuffle by the Union. The National Front government could not trust the impartiality of the governors appointed by the previous Rajiv Gandhi-led Congress regime. 5.4.9 Recommendations Sarkaria Commission. Several representations regarding the role of the governor was made before the Sarkaria Commission on Center-State Relations by the state governments, many calling for the reduction in powers and role of the governor. Representations were even made for the abolition of the office of governor itself. The Sarkaria Commission suggested the following 4 criteria for being appointed as a governor: 218 16 hours 37 minutes and 38 seconds issues and challenges pertaining to the federal structure. 219. 1. He should be eminent in some walk of life. 2. He should be a person from outside the state. 3. He should be a detached figure and not too intimately connected with the local politics of the state. 4. He should be a person who has not taken too great a part in politics generally and particularly in the recent past. In selecting a governor in accordance with the above criteria, persons belonging to the minority groups should continue to be given a chance hitherto. The Sarkaria Commission recommended that the selection should be based on consultation with the following authorities: the Vice President of India, Speaker of Lok Sabha and the Chief Minister of the state concerned. The Commission also recommended that it is desirable that a politician from the ruling party at the centre is not appointed a governor of a state which is being run by some other party or a combination of parties. The Commission observed that different governors had adopted different methods for similar situations for the dissolution of the State Assembly, and, accordingly, it was suggested by the Commission that Article 356 be amended so that the State Legislative Assembly should not be dissolved either by the Governor or the President before the proclamation issued under Article 356, 1, has been laid before Parliament and it has had an opportunity to consider it. May 4, 10 Recommendations. National Commission to review the working of the Constitution. The NCRWC has also made certain recommendations with regard to what role the governor should or should not play. It recommended that the question of whether a government has lost majority in the Assembly has to be decided only on the floor of the Assembly and nowhere else. NCRWC also recommended that the government in the state should not be dismissed as long as it enjoys confidence of the House and the majority in the Assembly. The governor can only dismiss the government when the chief minister refuses to resign even after his party had failed to prove majority on the floor of the House and on losing a no-confidence motion in the Assembly. In a situation of political breakdown, the NCRWC recommended that the governor should explore all possibilities of having a government enjoying majority support in the Assembly. If it is not possible for such a government to be installed and if fresh elections can be held without avoidable delay, he should ask the outgoing ministry, if there is one, to continue as a caretaker government, provided the ministry was defeated solely on an issue, unconnected with any allegations of maladministration or corruption and is agreeable to continue. The governor should then dissolve the Legislative Assembly, leaving the resolution of the constitutional crisis to the electorate. Regarding the imposition of the President's rule based on the report of the governor, the NCRWC recommended that the report has to be a speaking document containing a precise and clear statement of all material facts and grounds on the basis of which the President may satisfy himself as to the existence or otherwise of the situation contemplated in Article 356, and the Governor's report based on which the President rule is imposed should be given wide publicity in media and in full. 219 16 hours 37 minutes and 38 seconds. 220. May 4, 11 Conclusion. Even in present condition, the office of governor continues to play a major factor in the central state-federal dynamics. Despite numerous recommendations made by various commissions on center-state relations, the office of governor is continued to be misused by the central governments. It has become a ritual to reshuffle or change the governors of the states when there is a change in the government at center. 5.5 Impact of emergency on federal relations. 5.5.1 Introduction. There are some very unique features present only in the Constitution of India and found nowhere else. One such provision is the emergency powers vested with the central government. Central government has the power to turn the federation into a unitary system during this period, and in case of president's rule it has the power to suspend the state government, and during financial emergency it controls the finances of the state. Under the Articles 352/356, the central government virtually takes control over the entire legislative, administrative, and executive functions of the state instead of restoring back the constitutional machinery in the state which had failed. 5.5.2 Emergency provisions in Constitution. Except on few occasions, most of the application of President's rule was for political considerations. As per the Sarkaria Commission's report, nearly 75 instances of application of President's rule was to prevent a party from forming a government or dismiss a legitimately elected government. Political controversy followed most of the President's rule, and widespread protests and agitation were carried out by the people in many instances, and hence leading to the removal of the governors who have proposed the President's rule in the state. The Articles 352, 356 were envisaged as a last resort and as a salvage operation for the sick state, but it has been brazenly and wantonly violated by every government who has assumed power at the center. The word otherwise given in Article 356 has been interpreted in various ways to dismiss the state governments by the center without the reports of the governors. Hence, it is clear that the emergency provisions have significantly impacted the center-state federal dynamics. But it is also clear that all these interregnums were temporary, none were permanent. The Constitution also made it clear that these emergency provisions operated for a limited time only. 5.5.3 Emergency. The beginning. The first controversial use of the Article 356 was made by the first Prime Minister Jawaharlal Nehru when he imposed the President's rule in Punjab in 1951. He forced the Congress Parliamentary Board to compel the then Chief Minister of Punjab Gopi Chand Bhargava to resign, even though he enjoyed the majority support of the Nehru's cabinet. He informed the President that after the Chief Minister resigns no new ministry would be formed. Rather, the governor will submit a report that it was not possible to run the government as per the Constitution, and hence the President then should invoke the President's rule in the state and take over its administration. Nehru was careful in imposing the President's rule then onwards, but Indira Gandhi, Rajiv Gandhi, including the Janata government of 1977's use of this provision severely 216 hours 37 minutes and 38 seconds issues and challenges pertaining to the federal structure 221. Damaged the relation between the center and the state until the emergence of the coalition government in 1989. For now the national emergency has been imposed thrice. First during the Chinese aggression in 1962, and it continued, and no new emergency was imposed in 1965 during the war with Pakistan. The next was in 1971 during the liberation of Bangladesh, and finally the most controversial imposition of emergency in 1975 by Indira Gandhi. The President's rule has been imposed across states for more than 120 occasions, and the financial emergency as provided in Article 360 has not been imposed so far. 5.5.4 Emergency. Indira's time. In order to understand the increased use of President's rule during Indira's time, it is important to look into the political ramifications which forced her to retort to such draconian measures of imposing President's rule in the states and national emergency of 1975. 1. After Nehru, Indira succeeded in his place, and Indira faced a very tough scenario. The economy was in dire state, especially the crisis was acute after the 1962 war with China, and the economic scenario turned from bad to worse in subsequent years of 1960s, leading to severe payment crisis and devaluation of Indian rupee. 2. There was shortfall in agriculture production in mid-1960s due to 2 continuous drought spells. The public investments and the manufacturing saw a sharp decline. Apart from these, high inflation was prevailing, and all these had a significant impact on the political scenario when Indira became the Prime Minister in 1966. 3. The political setup started to become antagonistic to the Congress system. In the South, the anti-Hindi agitations often ended up being ugly and violent. Naxalite and leftist movements became more prominent in West Bengal and Kerala. 4. The dominance of Congress as a single party across the country suffered a severe setback in the general elections of 1967, as well as the midterm election of 1969. Moreover, there were internal cracks within the Congress party itself. Changes in the Congress. Thus, Indira's tenure was engulfed with several political and structural complexities. In order to overcome them, Indira had no option but to be assertive and dictatorial. She had to resort to some tough decisions and had also to nullify criticisms against her both within and outside the party. 1. Kamaraj-led Congress syndicate, which supported her succession after Shastri, gradually became hostile and started to challenge her authority. Indira too responded and retorted against the actions of the syndicate. 2. As a result, Indira was expelled from the party in 1969, leading to the split in the Congress into Congress Organization Wing, Congress O, which was dented by the Congress syndicate. 3. Indira then created numerous populist policies towards pleasing the people. The economic scenario too had become somewhat better by the time of emergency. If there were no violent protests against her, and if her election as Member of Parliament was not embarrassing, Indira might not have resorted to imposition of emergency. 221 16 hours 37 minutes and 38 seconds. 222. 4. Indira centralized the decision-making in the Congress party, as all decision of the state and central organization came together under her. 5. Using emergency, she was able to dictate the functioning of the state governments itself. 6. Apart from these, the emergency was used as a tool to improve the economic condition, and progressive economic policies were then implemented. A new 20-point program to improve the economic condition was introduced within days of imposition of emergency. It addressed various issues like bonded labor, agriculture workers, harijans, etc. 7. Because of the imposition of emergency, most of the measures to contain the inflation were implemented, and also other measures to bring stabilization were taken up, such as crackdown on the offenders, black marketers, hoarders, and smugglers. Unaccounted funds were restricted, traders were prevented from hoarding and were made to display the weights and prices properly. As Congress, as country centralization were carried out not just around the country, but it also happened within the Congress party itself. Using the powers under Maintenance of Infernal Security Act 1971 and various other draconian provisions, prominent opposition leaders who were spearheading campaign against Indira were arrested and detained. The press was also censored and strictly restricted. 1. The centralization in the government and party were essential for the survival of Indira and the Congress party, which had suffered a great setback and got its dominance shattered during the elections of 1960s. 2. Indira was firm in her resolve to centralize the powers in the party and the government, even though she suffered from several violent and disruptive protests from the opposition leaders. She had imposed strict restrictions and discipline within the party. 3. No criticism against the government was tolerated, and action was immediately taken against such persons. The Congress party local level committees were all restructured, the center took over the command and control. In the Congress-ruled states, the chief ministers were frequently changed and were replaced with loyal and active supporters of Indira Gandhi. c. Control over cabinet. Indira controlled the whole cabinet, even the senior-most ministers had to fall under her dictate. She implemented the concept called as the kitchen cabinet, whereby small band of very loyal followers of Indira were surrounding her to aid and advise her, hence all the decisions were taken within the kitchen cabinet itself. Indira frequently changed the portfolios of the ministers so that no one can have personal hold over any ministry, and also that it will tame the senior ministers. The Prime Minister's office, created in 1964 during the tenure of Lal Bahadur Shastri, became all-powerful. It bypassed the Home Ministry, the Cabinet Secretariat etc. to make appointments and promotions to high posts and positions. The Prime Minister's office also controlled important departments like the Research and Analysis Wing, the Central Bureau of Investigation and Central Security Forces. 222 16 hours 37 minutes and 38 seconds. Issues and challenges pertaining to the federal structure. 223. 5.5.5 Excess during emergency. 1975-76. The emergency period was fraught with excess and several other illegal measures. The following are some of the drastic and draconian steps taken during the emergency period between 1975-76. 1,10,806 persons were arrested, detained, and tortured without trial under the laws made by the then government. 2. Press was severely repressed and journalists were harassed and detained if found to be against the government. 3. Nearly 25,962 government employees were prematurely retired unjustly using provisions created during the emergency. 4. Temporary shelters and slums of urban poor numbering 1,50,105 in Delhi was bulldozed without providing them any alternative homes. V. The pet project of Sanjay Gandhi, the son of Indira, the compulsory sterilization was indiscriminately carried out. Nearly 81,32,209 sterilizations were carried out in 1976-77 as against 2,64,755 carried out under the Family Planning Program in 1975-76. 5.5.6 The 44th Amendment. The original emergency provisions made easier for Indira to impose such measures. But this was changed by the subsequent Janata government by bringing the 44th Amendment to the Constitution. 1. The provisions given under the Articles 352 and 356 were amended. The most controversial expression of internal disturbance was deleted and replaced with armed rebellion. 2. The recommendation to be made by the President should now be in writing from the Cabinet. Also, as under Article 74, the President can resend such recommendation to the Cabinet for reconsideration but had to act in accordance with the reconsidered advice of the Cabinet. 3. Previously there were no such provisions and thus Indira, without consulting her Cabinet colleagues, proposed and imposed the emergency by recommending it to the President. 4. Previously only a simple majority of both the houses was enough to approve the emergency, but the 44th Amendment made special majority mandatory for approval, that is, it has to be approved by a majority of total members of the House and by a majority of not less than 2/3 of the House present and voting. 5. Before the 44th Amendment there was no provision to approve the emergency provision periodically. An emergency under 352, once approved, continued for any length of time without further approval by the Parliament. 6. The amendment proposes that once approved by both the Houses the emergency continued for 6 months and after that fresh approval is needed from the Parliament for its continuation, and emergency continued for another 6 months unless it is revoked beforehand. 7. By the 38th Amendment, proclamation of emergency was made non-justiciable, but the 44th Amendment changed that, and hence now emergency can be challenged before the courts. 223 16 hours 37 minutes and 38 seconds. 224. 5.5.7 Emergency in present era. The misuse of emergency provisions under Article 356 has now been greatly reduced. The last 2 decades have seen a significant change in the scenario. There are several factors including the rise of coalition governments at the center. The Sarkaria Commission on Center-State Relations suggested that, to quote Article 356, should be used only as a last resort. A warning should be issued to the errant state. The material facts and grounds on which the article is invoked should be made an integral part of the proclamation, and the state legislature should not be dissolved until Parliament has approved it. The Supreme Court also asserted in the S.R. By my judgment that provisions under Article 356, 1, were not immune, and courts can look into them and strike down in case it is mala fide and based on extraneous or irrelevant grounds. The NCRWC in its report recommended that the proclamation of emergency under Article 356, 1, should be based on the report of the governor. Moreover, it suggested that such report should be a speaking document, whereby it should state all relevant facts and grounds, based on which the President can take decision whether to or not to recommend the President's rule in the state. The NCRWC also recommended that the State Assembly should not be prematurely dissolved by the President. First, the emergency has to be placed before and get approved by the Parliament. The Second Commission on Center-State Relations, the Punch High Commission, also recommended that the government should incorporate the guidelines given by the Apex Court in the landmark S.R. By my judgment. 5.6 Coalition Politics and its impact on federal relations. 5.6.1 Introduction. The upper middle class elite played a dominant role in running the country after its independence, and such scenario continued for a long time both in center and the states. This coordination and consensus was possible between center and state because of the one-party dominance of the system, which is ruled in both by the Congress Party. The consensual elite accommodation was possible because of the dominance of the political class by the powerful upper caste political elites, and hence similar view and line of thought was possible. 5.6.2 Initial phase. Times after independence. The scenario started to change after the 1960s. There were some noteworthy changes in the political system, such as rearrangement of the political forces, increasing role of rural elites in the system, rise of a party-colored and complex elite structure. The year 1967 marked the coming of change. The Congress Party lost elections in several prominent states, and first phase of coalition governments with support from regional parties started to arise in the system. This could not be sustained for a long time because of the lack of initial experience, differences, and contradictions among the parties. Indira Gandhi too played a significant role in curtailing the rise of coalition politics by centralizing political and economic powers. But some states did challenge such unilateral and centralizing tendencies of the Union government. They also questioned the veracity of the planning by the center. Though the initial phase of coalition politics was temporary and short-lived, it did indeed create some strong regional movement and state-specific parties in states like Tamil Nadu, Kerala, Orissa, West Bengal, Punjab, etc. 224 16 hours 37 minutes and 38 seconds. Issues and challenges pertaining to the federal structure. 225. Before the beginning of the first phase of coalition politics era, there was spurt of rural elites and regional interest groups in the form of farmers' lobby and agriculture interest groups. The Green Revolution had not only economically enhanced the lives of the agriculturists, but it also had a significant political impact. Their participation in regional and national politics started to rise, and within a short span of time they had become a force to reckon with. This could be seen when Prime Minister Lal Bahadur Shastri tried to formulate an integrated national food policy when the country was under a severe food crisis during the period of 1964-65. He was unsuccessful in doing so. The peasant castes have now been designated as the other backward castes, OBC, and they play a substantial role in the coalition government at the center. 5.6.3 The first phase. The late 1960s. The Congress Party underwent noteworthy changes during the 1960s. It had lost its dominant status after the 1967 elections. By the end of 1960s, the Congress had polarized into two camps and split, one led by Kamaraj called as the Syndicate Congress organization, and another under Indira called as the Congress ruling. Indira Gandhi faced stiff opposition within her own party. She increasingly started to reject principle of consensus and ignore long-standing and established leaders of the party. She dismantled the party's decentralized structure and restricted its functioning without concern for regional and local sentiments. She practically took over the party operations completely. All senior members of the party had to fall in line with her dictates. This had not only changed working of the Congress Party, but it inadvertently also had significant impact on the Indian political federal system. This had led to growth of strong regional sentiment in the states. Strong case was made demanding decentralization by sharing power of sovereignty by the states, especially Punjab and Assam during the second term of Indira Gandhi. Several prominent state-level parties came to power during Indira's second term in early 1980s, such as Assam Gana Parishad, AGP, in Assam, AIADMK in Tamil Nadu, Akali Dal in Punjab, Telugu Desam Party, TDP, in Andhra Pradesh, etc. The state governments of West Bengal and Kerala, led by the United Front of the Left parties, Swatantra Party in Orissa, DMK-led government in Tamil Nadu, had emphasized the need to restrain the authority of centre. In 1980s, Jyotha Basu, N.T. Rama Rao and other opposition chief ministers came together to build a coalition of non-Congress CMs challenging the hegemony of the dominant Congress party and the so-called centralized state. Several conferences and conclaves were held to discuss these issues. 5.6.4 The Janata Interregnum. The Janata Party was an amalgamation of diverse interests. Four opposition parties, namely Bharatiya Alok Dal, the Socialist Party, Jansan, and the Congress, came together. It formed the first coalition government at the centre. It also had support from the local dominant groups. It was expected that there would be greater decentralization of powers, but it was not so. The Janata government too acted like the previous Indira government and dislodged several Congress-led governments in the states using the President's rule under Article 356. 225 16 hours 37 minutes and 38 seconds. 226. 5.6.5 The second phase, late 1980s. The other major period of coalition era. The second phase started in 1989, 2 years before the economic reform program. There was a transition from the dominant party system to a multi-party system and from a majoritarian government to a coalition government. Several unstable governments were formed in quick succession. The coalition politics got boost from the implementation of the Mandal Commission reforms for reservation to OBCs by the VP Singh government and communalization of the polity by the demolition of the Babri Masjid in Ayodhya. BJP emerged as a major force in the centre, while in the states, caste-based, class-based politics of the SCS and OBCs took centre stage. Hence, now the so-called national parties had to align themselves with these state-level forces in order to win the elections, as national parties' powers had waned. 5.6.6 Present era of coalition politics. In successive years, the coalition government had become the norm in the centre with support from the regional state parties. Some of the dominant parties emerged in 1990s, such as Samajwadi Party, SP, Janata Dal, United, JDU, Biju Janata Dal, BJD, Trinamool Congress, Samata Party, Nationalist Congress Party, NCP, etc. 1. It is impossible now to form a government at the centre without the support of these regional parties. 2. This had significant impact on the federal system, as states now played a dominant and decisive role in the coalition governments. 3. Though in 2014 elections BJP had won majority on its own, it still chose to form government with coalition of other parties. 4. Thus, states are now becoming increasingly assertive in center-state federal bargaining as their dominance has increased in the national level politics. 5. The coalition government and its effect is not restricted to national politics alone, it has a significant impact on the neoliberal economic policies of the center. 6. Due to the opposition of the state governments, the center could not carry forward many decisive economic reforms. The states now have a say in directing and modifying the economic policies. 7. The national parties too are now exploiting the coalition politics and thus the system has become more corrupt. 8. During the pre-liberalization phase, there was a vertical competition between the national states, now it has become horizontal, that is, competition is now between the regional state governments themselves. 9. Hence the policies of the center are now diffused across the states and it works on political considerations. Thus, the disintegration of the party system and unstable coalition has adversely affected the governance of the country. 10. There is now increased prominence of the state and regional parties because of the stability of the coalition government at the center. 11. The states hence now enjoy a greater degree of autonomy and they try to establish their own influence at the center, which is adversely impacting the polity. 12. The state-level parties are also in talks to create a united federal front to resist any centralization moves. 226 16 hours 37 minutes and 38 seconds Issues and challenges pertaining to the federal structure 227. 13. Such centralization measures invite condemnation not just from the regional and state parties but also from the national parties themselves in order to preserve the federal spirit and structure. Even the BJP-led government elected in 2014 has given greater emphasis on improving the dynamics of center-state relations, at least on paper. 5.6.7 Conclusion. The emergence of coalition politics thus has significant impact on the center-state relations. The central government's intervention in the affairs of the state has now been reduced significantly. The use of President's rule under Article 356 has also seen decline. The state governments are now not disbanded at the whims and fancies of the center, and also the legislative intervention by using the power of governor to reserve the bill for the assent of the President too has now changed, under Article 200,201. Hence, according to scholars, the participation of the regional state parties in the coalition governments has led to refederalization of Indian democracy. Present era is moving towards increased decentralization, refederalization, and regionalization of politics, and hence the institutions should also keep up with such changes in the political scenario for effective sharing of powers. 5.7 Judiciary as a factor in federal relations. 5.7.1 Introduction. The erstwhile 1935 Government of India Act set in motion the constitutional federal structure of India. It established the legal basis for the present federal system. The Constitution of India, taking cue from the 1935 Act, created a unified and independent judiciary which plays a crucial role in maintaining the center-state federal balance. Unlike other federations where there is a dual judicial system for center and states, Indian Constitution provides for a single and integrated judiciary. Article 124 of the Constitution of India says that there shall be a Supreme Court for India, while Article 131 says that that Supreme Court shall have original jurisdiction in any dispute, a. between the Government of India and one or more states, or b. between the Government of India and any state or states on one side and one or more other states on the other, or c. between two or more states. 5.7.2 Basic Structure and Federalism. The system of federal structure has been upheld by the judiciary a number of times in various judgments. It has treated the Constitution to have established a federation in the country. It has also reiterated that the federal form of government forms the basic structure of the Constitution. This basic structure doctrine is undefined and the court has the power to define and block any changes to the basic structure of the Constitution. In the following judgments of Minerva Mills v. Union of India, 1980, and S.R. Bhamai v. Union of India, 1994, the courts have established parliamentary federal democracy and federalism to be the basic structure of the Constitution of India. Though the courts were the defenders of the concept of federalism and its structure, in the initial 30 years after independence most of the judgments were biased in favor of the center. 227 16 hours 37 minutes and 38 seconds. 228. 5.7.3 Judiciary during emergency. After the impact of national emergency imposed by Indira Gandhi, the courts started to defend the states to some extent. By enacting the 38th Amendment, Indira Gandhi tried to curtail the important aspect of judicial power, the judicial review. The amendment stated that the satisfaction of President based on the report of the Governor is not subject to the judicial review, that is, President's satisfaction cannot be questioned by the courts. Thus, the 38th Amendment enacted in 1975 sought to block out the powers of the court. But this was short-lived as the Janata government formed after the emergency enacted the 44th Amendment in 1978, which restored the power of judicial review back to the courts. After this period, the judiciary started to act on its own to deliver verdicts questioning the authority of the central government over the states. By 1980s, it started to question the rationale of using Article 356, the President's rule, to dislodge state governments by the center. 5.7.4 Center-State Relation and Judiciary 1. The first major judicial intervention came in the issue of center-state relation when the communist-controlled state of Kerala tried to take over the management of the private schools in the state. The Communist Party had formed the government in Kerala in the year 1957. The governor had reserved this education bill for the assent of the president. In order to avoid controversy, this was referred to the Supreme Court under the presidential reference of Article 143 of the Constitution. It was held by majority of 7 judges that the bill violated the fundamental rights guaranteed under Article 30(1), and thus was unconstitutional. State governments complained that they found it difficult to regulate the educational standards in the state after such a verdict. 2. In another landmark case of Babulal Parate v. State of Maharashtra, 1960, which had significant and far-reaching impact on the federal structure, the court held that the power to change, diminish, alter boundary, form new state and change its name given as proviso to Article 3 does not require the consent of the state concerned. It can be altered, changed unilaterally by the will of the center. The proviso to Article 3 states that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless, where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views therein within such period as may be specified in the reference or within such further period as the President may allow, and the period so specified or allowed has expired. The power under Article 3, the reference to the state government, is not the discretionary power of the President, it is the power of the Council of Ministers and under their advice, Article 74. Thus, in the judgment it was held that even if the states opposed, its boundaries, area, name etc. can be changed lawfully by the center. 3. The Supreme Court in the Purushothaman v. State of Kerala held that there was no time limit for the President to give assent to a bill reserved to him by the Governor. It was also held that the bill pending before the Governor or the President does not lapse on dissolution of the Assembly, and on proroguing the bill pending in the legislature, either house, does not lapse. 228 16 hours 37 minutes and 39 seconds. Issues and challenges pertaining to the federal structure. 229. 4. In the case of West Bengal v. Union of India, majority of the 6 judges upheld the Parliament's right to enact law to compulsorily acquire properties in the state by the Union. It was held that this measure would not amount to infringement of the state's sovereignty. Under the Coal-Bearing Areas, Acquisition and Development Act 1957, the authority of the Union government was challenged by the state of West Bengal. It was held by the court that the Parliament's power to legislate in such matters of acquisition is unrestricted and unparalleled. B.P. Sinha J, speaking for himself and 4 other justices, stated that it would be difficult to hold that Parliament, which is competent to destroy a state, is on account of some assumption as to sovereignty of the state, incompetent effectively to acquire by legislation property owned by the state for governmental purposes. In his dissenting judgment over the other 5 judges, Subbarao J held as follows: the impugned act, in so far as it conferred a power on the Union to acquire lands owned by the states, including coal mines and coal-bearing lands in ultra vires. Under the Constitution of India, the political sovereignty is divided between the constitutional entities, that is, the Union, and the states, who are juristic personalities possessing properties and functioning through the instrumentalities created by the Constitution. The Indian Constitution accepts the federal concept and distributes the sovereign powers between the coordinate constitutional entities, namely, the Union and the states. This concept implies that one cannot encroach upon the governmental functions or instrumentalities of the other unless Constitution provides for such interference. The legislative fields allotted to the units cover subjects for legislation, and they do not deal with the relationship between the coordinate units functioning in their allotted fields. This is regulated by other provisions of the Constitution, and there is no provision which enable one unit to take away the property of another except by agreement. The power to acquire the property of a citizen for a public purpose is one of the implied powers of the sovereign. Under the Indian Constitution, that sovereign power is divided between the Union and the states. It is implicit in the power of acquisition by a sovereign that it must relate only to property of the governed, for a sovereign cannot acquire its own property. 5.7.5 Judiciary on Education and Federal Issues. Education as a matter of law has impact on any federal system. Education has its own intrinsic values and universality which cannot be confined within any boundary. Every unit in the Federation play an important role in the field of education. But in the Indian context, the state government, the federal units are in requirement of funds and resources from the center. Thus, the concept of federal autonomy has become more complex. The constitutionally guaranteed place to education has undergone major changes because of the changing federal dynamics. The role and responsibilities of the center have increased because of the resource crunch and regional imbalances between the states. 1. Legislative process involving education had brought numerous federal questions before the Supreme Court. For example, the Gujarat government made Gujarati to be the exclusive medium of instruction in all the universities in the state, when the subject 229 16 hours 37 minutes and 39 seconds. 230. Matter of education was under their control in the state list of the 7th schedule. But the Supreme Court had struck it down as it was beyond the legislative competence of the state. 2. There was another item in the 7th schedule, under the Union List Entry 66, Coordination and Determination of Standards in Institutions of Higher Learning. This item was exclusively under the purview of the center, and courts decided that the state cannot override the powers of the Union, and therefore they had no competence to enact such a legislation. 3. After this, Gujarat University constituted the center set-up committee consisting of members of parliament, called as the Sapro Committee, to suggest steps to take greater responsibility in the field of education. The committee suggested an amendment to the Constitution, to include the university education in the concurrent list of the 7th schedule, so that center can take greater responsibilities in that sector. But this was heavily opposed by the states and hence the proposal could not get materialized into an amendment. 4. During the emergency the situation was different and the subject of education was taken from the state list and was added to the concurrent list. The 42nd Amendment enacted in 1976 made these changes to the Constitution. Hence, today we can see the sector of education being highly centralized and the center assuming greater legislative and policy-making competence in this sector. 5. Therefore, today the role played by the states in the field of education has greatly reduced. And the courts too have retrained the states' power to legislate in many matters concerning education. Especially the states' power does not extend beyond its territory, hence they cannot go beyond their territorial jurisdiction. In the landmark case of Professor Yashpal and ANRV. State of Chhattisgarh and others, the Supreme Court specifically considered the issue of extraterritorial jurisdiction of the states and their power to grant affiliation to any institution outside its jurisdiction. 6. University Grants Commission, UGC, is the central regulatory authority on higher education. It controls, regulates, makes rules and regulations of the universities, including the state-run universities on various matters. Based on the Yashpal case, the UGC had asked all the state governments to bring amendments so as to conform to the Supreme Court observations, also directed the private universities not to operate beyond the territorial jurisdiction of the state. UGC clarified that any university incorporated under the State Act can operate only within the territory of that particular state and in no case go beyond it. 7. The judiciary, based on the concept of single all India citizenship, held that admission to colleges based on the domicile of the state is highly detrimental. There is only one domicile in territory of India, as stated in Article 5 of the Constitution of India. 5.7.6 Judiciary on Emergency Provisions of Constitution. Supreme Court, as mentioned above in the judgment of Minerva Mills v. Union of India, established parliamentary federal democracy as one of the basic structure to the Constitution of India. And since then the courts have tilted towards the centre in support of taking over the 230 16 hours 37 minutes and 39 seconds issues and challenges pertaining to the federal structure. 231. State government under Article 356. The constitutional courts, that is the Supreme and the High Courts, made significant contribution in upholding the autonomy and status of the responsible state governments. 1. In 1977, the ruling Congress, dissolved the Lok Sabha, despite having another year to run as per the 42nd Amendment. The elections were held and the Congress, faced its worst first ever defeat since independence. 2. The coalition, Janata Party, formed the government with overwhelming majority. This is despite the fact that regionally there were a number of states ruled by the Congress Party, including states such as Himachal Pradesh, Haryana, Bihar, Uttar Pradesh, Orissa, Madhya Pradesh, Punjab, Rajasthan, and West Bengal. 3. The Union Home Minister addressed a letter to the chief ministers of these states on April 18, 1977 to earnestly commending for their consideration that they may advise their governor to dissolve their respective state assemblies under Article 174, 2, and seek a new, fresh mandate from the people. 4. Shanti Bhushan, the Minister of Law, Justice, and Company Affairs on April 22, 1977, said that a clear case has been made out for the dissolution of the assemblies in the 9 Congress-ruled states and holding of fresh elections, since a serious doubt has been cast on their enjoying the people's confidence, their party having been rejected in the recent Lok Sabha elections. 5. The aggrieved state governments knocked the doors of the Supreme Court seeking directions against imposition of President's rule under Article 356. The Supreme Court refused to intervene and question the dissolution of the governments in the Congress-ruled states. 6. In fact, it seemed that the court were supportive of such moves by the centre. The central government of Janata Party relied on the non-justiciable provision under Article 356, which was made so in the 42nd Amendment by the Indira government. It was later made justiciable by the Janata Party in the 44th Amendment. 7. The judgment of Supreme Court in the case of State of Rajasthan and Ors v. Union of India made a serious dent in the federal consciousness of the nation. It went against the autonomous functioning of the state and legitimized the intervention of the centre into the affairs of the state. This judgment thus had far-reaching implications which changed the view of federal setup in the country. But subsequent to this judgment, the courts started to take lenient view and supported the legitimate rights of the states. 5.7.7 Judiciary and Article 356 in S.R.Bhamai v. Union of India, the Supreme Court made a significant shift and upheld the federal rights of the state, and questioned the indiscriminate application of Article 356. It stated that Article 356 is not immune from the purview of the judicial review and the courts can strike it down when found to be mala fide or based on extraneous grounds. In the S.R. Bhamai case, the Apex Court laid down the following conditions: I. The power by Article 356 upon the President is a conditional power. It is not an absolute power. The existence of material which may comprise of or include the report, s. of the Governor is a 231 16 hours 37 minutes and 39 seconds. 232. Precondition. The satisfaction must be formed on relevant material. The recommendations of the Sarkaria Commission with respect to the exercise of power under Article 356 do merit serious consideration at the hands of all concerned. 2. The proclamation under Article 356, 1, is not immune from judicial review. The Supreme Court or the High Court can strike down the proclamation if it is found to be mala fide or based on wholly irrelevant or extraneous grounds. 3. Burden lies on the Government of India to prove that relevant material exists, to justify the issue of proclamation. When called upon, the Union of India has to produce material on the basis of which action was taken. It cannot refuse to do so, if it seeks to defend the action. The court will not go into the correctness of the material or its adequacy. Its inquiry is limited to see whether the material was relevant to the action. 4. If the court strikes down the proclamation, it has the power to restore the dismissed government to office and revive and reactivate the Legislative Assembly wherever it may have been dissolved or kept under suspension. In such a case, the court has the power to declare that act done, orders passed, and laws made during the period of proclamation was in FRCE shall remain unaffected and be treated as valid. V. The Constitution of India has created a federation but with a bias in favour of the centre. Within the sphere allotted to the states, they are supreme. 6. Any state government which pursues unsecular policies or unsecular course of actions acts contrary to the constitutional mandate and renders itself amenable to action under Article 356. 5.7.8 Judiciary on role of governor. Even before the judgment in the Minerva case, the Supreme Court in the Raghukul Tilak case in 1979 observed that the appointment of the governor and his tenure at the pleasure of the President does not make the Government of India an employer of the governor. The governor is the head of the state and holds a high constitutional office which carries with it important constitutional functions and duties, and he cannot, therefore, even by stretching the language to a breaking point, be regarded as an employer or servant of the Government of India. The Supreme Court further added, it is impossible to hold that the governor is under the control of the Government of India. He is not amenable to the directions of the Government of India, nor is he accountable to them from the manner in which he carries out his functions and duties. His is an independent constitutional office which is not subject to the control of the Government of India. The Constitutional Bench of the Supreme Court in the Bihar Assembly dissolution case, 2006, held that immunity granted to the governor under Article 356 does not stop the court from scrutinizing the proclamation made for mala fide or being ultra vires. Thus, the court's mandate put a full stop to end the unhealthy trend of unwarranted president's rule in the states. Further, the Punch High Commission on Center-State Relations recommended the government to adopt the directions issued in S.R. My case with respect to the use of Article 356. 232 16 hours 37 minutes and 39 seconds issues and challenges pertaining to the federal structure 233. 5.7.9 Judiciary on minority status. The intervention of the Supreme Court on the minority status has also affected the center-state relations. In the TMA judgment and other similar pronouncements, the courts have complicated the question of right of minorities and their relevance within the federal structure. Till then the court had asked to consider only the minorities based on religion state-wise, but after the TMA case, both religious and linguistic minorities were have to be considered state-wise. This did have impact in identifying and notifying minorities at the state level. May 7, 10 conclusion. It can be seen that initially the judiciary kept itself restrained and interpreted the provisions of the law literally. Moreover, due to the conditions prevailing at the time immediately after independence, it is logical to derive that the courts were tilted in favor of the Union to carry forward the spirit of nation building. And decades after independence it was found that the Union was not functioning as efficiently and it is better to leave certain powers with the states themselves. Moreover, it was seen that Union was encroaching the powers given to the states under the Constitution, and courts carried forward a liberal interpretation of the constitutional provisions. In numerous judgments we can see this tilt towards the right of people over the national unity and integration as put forth by the Union. In the present era there is a phenomenon called as the judicial activism, which makes the courts intervene into a wide range of issues. At present the Supreme Court and other courts have become the champion of the rights of the people rather than government. 5.8 National security and its impact on federal structure. As per the Constitution of India, law and order is the responsibility of the state. But in reality, the central government intervenes in maintaining the law and order in the state. Moreover, such problems are not limited to the boundary of such state, it goes beyond it. There are a number of internal and external causes for such issues. Thus, in these conditions the question of national security is becoming a major concern for maintaining the balance of federal dynamics between the center and the states. Presently the traditional and autonomous areas of functioning by the states are being eroded by emerging national security laws and various other security-related aspects. It is clear that national security laws are being increasingly centralized. Also, it is naturally inclined to think that national security is predominantly, if not absolutely, the responsibility of the center in a federation. Major national security resources and institutions are increasingly aligned towards the center. National security intelligence activities are also penetrating into the jurisdiction of the local federal units, which however are resisting such unilateral moves by the center. 5.8.1 Internal and external dimensions to national security. There is both an internal and external dimensions to national security scenario in our country. Internally, movements such as the Sons of Soil movement, Naxalism, and other communal and sectarian violence are posing grave threat to the unity of the nation. As per the reports of the government, 203 of 600 districts in 18 states in India is under the influence of left-wing radical. 233 16 hours 37 minutes and 39 seconds. 234 Forces. In the annual report of the Union Home Ministry 2011-12, says there were nearly 1,755 incidents of left-wing extremist violence extending to almost 9 states. And there is also a resurgence of such extremism in the southern states. Terrorism is also a major issue having both internal and external dimensions. The government has been employing several law enforcement measures together with various national security laws, such as National Security Act (NSA), Maintenance of Internal Security Act (MISA), Terrorist and Disruptive Activities, Prevention, Act (ADA), Armed Forces Special Powers Act (AFSPA), etc. Most of these laws have direct impact on the law and order problems in the state and thus has ramifications in the center-state relations. The state government has very little say in execution and implementation of these acts, hence the state cannot challenge any violations or misuse made by the forces under them. For example, acts of omission or commission under the AFSPA cannot be challenged in a civilian court, unless and otherwise it has had prior approval by the center. The AFSPA is thus a draconian act, which permits the armed forces to kill with impunity without having to answer to the courts of law. AFSPA has a long checkered history. It has been used even before independence and it is now continued to be used in some of the northeastern states and in Jammu and Kashmir. This act has been vehemently opposed in these states and there is a grassroots movement of people against it. It has been termed as discriminatory and is having a major effect on the relation between center and the states. Since independence, a number of security forces has been created by the center. There is a huge Central Police and Armed Forces, Intelligence Bureau, Central Bureau of Investigation, National Investigation Agency and a host of other forensic and training institutions to train, sustain, gather intelligence, to investigate special crimes and to maintain law and order in the states. The following Central Police and Armed Forces play a significant role in maintaining law and order in the states: Central Reserve Police Force, CRPF, Rapid Action Force, RAF, Central Industrial Security Force, CISF, Indo-Tibetan Border Police, ITBP, Border Security Force, BSF, Assam Rifles, National Security Guard, NSG, Sashastra Seema BAL, SSB, etc. Most of these forces operate at the state level, but their ultimate control lies with the center. Though the federal concept of the Constitution envisages the law and order to be maintained by the state government, stationing of such huge armed police force who function under the direction of the center has unduly influenced the functioning of the states. This is the most unusual feature of the Indian Federation, where a separate, parallel police force is being maintained by the center. The First Administrative Reform Commission has made the following observation. The Central Reserve Police and the Border Security Force are armed forces raised by the Union to meet the needs of the security of the country, both external and internal. In the circumstances, the use of the armed forces of the Union in aid of the civil power of a state is perfectly constitutional. It is also clear that such aid can be provided at the request of the state government or suo motu. The question whether such aid is needed must obviously be a matter of judgment by the center. It is understood by eminent scholars that such unilateral deployment of the central forces in the states based on its own judgment violates the federal autonomy guaranteed by the Constitution. A new entry to a empowering Union to deploy armed forces in the state in aid of civil power was added to the Union list of the Constitution by the 42nd Amendment. Apart from Union list, it also amended the state list entry 2, where police power of the state is now subject to entry 2A of the Union list. The states presently have come to have accepted the fact that some 234 16 hours 37 minutes and 39 seconds issues and challenges pertaining to the federal structure 235. Circumstances do warrant such deployment of the central forces, and they do need their help in maintaining the law and order situation in such cases. Moreover, the center and state have now devised a mechanism to effectively deploy the forces when the need arises. The states are in short of revenue, therefore maintaining a huge armed police forces has become a burden. Lack of equipment and training also adversely affect the maintenance of law and order situation in the states. 5.8.2 Anti-terror laws in India. A number of anti-terror laws has been enacted by the centre over the years in order to cope up with the increasing menace of terrorism. But these laws have been opposed by most of the state governments. The Terrorist and Disruptive Activities Prevention Act, THIRD, 1985 was enacted to manage the rising anti-national activities in the states, especially in Assam and Punjab. Initially it was introduced as a temporary measure to curtail the violence and disruptions caused by the secessionist Khalistani movement. But the Union government continued the use of the act in other states also. THIRD was seen as continued interference of the Union into the affairs of the state. It also enormously increased the power of the state police forces, which is controlled by the state government. As per the provisions of the THIRD Act, the central government is the final authority to decide how the act is to be implemented. 5.8.3 National Investigation Agency. The central government had set up the National Investigation Agency created by passing the National Investigation Agency Act 2009, after the horrifying Mumbai terror attacks, in order to take up cases having international and interstate implications with serious impact on the national security. The government had also thought of setting up the National Counter-Terrorism Centre as recommended under the Punch High Commission on Centre and State Relations, but this has been resisted by the state governments as this NCTC encroached on the law and order, which is essentially a state subject. States have raised their voices against setting up of such commission, as such unilateral on the pretext of national security erodes the power of state over maintaining the law and order in the state, which essentially comes under the ambit of duty of the state governments. Moreover, such action by the centre lacks accountability. The centre has taken up to set this up under the Article 355 of the Constitution, which entails the centre to protect the states against external aggression and internal disturbance. It also ensures that the states function as per the constitutional provisions. But this justification of using Article 355 does not hold water, as it can only be used during the emergency and not for everyday law and order functioning of the state governments. National security is indeed the concern of the Union government, but it cannot act unilaterally. Any measure taken by the centre has impact and influence on the law and order of the state. Such measures also involve stationing of the central security forces within the territory of the state. These measures cause friction between the centre and the state, and this tension cannot be simply overlooked. 235 16 hours 37 minutes and 39 seconds. 236. 5.9 Reinvention of self-governing institutions and decentralization. 5.9.1 Introduction. The concept of local self-government has a very long history in India. Any system of governance within the country would be incomplete without the mention of the independent small village republics. During the Vedic period, the Savas and Samhitas played a key role in the administration of the village republic. Even under the Gupta rulers, the villages were important administrative units and panchayats were important local self-governing institutions. Charles Metcalfe, in his famous Minute of 1830, has best described the autonomous village as follows. The village communities are little republics, having nearly everything they can want within themselves. They seem to last where nothing else lasts. Dynasty after dynasty tumbles down, revolution succeeds revolution, but the village community remains the same. This union of the village communities, each one forming a separate little state in itself, has contributed more than any other cause to the preservation of the peoples of India, and the enjoyment of freedom and independence. 5.9.2 British era. The British started to develop the modern local self-governing institutions in India towards the end of 17th century, in the form urban municipal bodies. Likewise, municipal corporations were set up in the Presidency town of Madras in 1688 and in Bombay and Calcutta in 1726. 1. Lord Mayo turned bodies into elected representative bodies in the 1870 resolution. 2. Lord Ripon carried forward this to the panchayat and rural localities. He created district board at district level and rural board at taluk/tehsil level under the resolution of 1882. 3. However, it was the passing of the Bengal Local Self-Government Act 1885 that led to the spreading of modern self-governing institutions beyond the cities to the rural areas. 4. It led to establishment of district boards across the province of Bengal. To quote the Second Administrative Reforms Commission, within a span of 5 years, a large number of district boards came into existence in other parts of the country, notably Bihar, Assam, and Northwest Province. The Minto-Morley Reforms, 1909 and the Montague-Chelmsford Reforms, 1919, when local self-government became a transferred subject, widened the participation of the people in the governing process and, by 1924-25, district boards had a preponderance of elected representatives and a non-official chairman. 5. The origin of the statutory panchayats is attributed to the 1907 Royal Commission on Decentralization, which in its report had suggested setting up of village panchayats for cutting down the financial burden on the provincial government and to extend the concept of local self-government to the villages. And based on this recommendation, various provincial governments enacted the Village Panchayats Act to extend the governance to the villages. 236 16 hours 37 minutes and 39 seconds Issues and challenges pertaining to the federal structure 237. 5.9.3 Panchayats post-independence debate. Though this system of village panchayat has long historic tradition, it is disappointing to find that the Constitution of India made no representation for the self-governing bodies. The constitution makers sought to project India as a giant nation, forgetting the consequences of being a giant. 1. While several attempts were made before and after independence to create and develop local self-governing political institutions, the same could not take a formal constitutional shape until the early 1990s. 2. Even before the independence, Gandhi was in favor of decentralization and handing over political powers to the villages and districts. 3. Gandhiji wanted lesser power to be wielded by the centre, and villages be granted autonomous power to govern themselves through sarpanchs and punches, village chief, and councillors. Though this idea of Gandhiji's self-governing village republics came up for debate in the Constituent Assembly, but they did not find a mention in the final draft of the Constitution. 4. Though this concept of village-level self-governing institutions found support among few of the members of the Constituent Assembly, the drafting committee of the Constitution deliberately avoided making any provision for local self-governing institutions. 5.9.4 Ambedkar's view on panchayats. Dr. Ambedkar, the chairman of the drafting committee, did not find any merit in such system of governance. While moving the draft constitution for approval in the Constituent Assembly on 4 November 1948, Dr. Ambedkar spoke at length against the concept of village self-governing institutions as follows: "The love of the intellectual Indians for the village community is of course infinite if not pathetic. It is largely due to the fulsome praise bestowed upon it by Metcalfe, who described them as little republics having nearly everything that they want within themselves, and almost independent of any foreign relations. The existence of these village communities, each one forming a separate little state in itself, has, according to Metcalfe, contributed more than any other cause to the preservation of the people of India, through all the revolutions and changes which they have suffered, and is in a high degree conducive to their happiness and to the enjoyment of a great portion of the freedom and independence. No doubt the village communities do not care to consider what little part they have played in the affairs and the destiny of the country, and why. Their part in the destiny of the country has been well described by Metcalfe himself, who says, 'Dynasty after dynasty tumbles down. Revolution succeeds turn, but the village communities remain the same. In times of trouble they arm and fortify themselves. A hostile army passes through the country. The village communities college their little cattle within their walls and let the army go unprovoked. Such is the part the village communities have played in the history of their country. Knowing this, what pride can one feel in them? That they have survived through all vicissitudes may be a fact. But mere survival has no value. The question is on what plane they have survived. Surely on a low, on a selfish level. I hold that these village republics have been the ruination of India. I am therefore surprised that those who condemn provincialism and communalism should come forward as champions of the village. What is the village but a sink of localism, a den of ignorance, narrow-mindedness, and communalism? I am glad that the draft constitution has disregarded the village and adopted the individual as its limit. One Ambedkar was fundamentally opposed to the idea of independent village republics because he thought that it would be detrimental to the interests of the minorities and particularly to the interests of the untouchables, the Dalit community. 237 16 hours 37 minutes and 39 seconds. 238. 2 Ambedkar argued that villages were the cause of ruination of the country. Empowering such villages will perpetuate the dominance of the upper castes, who would continue to dominate the downtrodden people. Autonomy to the village panchayats was also against his centralization project. 3 Ambedkar even wanted limited powers to be given to the provincial governments as he believed that such localized governments would not sincerely protect and safeguard the rights and interests of the minorities and the Dalit communities. 5.9.5 Countering Ambedkar's views. This idea of Ambedkar drew comments from various quarters of the Constituent Assembly. 1 K. Hanumanthia argued that in such a vast country, it is impossible for any human or government to effectively control all the administration. Even as late as 1949, Hanumanthia was arguing for the effective decentralization. He also reminded the Constituent Assembly that this decentralization was the principle based on which Gandhi had wanted the constitution to be constructed. 2. In order to defuse the situation created by Ambedkar's comment, and to air their resentment against the omission of the village panchayats, some of the members of the Constituent Assembly, including Alladai Krishnaswamy IR, had to clarify that, although the draft constitution had not provided for establishment of such panchayats, the provinces had power to create such autonomous units in their states, providing them with administrative powers. 3. Subsequently, consensus emerged within the Constituent Assembly, thereby the decentralization of power and provision of village panchayat was made into the constitution in the form of directive principles of state policy. 4. Thus, panchayats only found a peripheral place in the original constitution, among the Part 4, the directive principle of state policy, and Article 40 provides that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as self-governing institutions. 5. The Article 40 does not provide steps of constituting the village panchayat. Under it, the creation of panchayat as statutory institutions was left with the state legislatures. Under the 7th Schedule Entry 5 List 2, the State List, empowers the state legislatures to make laws with respect to local self-government or village administration. 5.9.6 Local Governance Community Development Programs. Only 2 tiers of government, center and state, was recognized by the original constitution post-independence. However, the idea of local self-government was raised from time to time. 1. In compliance with the directive principle to establish villages as independent self-governing institutions, the central government launched ambitious community development program in 1952 with the intention to bring socio-economic transformation of village life through people's own democratic and cooperative organizations, with the government providing technical services, supply and credit to the village bodies. 2. Participation of whole community was the key element of this experiment, and under this, 100 to 150 villages formed a community development bloc, to strengthen the foundation of the grassroots democracy. 238 16 hours 37 minutes and 39 seconds Issues and challenges pertaining to the federal structure 239. 3. Scientific and technical knowledge of agriculture, animal husbandry, and rural craft sectors was transferred to the people by establishment of National Extension Service in 1953. 4. The second five-year plan in 1956 recommended that the village panchayats should be linked with other organizations at the higher level, and in stages the democratic body should take over all the functions of general administration and development of the district, excluding the functions such as law and order, administration of justice, and a few functions of revenue administration. In view of this, the Government of India set up a committee under the chairmanship of Balwantram Mehta in 1957. 5.9.7 Balwantram Mehta Committee Recommendations. The Balwantram Mehta Committee suggested that for effective implementation of the development programs, there should be administrative decentralization, and the local bodies should control the implementation of development programs and also other administrative functions. 1. It recommended for further extension of the Community Development Program and National Extension Service throughout the country, in all developmental blocks. It should be placed under an elected Panchayat Samiti for effective functioning. 2. The Balwantram Mehta report recommended popular participation in the decision-making process at the local level. For that to happen, there has to be democratic decentralization of power to the sub-district level. 3. Based on this report, a three-tier Panchayati Raj system was introduced in various states consisting of Gram Village Panchayats at the base, Mandal or Taluka Panchayat in the middle, and Zilla Panchayat at the district level. 4. The Panchayati Raj was also promoted by the Union government as a matter of policy from 1957 to 1963, where the state governments were pressurized to adopt democratic decentralization and to directly involve the people at the village level in the planning process. Based on this, states of Andhra Pradesh, Rajasthan, Maharashtra, and Gujarat took legislative and administrative initiatives to set up the Panchayati Raj institutions. 5.9.8 Santhanam Committee Recommendations. Santhanam Committee was appointed in 1963 to solely look into the issue of the finances of the Panchayati Raj institutions, pre. It gave the following recommendations. I. The panchayats should have special powers to levy special tax on land revenues, home tax, etc. 2. A Panchayat Raj Finance Corporation should be set up which would look into the financial resources of PRI at all three levels, provide loans and financial assistance to these grassroots level government, and also provide support for non-financial support of the villages. 5.9.9 Ashok Mehta Committee Recommendations. The momentum started to decrease, and by mid-1960s, the support for Panchayati Raj system started declining as the most of the political leadership in the states were reluctant to devolve 239 16 hours 37 minutes and 39 seconds. 240. Powers to the district level. They feared that if powers were devolved, these local institutions would become alternative sources of political influence and patronage, which would threaten the leadership at the top, and degrade their ability to influence and control at the grassroots level. Hence by 1970s, only the skeleton existed, the panchayats were there but without any powers or functions. And simultaneously during this period, the centralization carried out by Indira Gandhi made the panchayats completely redundant. After the controversial tenure of Indira Gandhi, the subsequent Janata government in 1977 set up a new committee on Panchayati Raj, under the chairmanship of Ashok Mehta. 1. It assessed the problems faced by the Panchayat system and recommended establishment of a two-tier system, one at Mandal and other at district level. 2. The committee chose the district to be the first point of decentralization below the state level. 3. Under its recommendation, the Zilla Parishad, the district boards were to be given full control over all the development activities to be carried out. 4. The law and order would remain under the control of the existing administrative apparatus. 5. The most important aspect of this committee was that it introduced taxation powers by the local bodies. 6. While submitting its report in 1978, the committee was of opinion that the rhetoric over panchayat empowerment was not of much use unless it received a constitutional standing. May 9, 10 other committees won. In 1985, the G.V.K. Rao Committee recommended that PRI at district level and below be assigned responsibility to implement, monitor, and plan the rural development programs, and the Block Development Office should be the spinal cord of the rural development. 2. In line with the Ashok Mehta Committee recommendation, the L.M. Singhvi Committee in 1986 recommended that the local self-government be constitutionally recognized, protected and preserved by including a new chapter in the Constitution. 3. As per the report of the Second Administrative Reform Commission, by end of 1982, except Meghalaya, Nagaland, Mizoram and Union Territory of Lakshadweep, all other states and UTs had enacted legislation for the creation of PRI. In 14 states/UTs there was a three-tier system, in 4 states/UTs it was a two-tier structure, and in 9 states/UTs only one tier functioned. 4 strong arguments were continued to be made for the reorganization of the Indian Federation with smaller political units. The requirement for this reorganization was for greater political participation and effective democratic governance at all levels of governance. 5 demands were also made to set up Second State Reorganization Commission. It was argued that there was much room for the states to devolve their power to the lower, district, panchayati level. It was said that failure of panchayati Raj institutions can be attributed to the ineffective devolution of the powers. 240 16 hours 37 minutes and 39 seconds Issues and challenges pertaining to the federal structure 241. 6. The Sarkaria Commission, set up in 1988, in its report recommended that the local self-governing bodies have to be significantly strengthened both functionally and financially. It also recommended that a parliamentary law be enacted so that it is uniformly applicable throughout the country. May 9, 11 constitutional amendments. The landmark move in the process of decentralized governance came in 1989, when 64th and 65th constitutional amendment bills were introduced in the parliament by Rajiv Gandhi, making it mandatory for all states to set up elected panchayats and urban local bodies, providing more powers and functions to the local bodies, even authorizing the panchayats to levy and collect taxes/tolls and fees, etc. These bills were finally passed in 1993 under the stewardship of Prime Minister Narasimha Rao as 73rd and 74th Constitutional Amendment, resulting in insertion of new parts Part 9 and IXA, and new Articles 243 to 243 ZG. 1. The 73rd and the 74th Amendments created the panchayats and the urban local bodies. 2. They brought back the three-tier system of governance back, which was initially proposed by the Balwantram Mehta Committee. May 9, 12 The 73rd Amendment. The important aspect of the 73rd Amendment is that it brought in constitutional legitimacy to the Panchayat Raj institutions. A. It has provided panchayats at village, intermediate, and district levels, with an exception that states having population less than 20 lakh need not constitute the panchayat at the intermediate level. B. A new Part 9 has been inserted to the Constitution for legitimizing the panchayats. C. In pursuit of this, the states have to devolve administrative and financial responsibilities to the panchayats in respect to the 29 matters listed in the new inserted 11th schedule. May 9, 13 The 74th Amendment. The urban local bodies too received constitutional recognition, as the Parliament enacted the 74th Amendment in 1992, known as the Nagarpalika Act, which received the assent of the President in April 1993 and came into force in June 1993. 1. This new amendment has added a new Part IXA to the Constitution. It mentions the subject matters pertaining to the municipalities. 2. The Act has provided for 3 kinds of municipal bodies: municipal corporations for larger urban areas, municipal councils for smaller urban areas, and Nagar Panchayats for rural urban transitional areas. 3. These amendments have special provision with respect to participation of SCS/STS and especially women in the panchayats and urban local bodies. Another important aspect is that it has given power to the local bodies to impose tax. 241 16 hours 37 minutes and 39 seconds. 242. 4. Apart from the 3-tier structure, some new provisions have been made for the establishment of district and metropolitan committees under Articles 243 ZD and 243 ZE. 5. The job of the District Planning Committee is to consolidate the plans prepared by the panchayats and the urban local bodies in the district and prepare a draft plan for the district as a whole, while the Metropolitan Planning Committee is to prepare a draft development plan for the metropolitan area as a whole. 6. The composition of these committees is left to the state legislature. 7. Though the panchayats and the urban local bodies are directly elected by the people, they are subjected to the political control of the state through its legislative assembly. 8. Most of the panchayats continue to be treated as an agency of the state for implementation of its schemes, though it is accepted that the essential services for providing drinking water, rural sanitation, preventive health, and primary education come under the panchayat's legitimate core functions. May 9, 14. Devolution of finance. In order to effectively devolve finance to the 3rd tier, the Constitution has given additional task to Finance Commission, which is now burdened with to recommend measures to supplement resources of the 3rd tier, including grants, which are supplementary to the devolutions by the State Finance Commission. Although the 11th and 12th Finance Commission has provided for united grants to these institutions, there is a doubt regarding their financial capacity. Hence, we can see that the pre-exist as overstructured but under-empowered organizations. They boast to have constitutional status, but suffer from lack of effective devolution of powers, functions, and finance from the state governments. May 9, 15. Other recommendations. The National Commission for Review the Working of the Constitution, in order to address the gap between state governments and the local self-governing institutions, had recommended that a provision be made for creation of State Panchayat Council, with Chief Minister at its head, in line of Interstate Council, created under the provision made under Article 263 of the Constitution. It further recommended that the Leader of Opposition be made the de facto Vice-Chairman of the Council, to provide for a consensus-based approach for the development of panchayats as fully democratic, effective, and responsible institutions. May 9, 16. Extension of panchayats to scheduled areas. The 73rd Amendment excluded the Adivasi and the scheduled areas from its purview. But it was always open for the Parliament to extend to same to these areas, as per the provisions of the Article 243 4. Boria Committee was constituted in 1994 to formulate law for extending the provisions of the Part 9 to the scheduled areas and to suggest modifications in other acts relevant to the 5th Schedule in order to further strengthen the local self-governing areas. The recommendation of this committee culminated in the enactment of the Panchayats, Extension to the Scheduled Areas, PESA, Act 1996, which came into effect on December 24, 1996. The PESA Act has led to the extension of the Panchayats Act to the tribal areas of Andhra. 242 16 hours 37 minutes and 39 seconds. Issues and challenges pertaining to the federal structure. 243. Pradesh, Orissa, Gujarat, Chhattisgarh, Himachal Pradesh, Jharkhand, Maharashtra, Madhya Pradesh, and Rajasthan. This enables the tribal society to effectively take control of their traditional rights over natural resources. May 9, 17 conclusion. It has been proposed for some time now that all the functions of the district be devolved to the district government, including the police, land administration, and other economic and social functions associated with the district. The Ashok Mehta Committee report in 1978 had considered district to be an important governing unit. In carrying forward its recommendation, the Second Administrative Reform (ARC) Commission in its report on the local governance has also recommended setting up of the district government, with each district constituting a district council having elected representatives both from the panchayats and the urban local bodies. The ARC also recommended that the post of district collector should be eventually abolished. In the interim period, the collector will play a dual role as head of the administration and the secretary to the DG. The observation of the ARC is as follows. There must be a single elected district council with representatives from all rural and urban areas, that will function as a true local government for the entire district. In such a scheme, the district council will be responsible for all the local functions, including those listed for them in the 11th and 12th schedules. The DPC in its present form will be redundant, once a district council comes into existence as envisaged by the Commission. Planning for the whole district, urban and rural, will become an integral part of the district council's responsibility. The role of district collector/DM also needs to be reviewed in the context of the district council and the district government. The institution of district collector must remain in the current form for some more time. Eventually, the district council should have its own chief officer. Meanwhile, as an interim mechanism, there is a merit in utilizing the strength of the collector's institution to empower local governments. The Commission is of the considered view that a golden mean between these two positions is desirable, and the district government must be empowered while fully utilizing the institutional strength of the district collector. The Commission believes that these two objectives can be realized by making the district collector function as the chief officer of the district council. In such a case, the collector's appointment should be in consultation with the district council. The district collector cum the chief officer would have dual responsibility and would be fully accountable to the elected district government on all local matters, and to the state government on all regulatory matters not delegated to the district government. 5.10 Federal Fiscal Relations. 5.10.1 Introduction. Center-state fiscal relation forms important aspect in any federation. Imbalances and disparities exist between the constituent states, and this can only be removed by redistribution and reallocation of the economic and fiscal resources. Imbalance exists not just between different states but also between different tiers of government in a federation, and thus the fiscal federalism helps in distribution of goods and resources to the subnational governments so that they can be allocated as per the public consumption, entailing responsibility between different levels of government. Thus, redistribution and reallocation of financial resources become important aspect. 243 16 hours 37 minutes and 39 seconds. 244. Of fiscal federalism. Various ways and means such as revenue sharing, specific purpose grants, general purpose grants, conditional grants, matching grants, central policies/rules and centrally administered prices, local incidence of central expenditures, such as central government investment, etc., help in redistribution of the resources in a federal state. 5.10.2 Role of the center. As far as India is concerned, the central government play an important role. It retains the control over the economy and frames most of the fiscal rules and regulations. The center has more resources than it needs, while the subnational state governments have less than needed. There is always fiscal imbalance between center and the states, and also more between the states themselves. In the Indian federal system, the states' governments have very little choice in revenue raising and spending. In the fiscal federalism, the intergovernmental fiscal transfers constitute an important policy mechanism. It helps in removing the inequalities between various federating states and also to remove the fiscal mismatch between the revenue sources and expenditure needs of the constituent states. But this sharing of the fiscal resources has always been controversial in the federal system. The method of fiscal transfer to the states has always been politicized, especially the controversial use of planning commission in distribution of fiscal resources. The various centrally sponsored schemes and uneven distribution of centrally controlled public resources has made the matters more politicized and contentious. 5.10.3 The Finance Commission. The framers of the Constitution had anticipated the mismatch and the problems that could arise due to the presence of gap between the fiscal capacities and the needs of the states. And thus they had constituted an impartial transfer the revenue to the states from the center through the Finance Commission. Article 280. 1. The Finance Commission is an independent constitutional body. It is constituted every 5 years and submits its report to the President. Its basic terms of functioning are set under Article 280 of the Constitution, which are as follows: I. Distribution between the Union and the states of the net proceeds of the taxes which are to be, or may be, divided between them under 1 Part 12 of the Constitution, and the allocation between the states of the respective shares of such proceeds. 2. The principles which should govern the grants in aid of the revenues of the states out of the Consolidated Fund of India, and the sums to be paid to the states which are in need of assistance by way of grants in aid of their revenues under Article 275 of Constitution for purposes other than those specified in the provisions to Clause I of that article. 3. The measures needed to augment the consolidated fund of the state to supplement the resources of the panchayats and municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. 2. This transfer of fiscal resources from center to state through the Finance Commission is called as the statutory transfer. 3. It has been fixed based on a formula and cannot be deviated from it. 244 16 hours 37 minutes and 39 seconds. Issues and challenges pertaining to the federal structure. 245. 4. Apart from this, the Finance Commission has also to recommend the distribution of grant and aid to the states under the Article 275. The Article 275 specifies special grant given to the states based on its backwardness or whether it is a hill state, and thus some states were categorized and given special status. 5. Through Article 275 the Finance Commission gives specific grants to the individual states based on the problems faced by them, and thus the Commission meets the requirement of the special category state through these grants. The special category states receive relatively favorable treatment in case of federal fiscal transfer. 11 states were categorized as special category state by the Planning Commission. The share of such grants under Article 275 in the total Finance Commission's transfers has been between 15%–18%. 6. The 12th Finance Commission brought in new provisions based on maintenance of forest to provide grant in aid to the states. 7. In this regard, the state of Uttarakhand submitted a memorandum before the 13th Finance Commission to review and properly evaluate its ecosystem services, S, and asked for special compensatory grant based on S to the state. 8. The Punch High Commission of Center-State Relation also gave recommendation that an expert body has to be constituted with representatives from center and states on a periodic basis to determine the amount of compensation to be granted to the forest-rich states. 5.10.4 The Planning Commission. The role of Finance Commission has been undermined and reduced by providing grants under Article 282 by the non-statutory, Permanent Planning Commission and by giving loans to the states by the center under Article 293 of the Constitution. Right from its inception the Planning Commission, which was not envisaged initially by the Constitution makers, started to play a dominant role in economic policies and in distribution of central resources to the states. 1. The Planning Commission had distributed larger share of the central resources compared to the statutory transfers made by the Finance Commission up until the annual plans of 1966-69. 2. This influence of non-statutory Planning Commission created a dilemma because before the fourth plan period there was no objective criteria used by them to transfer the central funds. Apart from these, other discretionary transfers such as the budgetary transfers and the transfers by the ministries were also quite high during this period. 3. The inherent nature and functions of the Planning Commission were not federal but unitary in nature. And in the name of development the successive planning commissions too tended to expand and extend the authority of the Union government with total disregard to the spirit of federalism emulated in the Constitution. 5.10.5 Planning Commission and Finance Commission. A comparison. Till recently, the Planning Commission has been controlling major share of the transfers to the states. Though the transfers were made based on the Goodgill formula, revised from time to time, 245 16 hours 37 minutes and 39 seconds. 246. The inherent objective of the Planning Commission and the Finance Commission were entirely different. 1. The statutory transfers made by the Finance Commission were largely fixed and predetermined based on distribution of net proceeds from the central taxes. 2. In 1960s, a clear-cut distinction was made between the roles and jurisdiction of Finance Commission and the Planning Commission with regard to transfer of central funds to the states. 3. All planned expenditure came under the purview of the Planning Commission, while the non-plan expenditure was disbursed by the Finance Commission to the states. 4. Apart from these, a major chunk of the federal fiscal transfers is through the ministries under their welfare schemes and programs. The transfers are made to the states directly from the center. 5. After 1984, the federal fiscal transfer made by the Finance Commission year-on-year basis to the states were between 35% and 40%. The remaining share of the transfers were carried out either under the plan or discretionary powers of the center. 5.10.6 Centralization of economy. A. Under Nehru, the centralization of the economic policy making was carried out by Nehru through regulation and development of large-scale industries, including their distribution and location. The majority of the investments were from the center and the most basic industries were reserved for the public sector. 1. Several constitutional amendments were carried out by Nehru to centralize the economic planning. For example, the Third Amendment in 1954 amended the entry 33 of the concurrent list by adding production of and trade in certain foodstuffs and cattle fodder and raw cotton and raw jute to the industrial products which were under the legislative jurisdiction of the states so that they could be brought under the unions by a parliamentary enactment in public interest. 2. The Sixth Amendment in 1956 amended Article 286 to give power to the Union in order to determine the principles governing interstate trade and commerce and also to implement the intention of the Constitution makers not to allow the states to tax goods passing through its territory meant for sale or purchase in some other state or outside the country. 3. Further economic and political centralization was made by further amending the Seventh Schedule by bringing in the Seventh Amendment in 1956. B. Under Indira, Indira furthered the economic centralization tendency of the Union by drastically nationalizing the major commercial banks in 1969. The states virtually became satellites of the center because of the centralized economic planning, increasing role of Planning Commission in the federal fiscal transfers and through other discretionary transfers to the states by way of centrally sponsored social and welfare schemes and policies. The states thus were totally dependent on the center for the funds. Apart from these, there were also other indirect transfers such as the food and fuel subsidy, schemes involving tax expenditure, etc. 246 16 hours 37 minutes and 39 seconds. Issues and challenges pertaining to the federal structure. 247. 5.10.7 Role of discretionary grants. Plan and discretionary transfer is influenced by the political consideration and bargain made by the states. Hence, when there is political consideration, it is impossible to expect the central ministers to take unbiased decisions to effectively allocate their budgetary funds to develop all regions equally. The most astounding fact is that the discretionary grant has continued to play a substantial part in the federal fiscal fund transfer. Majority of the resources needed to implement important development plans of the states concern, such as education, health, agriculture, rural development, etc., come from the means of various central government schemes and programs. Majority of the activities under the education and social welfare have now become central subjects. The central ministries thus play an important role in allocation of its discretionary funds to the states. The Planning Commission also play a role in allocation of the discretionary funds as it approves the plans proposed by the states. Key role in development and design of some of the centrally sponsored schemes was carried out by the Planning Commission. 5.10.8 From Planning to NITI 1. The role of Planning Commission as a decision-making body went unchallenged during the first 2 decades after independence, as there was a single-party rule across the country. Thus the Planning Commission's failure to include representatives from the states went unquestioned. 2. This scenario changed when other party governments were formed in the states and when era of coalition governments started to rise in the center. These challenged the powers and functions of the Planning Commission, and questioned the contradicting federal aspect of the Commission. 3. The Commission was seen as a stumbling block when the government initiated the liberalizing measures after the 1990s crisis. 4. Then Prime Minister Manmohan Singh tried to alter the nature and infuse new dynamism to the Commission by appointing pro-market specialists to manage the Commission. 5. The states started creating their own federal space whereby they could dictate the path of national development. This increasing role of the states pushed forth the requirement of cooperative federalism among the center and the states, and also among the states themselves. 6. In order to foster this new need, the present NDA government under Narendra Modi established a new body, NITI Aayog, National Institution of Transforming India. 7. NITI Aayog came into existence through an executive order replacing the Planning Commission. The present organization too is under the command of the central government, and it is feared that this body too will follow the path taken by the erstwhile Planning Commission. But the performance and outcome of the NITI Aayog is not over yet to be judged. Nevertheless, the abolition of Planning Commission and establishment of NITI Aayog are expected to infuse energy towards a beginning of a new kind of fiscal federalism. There is already a recommendation made by the 14th Finance Commission to increase the state's share in the center's new divisible tax pool to 42% from current 32%. It has also recommended to 247 16 hours 37 minutes and 39 seconds. 248. Remove the distinction between plan and non-plan expenditures. Even this measure might have political implications, as there is still inequality existing between various states. The centrally sponsored schemes are sought to be cut down and states' duties and responsibilities are to be increased in these spheres. The NITI Aayog is set to prioritize the plan and development needs of the states individually. 5.10.9 Role of centrally sponsored schemes. The states and center have always mulled with the idea and functioning of the centrally sponsored schemes. Time and again, the states have expressed their genuine concerns about the design and implementation of these schemes. Most of the time, these schemes are unilaterally, without getting inputs from the states, constructed, and no room is given for local and regional specificities. Several committees were formed to examine various centrally sponsored schemes in view of the dissent raised by a number of state leaders. Some of the leaders consider these schemes to be encroachment of their constitutionally guaranteed powers and functions. Opposing the central government's recent implementation of the Direct Benefit Transfer (DBT) scheme, which was implemented by bypassing the state governments, former Chief Minister of Tamil Nadu, late J.J. Jayalalitha stated as follows: "They insidiously seek to secure for the Government of India unnecessary influence and authority over the finances of the states. We are equally opposed to the direct transfer of cash to the bank accounts of the beneficiaries by the Government of India bypassing the state governments altogether. This was neither an administratively sound practice nor in keeping with the spirit of federalism." Planning Commission had issued a series of instructions and guidelines on number of conceptual and operational issues relating to DBT with virtually no consultation with the state governments. Once decisions were taken and the scheme was finalized unilaterally by the centre, the states were required only to place their field machinery at the disposal of the central government to implement the mechanism. Are the state governments expected to look on as mere bystanders, far removed from the process of administering the scheme, after having placed their entire field machinery at the disposal of the Government India? This is clearly an infringement of the authority of the state governments and totally violative of the federal polity of the country and the spirit of democratic decentralization. 1. The centrally sponsored schemes, CSS, have been undermining the autonomy and the fiscal powers of the state. 2. Larger expenses by the centre on the CSSs has its impact on the resources to be transferred to the states, as their availability becomes less, and hence the states suffer. 3. The smaller states are faced with other problems due to these schemes. These states are forced to allocate resources in the form of monetary and human resource. As they are already backward, these states struggle even more to implement the schemes of the centre. 4. A subcommittee appointed by the National Development Council, NDC, in 1966 recommended abolition of several centrally sponsored schemes. 5. The first Administrative Reform Commission too recommended minimizing these schemes. In 1968 the NDC took decisions so as to keep the transfers to the states outside the fixed Gadgil formula to be 1/6 of the total central assistance to the states. 248 16 hours 37 minutes and 39 seconds Issues and challenges pertaining to the federal structure 249. 6. In 1985, committee headed by K. Ramamurthy recommended that the number of CSSs has to be reduced and its primary aim should be to initiate the process of change. Another high-level committee in the year 1985 recommended to transfer some of the CSSs to the states. But in reality, against all these said recommendations, the number of CSSs has only risen with bigger budget allocation and outlays, and in name of CSS these schemes intervened into the subject matter of the state list. 7. Accordingly, decision was taken at the Chief Ministers' Conference, headed by the Prime Minister, in 1996 to transfer the funds of those CSSs which fall under the state list. 8. The CSSs have other implications too, such as when the centre coerces the state to take part and share cost in some of the major CSSs like Sarva Shiksha Abhiyan, SSA, scheme. 9. The Union government, being in the dominant position and as the major funder of these schemes, dictates terms to be followed by the state governments even on matters pertaining and falling within the constitutional jurisdiction of the states. A. Views of Punja Commission centrally sponsored schemes. A. The Punj High Commission on Centre-State Relations was of the view that these CSSs tended to erode the state powers and created an unbalanced fiscal relation between the centre and the states. B. In line with various other recommendations made by other committees, Punj High Commission recommended a comprehensive review of all fiscal transfers made to the states with a view of reducing the discretionary transfers through the centrally sponsored schemes. C. It has also suggested that some of these schemes should be completely transferred to the states while some others' inbuilt flexibility be incorporated so that states can individually design and implement the schemes based on their need. D. The Commission also suggested that the additional expenditure liabilities on the states for implementing the central legislation should be borne by the central government and it should not burden the already overburdened state governments. May 10, 10 Taxation powers. The Constitution itself provides a favorable position to the center with regards to the revenue and financial resource generation. The taxation powers of the center are vast compared to that of the state. The most productive part of the taxes, the income and corporate tax, duties of customs and excises are assigned to the Union. The 88th Constitutional Amendment in 2003 inserted a new entry No. 92C to the Union list, giving exclusive jurisdiction to the Union government to levy taxes on services, which has now become a major source of revenue in the economy. The proceeds of the states taken together are less compared to that of the Union. Though the Constitution allows the center to retain and control major resources, it does provide for transfer and assignment of these resources to the states. Some of such provisions are: 1. Article 268, levied by center but collected and appropriated by the states. 2. Article 269, levied and collected by the center but assigned to the states. 249 16 hours 37 minutes and 40 seconds. 250. 3. Article 270, taxes levied and collected by the Union, but assigned to both Union and states. Mandatory sharing through the Finance Commission. 4. Article 275, statutory grants in aid, based on the recommendation of the Finance Commission. 5. Article 282, grants for any public purpose. 6. Article 293, loans granted for any purpose. May 10, 11 Borrowing powers. Under Article 292 of the Constitution, the Union government has unrestricted power to borrow subject to the limits imposed by the Parliament. But borrowing powers of the states are restricted under Article 293. This article says that the executive power of the state extends to borrowing within the territory of India and not outside. It also says that the state cannot raise a loan without the consent of the Government of India or its guarantee. Even after the economic liberalization, the constitutional structure and nature of center-state fiscal federalism has not changed. Foreign funding to the state government and its projects are routed through the central ministries or through central financial institutions. Major industrial and investment policies are still under the control of the central government, or under boards or agencies appointed by it. As per Article 301 of the Constitution, trade, commerce, and intercourse throughout the territory of India shall be free, but restrictions can be imposed for public interest both by centre and the states. Movement of commodities which play a vital role in life of common people though cannot be restricted even for such public interest. Article 285 says that the property of the Union shall be exempt from all taxes imposed by the states or any other authority within the state, and similarly Article 289 provided that the property and income shall be exempt from the taxation by the Union. May 10, 12 Conclusion. There are multiplicity of subnational structures and political institutions in a federation, which undesirably affect the implementation capacity of the national governments which tries to formulate macroeconomic reforms. The Indian Federation is no different in this regard. As seen in the beginning, India is a giant multinational system and many states within the system are now demanding reform in the center-state fiscal dynamics. The third tier, the panchayats, which are still under the control of the state governments, have been already covered under the federal fiscal transfers. The states are now claiming their share from the national resources which till now were under the exclusive jurisdiction of the Union government. The states still look to the center for most of the things, but this dynamics is now changing in the era of coalition politics. The states are not just expecting but are bargaining and demanding from the center. And such dependence of states on the center eliminates the fundamental federal principles. To quote the State Reorganization Commission, It is no doubt true that all the states of the Indian Union are now dependent in varying degrees on central aid for development expenditure. However, we must not lose sight of the fact that excessive dependence on the center detracts from the federal principle, since a real division of the political power is not possible without an adequate separation of financial powers and resources. The balance of a federal union is bound to be disturbed, if there are among its constituent units poor relations or mendicants, particularly if they are inclined to be extravagant. 250 16 hours 37 minutes and 40 seconds Issues and challenges pertaining to the federal structure 251. Thus in such scenario, shift towards centralization is inevitable if a nation and its macroeconomic status has to progress. Effective federal fiscal and macroeconomic management can be carried out by a unitary federal system. It can also generate several prospects for decentralization also. 5.11 Conclusion 5.11.1 What is a federation? It is important to highlight the fact that Constitution of India does not define what federalism is. During the Constituent Assembly debates, the terms federal and federation were very much discussed, but they did not find favour to be included in the final draft of the Constitution of India. Instead, the Constitution declares India to be a union. During the final stage of the Constituent Assembly debates, the drafting committee deliberately tried to avoid the usage of the words federal or federation in the Constitution. 5.11.2 Need for a strong center. A strong centralized government has gathered forces and has brought a sense of unity and created a feeling of nationality among the people. Support has been there for a strong center in the federation, which can be seen from the debates and discussions in support of strong center in the Constituent Assembly. G.N. Joshi, in 1937, much before the Constituent Assembly started its debates, he argued as follows. Having regard to the political problems of India, the composition of her population, her economic requirements, and the danger of provincial patriotism intensified by communal feeling running amok, effective solutions of her vital problems are only possible if they are attempted on an all-India scale. Such a feeling is even present now among some of the contemporary political scientists in India. Only at a political level, the political parties and state political leaders are demanding for better federalized structure and are raising voice against the centralization moves by the union government. These pressures have resulted in gradual move towards decentralization. 5.11.3 Federalism in the Constitution. The Constitution of India tried to project India as a unified whole. Even though it contains several unfederal features, India is still considered to be a federal country. Several federal features have been incorporated into the Constitution, such as devolution of powers. Unlike the standard federal setup, the Indian constituent federal setup did not willingly join the continental structure. Forceful arguments were made for federalism during the initial years as there was difference in culture, social conditions, and even history among the constituent states. But today federalism is being held as one of the basic features of the Constitution. 1. The Constitution of India has recognized and acknowledged asymmetries existing between various states in the Federation. 2. The representation of the states in the central legislature, that is the Parliament, is highly asymmetrical in nature. 251 16 hours 37 minutes and 40 seconds. 252. 3. The seats reserved for the MPs from each states varies according to its size and population of the states. 4. It is not understood why asymmetrical pattern of representation based on population which was followed in the lower house Lok Sabha of the Parliament got replicated in the upper house Rajya Sabha also. 5. Considering the center-state federal fiscal relation, there exists a wide gap between the constituent states. 6. There is also a preference for more centralized or unionized fiscal system as the tax structure is largely controlled by the central government. 7. There is mismatch in the pattern, growth, and development of different units of the federation. 8. The developments of the constituent units are now increasingly tied to the central government. 9. Apart from these, the Constitution itself has provided explicit asymmetric federal provisions for the state of Jammu and Kashmir, northeastern states and some other tribal states and regions. These provisions have been laid down in the Articles 370 and 371 and 5th and 6th schedules of the Constitution. Also, Article 275 has laid the foundation for categorization of some of the states as special category states. 5.11.4 Constitutional powers to the center. The Constitution has empowered the center to create new constituent states, change areas and nomenclature of existing states. Thus, territorial integrity is not protected by the Constitution. This is a major deviation from the fundamental federal principles. The constituent states are trying and retrying to define the powers and functions on their own, including demand for more autonomy. Since independence, the Indian Federation has undergone number of reorganization and changes in its boundaries. There are still more demands for reorganization and creation of more states. Intellectually, demands are also being made for smaller constituent states for better administration of Indian Federation. 5.11.5 Theory of Federalism. Coming to the theoretical aspect of the Indian federalism, it is presumed that the main issue involved is distribution of powers and functions between different organs of the government and distribution of functions and powers between different constituent state governments. While talking about federalism, we generally tend to link federalism with functional and territorial aspects. We tend to ignore other non-territorial aspects and other socio-cultural norms, including community participation and representation, which tend to govern these relationships. Territorial federalism and power distribution had resolved the initial conflict facing the Indian Federation, issues based on ethnicity and language. Of late, contemporary issues, including issues of non-territorial communities, such that of religious, caste and other cultural issues, have become important to maintain the political stability. 5.11.6 Indian Model of Federalism. 1. In many academic discussions, it is argued that India has its own model of federalism with its own unique features. 252 16 hours 37 minutes and 40 seconds Issues and challenges pertaining to the federal structure. 253. 2. Federalism in India is significantly different from other existing models practiced elsewhere. 3. They are marked by certain distinct features. Unlike any other federations, there exists a centralized power setup which determines the powers and functions of the territorial and non-territorial units within its ambit. 4. The center-state relation and the political power distribution are centrally controlled. 5. This is against the basic tenet of concept of federalism. In recent times, when the constituent states are demanding more power and autonomy, we can see the growth of power of the centralized power structure, which is becoming more dominant. 6. However, when the central government is trying to take some of the important roles and functions of the state governments, the emergence of the coalition governments has bulldozed some of the constitutionally guaranteed powers of the central government over the states. 7. The distressing fact of emergence of the coalition politics is that it has led to development of some blackmail-type bargaining in center-state federal relations. 8. As far as India is concerned, federalism means a dynamic process of maintaining vertical relations between the constitutionally powerful federal government and the constituent state governments. 9. Federalism has a long historic tradition in India, and it has also undergone numerous changes. 10. In the post-independent era, the political leaders have played a decisive role in shaping and reshaping of Indian federalism. 11. Apart from them, the state governors and the constitutional courts have played important role in shaping and reshaping of the federalism. 12. Effort was made in 1990s to constitutionally recognize the third tier of the Indian federalism, this reinvention of Indian federalism did not alter much of the basic centralized structure, and these institutions are yet to become effective governing bodies on their own. 5.11.7 Features of federalism. It should be understood that federalism is a dynamic process in its relations and power sharing among arrangements among the constituent states. It has been argued that the success and the stability of the federation is based on how it is allowed to work. 1. The political leaders play a key role in maintaining this dynamic federal relationship between the constituent units. 2. In a federation, it is important to maintain the balance between relations of center and the constituent state units. 3. Any move towards over-centralization will break down the federation. 4. A strong and united India is always welcome, but for that to happen the constituent states have to be strong and resilient, which then can create a strong and united India. 5. Power sharing among the federal constituent units is very essential for sustaining and maintaining the democracy in deeply divided societies such as India. 253 16 hours 37 minutes and 40 seconds. 254. 5.11.8 Reorganization of states. As already stated before, since independence the reorganization of the state boundaries and territories are regular features. Time to time, new states have been created through the process of reorganization, and hence there are now demands for more states based on regional tribal identities. Intellectually, arguments have been put forth that smaller states would be easier to manage in Indian context. In fact, in reality some of the states are too large to manage or govern effectively. It is perhaps now the right time to constitute a second state reorganization commission to look into the rationale behind demands of such states and consider the importance of size, population, and cultural settings of the people. There is now also the need to devolve the power to the districts in order to strengthen the grassroots level governance. 5.11.9 Role played by the regional parties. The center-state relation dynamics has undergone change because of the growing role of regional parties and their participation in the coalition governments. This growth has led to informal refederalization of the Indian political system. 1. This kind of federalism is tending to undermine the national development perspective. 2. On the other hand, as the country is fast developing in terms of industry and capital, the concept of federalism is losing its significance. 3. Nonetheless, the constituent federal units are trying to reinforce the concept of dynamic federalism in order to protect their power, authority, and functional autonomy. 4. The role and power of the central government were enhanced by extra-constitutional bodies such as the Planning Commission, now reconstituted as NITI Aayog, but presently extra-constitutional features such as the coalition regimes are undermining the power of the center and the states are trying to enforce their will. May 11, 10 steps to be taken by the center. It is perhaps time that center relieves its responsibility for each and every aspect concerning the country. 1. It must restrict its responsibility to limited subjects concerning national importance. 2. It must stop relying on the states to implement its policies and programs. It must implement them using its own resources, infrastructures, and offices. 3. It can even liaison with the district governments directly for implementation of such programs. 4. For subjects under the purview of the state governments, the center should ask the people to seek out to the state government they have elected for their implementation. 5. If the state governments could not guarantee and fulfill its public duty obligation to its citizens, the center may coerce it to act and in extreme circumstances may take over the administration of the states for a temporary period. 6. In brief, it can be stated that federation is antithesis to the concept of nation-state, but nonetheless it plays a key role in nation development. 254 16 hours 37 minutes and 40 seconds Issues and challenges pertaining to the federal structure. 255. 7. Though Union of India is the basis of our national identity, it must be accepted that the strength and stability of the Union depends on the strength and capacity of the constituent states to develop and grow on their own. 8. The central government must not distort the powers and functions given to the constituent state units. May 11. 11. Contemporary status of federalism. It is a known fact that India has voluntarily federalized itself to accommodate both territorial and non-territorial interests within the framework of broader power-sharing arrangements and through recognition of linguistic and cultural autonomies of the constituent state concerned. 1. The independent India is undergoing a federalizing process, and through this the federal diversity is also increasing. 2. In order to govern the vast diversified people divided historically, culturally, ethnically, etc., led to establishment of the federal structure in order to help them govern themselves. 3. The Republic of India is thus a federation, but it has many distinctive features which essentially modifies these federal features. 4. In India the federation was created paradoxically to contain the divisive forces. Since independence, several states have been added by modifying and rearranging the boundaries of the existing states. 5. There is growing demand for further creation of smaller states and their reorganization. 6. Number of communities based on caste, religious and other cultural identities are demanding legitimate space of their own within the federal system in form of cultural autonomy. 7. In such a scenario, the nature of federal dynamics is changing rapidly. 8. The rise of coalition politics has also given boost to new dynamics in the federal debate in India. Today, every policy and program of the central government, including development and welfare measures in some of the most important sectors such as education, agriculture, rural development, health, etc., are directly linked to the emerging federal relations. 9. Apart from these, emerging security concerns in areas such as terrorism and Naxalism have also given a new push to the federal dynamics in the country. 10. Additionally, in order to address diverse demands made by the constituent states, the Indian state has resorted to numerous asymmetrical and special federal arrangements, including that of asymmetric fiscal federal measures. 11. In short, the independent India started with a unitary federal state with strong unifying tendency. 12. The constitution was also highly centralized. Though the constitution was in favor of a strong central government, it did have several provisions for maintaining the federal character of the state. 13. As time passed, the independent India underwent federalizing process. It recognized the regional federal diversity, ethnic diversity, linguistic and other cultural diversities. 255 16 hours 37 minutes and 40 seconds. 256. 14. This federalization process contained both unionizing and regionalizing features, which were expected to provide stability to the federal union and thus consolidate India as a federal state. 15. The Constitution guarantees enough powers to the state governments to protect interests and identities of various territorial and non-territorial minority communities. 16. It may still be argued that India is still a multinational state, but it is strongly moving towards a nation-state system. 17. People and the states are looking towards the one government that is the national government. 18. An even center government is playing a dominant role in every aspect possible. But as the states are demanding, the center should recuse itself from all activities and provide enough autonomy and powers to the states to take decisions on their own. 19. The center should also stop relying on the states for implementation of its policies and programs. 20. It should intervene directly and reach people at the ground level through its own officers or with help of the district administration. 21. This will help in doing away with the negative role played by some of the state leaders and parties. 22. Perhaps time has now come to realize that districts are the constituent units of governance. 23. Constitution may itself delegate powers and functions at district level and create a mechanism to elect a representative, democratic, responsible government at district level. Finally, it is important to understand that any demand for strong federalizing features will not in turn create a stable political governance system. Political leadership has a crucial role to play in the changing federal dynamics. What needed is not just a federal political leadership to understand the dynamic underlying federal relations. Thus, the federalism in India is a dynamic process based on needs and aspirations of a diversified population. Following findings and observations can be derived from the above study. 1. Since ancient times, federalism has remained an important instrument for political organization in the country. Centralized states have been formed by alliances and counter-alliances of the kings and emperors during the medieval and ancient period. There existed several autonomous and semi-autonomous provinces having a limited sovereignty. In fact, some of the masterful personalities of ancient India controlled vast empires consisting of several smaller feudatory kingdoms. The emperor who had captured the kingdoms always treated them to be as subordinate alliance by the local ruler and king, but he respected the local laws and customs and never tried to introduce his principles in those territories ruled by him. In course of this, we have to acknowledge that the kingdoms in ancient India never joined together or united under one single ruler or system to form a strong unitary state, nor was there any effective federal structure. 2. The local self-governing institutions and the village republics played a crucial role in the political organization of people in ancient India. 3. While kingdoms in ancient India never came together to form a strong military state or a pure federal system, it has been established that all successful empires in that 256 16 hours 37 minutes and 40 seconds issues and challenges pertaining to the federal structure 257. Time was highly centralized. This centralization became distinct during the medieval period. It has to be noted that strong centralizing tendencies of the ancient empires was followed by simultaneous devolution of powers, that is, by providing regional and provincial autonomy. Though the personality of the emperor held together the empire together, he had to give some kind of recognition to the regional kingdoms and autonomous states from time to time. There did exist a number of such autonomous provinces within the centralized structure, and the rulers of these states did enjoy varying degree of power and autonomy. 4. The British tried to rule the country as a unitary system, but even they introduced several measures for administrative decentralization and paved way for formal decentralization of the federal system by enacting the Government of India Act 1935. Thus credit has to be given to the British for the emergence and growth of federal idea in modern India. The role played by the British brought in several territorial and non-territorial units of the Indian Federation. In order to suit their vested interests, the British even recognized and accommodated the princes, the minorities, the depressed classes and various other functional communities. They made systemic efforts for representation of these communities in the legislative and the public bodies. 5. The federal structure underwent a change by the enacting of the Government of India Act 1919, popularly known as the Montagu-Chelmsford Reforms. It marked the beginning of emergence of federalism in the country, as it had clear-cut provisions of separation of revenue heads between the centre and the provinces. It introduced the concept of diarchy for sharing the sovereignty at the provincial level. It transferred many subjects to the Indian ministers answerable to the provincial government, and rest other subjects were under the consideration of the provincial governor's discretionary power. These reforms also provided for a representative bicameral legislature at the centre, a council of state and central legislative assembly, and a consulting and advisory body of Chamber of Princes. For the first time ever, the provincial legislatures were given legal and financial authority over important subject heads like health, education, irrigation, public works, agriculture, etc. 6. In the history of development of federalism in the country, the Government of India Act 1935 remains a landmark instrument. The Government of India Act 1935 not only served as the governing instrument till the independence, it also served as a reference for the members of the Constituent Assembly. If this act had not been enacted, it would have been difficult for the members of the Constituent Assembly to frame the Constitution of India within the time they had taken to do it. Almost every provision present in the Constitution of India finds a mention in the Government of India Act, 1935 either directly or indirectly. The Constituent Assembly simply modified or changed the most of the existing provisions present in the 1935 Act and adopted what suited them. They were thus not required to introduce any major fresh subjects. 7. The existence and presence of large number of princely states was a unique problem faced by the Indian Federation which had no parallel anywhere. Their merger and integration with the Union of India within a short span after the independence was a unique exceptional achievement. 257 16 hours 37 minutes and 40 seconds. 258. 8. Initially the Constituent Assembly started with a very positive spirit to draft a federal constitution for India and also envisioned that India is a federation of states. However, right after the independence and the scenario that existed during the partition made the Constituent Assembly to think in the other extreme, and it in fact decided to create a strong centralized structure. In the end, the Constituent Assembly even avoided the use of words federal or federation in the Constitution and supported for a strong union. The Constitution of Independent India was biased towards the centre. The consociational provisions as provided in the Government of India Act, 1935 for the minorities, depressed classes were taken away by the Constituent Assembly. But certain special concessions to the SCS and STS, to some extent the Anglo-Indians, were allowed to continue. 9. The territorial integrity and unity of the constituent states have not been recognized by the Constitution of India. Since the time of independence several state reorganizations have taken place. As per the Article 3 of the Constitution, the centre has not only created several new states, but have also altered boundaries, changed names etc. of the existing states. The reorganization of the states is still a burning issue as still now there are demands for autonomy. 10. The constituent states in the federation vary in terms of size and population. Apart from this there is significant difference in terms of economic growth and levels of economic development between the constituent states. In the Indian political setup the larger states enjoy much more dominant power and status. All these asymmetries existing between the states will impact on interstate concord and discord, and it will further reinforce state-wise son of the soil movement. Asymmetrical features present in the Constitution for representation of the states in the Parliament have led to major imbalances in the power structure of larger and smaller states. In order to mitigate this imbalance in power and socio-economic backwardness of the smaller states, some asymmetric provisions have also been incorporated into the Constitution. It has had a negative effect as some of these provisions have further reinforced the asymmetry and thus making it difficult to manage the political process. 11. In the future the reorganization of the states is going to be still a major concern for the Indian Federation. The delimitation of the electoral constituencies, which was freezed till 2016 by the 84th Constitutional Amendment, is likely to open new problems as this will have a significant impact on the representation of the states in the Parliament. Based on population proportionality, the northern states having larger population will walk away with more seats in the Parliament compared to other states which have effectively implemented population control measures. This is likely to create problem among the states which might lead to further reorganization. 12. In order to deal with several asymmetrical aspects and to provide effective governance, it is perhaps time to realize the need to make further reorganization of the states and create new smaller states. It is indeed time to fix the minimum and maximum size of the states in terms of its population and size. The bigger states may be divided so as to fit the maximum size provided. This may not be as easy, thus there is now a requirement for a new State Reorganization Commission for effectively dealing with the issue. This reorganization has to happen with the involvement of several experts and other representative members to be present in the Commission. 258 16 hours 37 minutes and 40 seconds Issues and challenges pertaining to the federal structure 259. 13 In the Parliament of India, the Lok Sabha has a differential representation of members based on population of each state, hence there is no logic behind using the same formula for the representation of the upper house that is Rajya Sabha also. Such kind of similar proportionate representation for the both houses for the constituent state was in fact questioned in the Constituent Assembly, and thus the composition of the states in the Parliament, especially Rajya Sabha, is a subject matter of debate for a long time. The smaller states did have concerns regarding such composition in the Rajya Sabha, as it was favoring the larger states having larger population. Thus these larger states can impose a legislation on large number of the smaller states even without their consent or support. The Rajya Sabha being the House of States, and accordingly the Rajamannor Committee in 1971 recommended for equal representation of states in it. This issue of equal representation was raised before the Sarkaria Commission on Centre-State Relations. The Punch High Commission on Centre-State Relations went a step further or recommended that relevant provisions should be amended so as to provide equal representation of states irrespective of their population size. It also suggested that the Section 3 of the Representation of the Peoples Act be placed back to its original position before its amendment in 2003, and thus representatives of the state in Rajya Sabha should again be linked to the territory of the concerned states. 14 The centre state as well as the interstate conflict resolution mechanism is not very well developed. The Rajamannor Commission, the Sarkaria Commission, the National Commission on Review of Working of the Constitution, the Punch High Commission etc. all suggested for a stronger role for the Interstate Council. In fact, Interstate Council was established by the VP Singh government, but it was kept in deep freeze. No proper role and function has been allocated to the Interstate Council. As far as interstate river waters are concerned, the interstate river water tribunals have failed to resolve such issues within reasonable time. Such disputes have continued for a long time, and the procedure behind the Water Disputes Act has remained a lengthy one. Even the interference of the courts in such matters have not made any significant changes to resolve these issues. Hence there is pertaining need to bring proper and effective legislation concerning the interstate sharing of river water and restructuring of the role of the tribunals in such matters. 15 There is now urgent need for a balanced and equal growth and development among different zones of the country. Such measures will strengthen the Union on India against any vociferous tendency. 16 The extra-constitutional role played by the political parties and their leaders have significantly changed the dynamics of federalism in the post-independent India. A perusal of federalism in the post-independent India shows that Indian federalism has experienced three different phases of centre-state federal setup. First, during the first 2 decades after independence, most particularly under Nehru and Shastri, the federal relation was marked by centralized but cooperative federalism between the centre and the states. The relations were centralized from the perspective of the economic planning and national development. As far as the political relations were concerned, Nehru maintained a balanced and coordinated federal relationship. Nehru, with strong support from the Congress Party, defended the strong centre in order to maintain the national unity and integrity. The single-party dominance by the Congress Party during 259 16 hours 37 minutes and 40 seconds. 260. The first 2 decades played an important role in centralizing all the important economic and government activities. 17. The second phase starts after Nehru, significantly after the 4th general elections in 1967. Indira Gandhi changed the cooperative federalism of the Nehru-Shastri era to coercive federalism. The centre-state relation was highly reactionary to each other. The coercive federalism of Indira was seen by over-centralization of both political and economic spheres. The centre virtually ruled over all the states. Even the Janata government formed after overthrowing the Indira government did nothing to reverse this trend. Rajiv Gandhi, though initially tried to be cooperative with the states, ultimately tried to revive his mother's centralized and authoritarian mode of taking decisions. The coercive and over-centralized phase of the center-state federal relations continued till 1989, when the emergence of coalition politics virtually changed the federal dynamics. 18. The second phase of the center-state federal relations started after the strong role played by Kamaraj-led Congress syndicate's influence of the state leaders of the Congress Party. This syndicate later turned out to be a spoiler for Indira and was in fact responsible for her over-centralization measures and the subsequent proclamation of emergency. The states by mid-1960s started to challenge the center, and after the 1967 elections the domination of the Congress Party in strategically important states got eliminated and non-Congress took up the power in these states, thus strengthening the regional voice. The Congress Party got trounced in several state and coalition of regional parties or national party with regional parties' support formed the government. This signaled the weakening of the center and the strengthening of the clout of the states. This is described as the adulthood of the Indian states within the Indian federal structure. Apart from challenging the dominance of the Congress Party, these non-Congress ruled states started demanding structural changes be made to the Indian federalism. Indira's centralization move virtually defeated the adulthood of the Indian federalism. 19. The third phase marked with cooperation and confrontation between the center and the states due to the emergence of coalition politics. The center-state relations became a kind of federal bargain between the center and the states. If the bargain resulted in favor of cooperation, both the center and state cooperated; in case otherwise they confronted each other. A perennial kind of era in coalition politics has given power to some of the leaders of the states who have become powerful and have influenced the bargain in favor of their own state and party. Even the central government started to bargain in order to have its own political sustenance. Unfortunately, the federal structure has served as the breeding ground for uneven development, as the regional political groups have started to exert pressure on the central government to work on their interests, thus marginalizing the reforms to be carried forward by the center. These kinds of bargain has weakened the ability of the central government to carry forth strong economic and political reforms. 20. The emergence of coalition politics and the role played by the judiciary has reduced the misuse of the office of the governor and the controversial use of president's rule in the states. In the present political scenario, it can be easily inferred that constitutionally Indian federalism still remains centralized in nature, but practically it has 16 hours 37 minutes and 40 seconds issues and challenges pertaining to the federal structure 261. Turned out to be decentralized 1. Within Indian federalism there is shift in balance of center-state relation in favor of the states. 21. As far as the fiscal federalism is considered, the center still plays a dominant role. The extra-constitutional role played by the Planning Commission in discretionary allocation of the funds and other discretionary fiscal transfers in the form of centrally sponsored schemes and welfare policies and other budgetary support undermined the growth of true federal spirit. 22. There are plethora of centrally sponsored schemes, CSSs, and in particular the manner in which such schemes are designed and implemented has greatly undermined the authority of the states concerned. Almost all the CSSs are designed by the central government without the consultation with the state governments, and it does not give due recognition to the regional and local specificities for such schemes. Importantly, in some on the major centrally sponsored scheme involving huge funds, the states have been coerced to share the financial burden. Many state political leaders consider the same to be an encroachment upon their federally allocated jurisdiction. 23. Time has indeed come for the need to review and reframe the various centrally sponsored schemes and policies of the central government. If the subject matter they deal with fall under the purview of the state list, then such schemes have to be transferred to the states for its administration and implementation. Even if the schemes of the center has to be administered by the states, they have be consulted and involved in the design and development of such schemes and policies. Any such centrally sponsored schemes has to be fully funded by the center without financially burdening the state government. States may also be provided with scope of additional revenue generation by implementing various welfare schemes of their own. 24. In order to avoid controversy with regard to implementation of various CSSs and other direct benefit transfer schemes, the central government may use its own resources and offices, administrative infrastructure, and thus directly deal with the concerned people and avoid using the resources and machineries of the states. 25. Districts have traditionally remained the units of administration and governance. It is perhaps time to realize its importance, effectiveness, and recognize the elected district governments. The idea of elected district government can be enhanced and implemented as part of already existing constitutionally provision giving power to local self-governance. 261 16 hours 37 minutes and 40 seconds 262 16 hours 37 minutes and 40 seconds. In this, you will learn about civil society, people's participation, why citizens' participation has to be strengthened, theories of management related to good governance linking public participation, contextualizing people's participation, use of tools for people's participation, relationship between people's participation and good governance, models of good governance on the basis of participation levels, effective participation for good governance, citizen and administration, an accountability perspective. Success of democracy is impossible without participation of the people. Honorable Prime Minister Shri Narendra Modi. As per the UN World Public Sector Report, 2008, citizen participation implies the involvement of citizens in a wide range of policy-making activities, which includes the determination of levels of service, budget priorities, and the acceptability of physical construction projects in order to orient government programs towards community needs, build public support and encourage a sense of cohesiveness within neighborhoods. The working definition for citizen engagement as per the United Nations Public Administration Country Studies, UNPACS, is: citizen engagement in public administration implies the involvement of citizens in decision-making process of the state through measures and/or institutional arrangements so as to increase their influence of public policies and programs, ensuring a more positive impact on their social and economic lives. Citizens' participation in governance. 6. 264. 6.1 Civil society. The World Bank in its report defines civil society as follows. Civil society refers to the wide array of non-governmental and not-for-profit organizations that have a presence in public life, expressing the interests and values of their members or others, based on ethical, cultural, political, scientific, religious, or philanthropic considerations. Civil society organizations, CSOs, therefore refer to a wide array of organizations, community groups, non-governmental organizations, NGOs, labor unions, indigenous groups, charitable organizations, faith-based organizations, professional associations, and foundations. The term civil society has come to enjoy political, intellectual, and administrative importance in the recent years. But the concept has been in existence for a long time. Traditionally, the terms civil society and state have been used interchangeably, and treated as synonyms. Hegel was the first philosopher to separate civil society and the state, and this was followed by a number of other scholars. 6.1.1 Definitions of civil society. The following are the various definitions given to the civil society. From this we can come to understand the concept and principle behind establishment and existence of the civil society. The concise Oxford Dictionary of Politics defines civil society as the set of intermediate associations which are neither the state nor the extended family, Civil society therefore includes voluntary associations and firms and other corporate bodies. The definition for civil society as given by various scholars is as follows: the realm of spontaneously created social structures separate from the state that underlie democratic political institutions. Fukuyama, 1995:8. Civil society is broadly regarded as the domain of relationships which falls between the private realm of the family on the one hand and the state on the other. Dunn 1996:27. Charles Taylor defined civil society as a web of autonomous associations independent of the state, which bind citizens together in matters of common concern, and by their existence or actions could have an effect on public policy. Kligman 1990:420. Schmitter defined civil society as a set or system of self-organized intermediary groups. Schmitter 1995:1. Civil society is the social relationships which involve the voluntary association and participation of individuals acting in their private capacities. In a simple and simplistic formula, civil society can be said to equal the milieu of private contractual relationships. Tester 1992:8. 264 16 hours 38 minutes and 12 seconds. 6 Citizens' participation in governance 265. According to Andrew Haywood, civil society refers to a realm of associations, business, interest groups, classes, families, and so on. According to Jan Art Schulte, civil society can be understood to be a political space where voluntary associations deliberately seek to shape the rules that govern aspects of social life. 6.1.2 Features of civil society. The following are the features of civil society. 1. It refers to an organized form of society. 2. It covers a large space in the society. 3. Even though it is an autonomous entity, it is still subject to control by the state. 4. It is in pursuit of common good of the people. 5. It helps in the formulation of public opinion and sets up demand which are general in nature. 6. It is an advocate of pluralism in order to reduce the domination of the state. 7. It serves as a moral compass in the community value system. 8. It is a non-state institution. 9. Its existence implies that there is freedom of expression, freedom of thought and other fundamental rights of the people. 10. It is in opposition to authoritarianism and totalitarianism. 11. By educating the people, it promotes citizenship. 12. It covers all the intermediary groups which is present between the state and the family. 13. It facilitates participation of the citizens in administrative matters. 14. It does not coerce, rather it encourages voluntarism. The current positive thinking is civil society is an arena of freedom which correctly identifies its basic value as a condition for democracy. There can be no effective citizens where there is no democracy. The capacity of the citizens to choose their identities, duties, entitlements within the legal political framework is not possible without the development and role played by the civil society in a democracy. Public organization is a necessary requirement in a liberal democracy, and for developing such values and norms, the role played by civil society is essential. Larger interests of the population, common civic ends can only be achieved through existence of a vibrant civil society. 6.1.3 Components. The following organizations and groups are included under the ambit of civil society: community-based organizations, cooperative societies, youth groups, farmers' organizations, religious associations, trade unions, non-governmental organizations. 265 16 hours 38 minutes and 12 seconds. 266. Indigenous peoples' organizations, women's groups, other similar organized groups in the society. In countries like the United States, civil societies are well established, while in developing countries like India, it is still underdeveloped. It can be understood by the case in India that, here the civil society groups in opposition to the government are well developed, but civil society as an associational group representing interests of wide segments of the society is not fully functional yet. In India, the civil society groups are apart from voluntary associations, seen as fluid associations of social groupings based on caste, kinship, religious ties, etc. The civil society organization in India can be classified into the following 5 categories. 1. Religious associations such as Deobandi movement, Sikh Khalsa groups, Ramakrishna mission, other church missionaries, etc. 2. Membership associations of various types, such as professional associations, viz., lawyers, doctors, etc. Self-help groups, viz., ward committees, women's organized self-help groups and community-based organizations in the villages, etc. Representational institutions, viz., farmers' organization, trade unions, etc. Socio-cultural groups based on sports, other recreational activities, etc. 3. Social movements of different kinds, such as movements to reform particular social evils, e.g., dowry, alcoholism, etc. Movements focusing on process of governance, e.g., anti-corruption campaign, civil liberties movement, etc. Movements focusing on need of particular vulnerable groups, viz., women, tribal groups, etc. Movements of protest against disruptions and displacement due to developmental activities. 4. Intermediary associations of various kinds, such as philanthropic groups, e.g., Child Relief and You Cry, Gate Foundation, and other associations, etc. Mobilization-based groups which help to fight for and mobilize the marginalized groups in the society. Service delivery groups, viz., schools, old age homes, etc. Advocacy groups which give voice for particular cause. Other networks, which extend the collective voice of the people. Supportive groups, which provide support to the community-based groups in the society. 5. Traditional associations formed based on caste, tribe, and ethnicity. 6.1.4 Role. The civil society organizations play a very important role in the welfare and development of people in the society. The various dimensions of their role are as follows. 1. They help in the facilitation of people's participation in governance. 2. They help the administration by identifying the target groups. 266 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance 267. 3. They help create political consciousness among the people by discussing various political issues with them. 4. They help strengthen the principle of self-help. 5. They act as the watchdog of public interest. 6. They make the administrative machinery more responsible and responsive to the needs and aspirations of the people. 7. They mobilize and organize the poor for the purpose of socio-economic development. 8. They help in identifying and using the local resources for the purpose of development and thereby make the communities self-reliant. 9. They disseminate information and help make people aware of the various schemes, programs, and activities, developed by the government for their welfare. 10. They try to reduce the scope of corruption, by imposing a community system of accountability on the administration at lower levels. It must be said here that the role of voluntary agencies is not to compete with the government, rather complement its activities. Apart from this, the advantages of involving voluntary agencies in the development process is as follows. It creates a sense of solidarity among the people, it gives opportunity for the governing agencies to interact with the people directly for implementation of the development goals, and it strives for participation in decision-making process. The voluntary agencies also have other advantages over the governmental bodies. They are as follows: 1. They can have better rapport with the local people than that by the government officials. 2. They can be very flexible and act in such a manner as they are not bound by rigid bureaucratic rules, regulations, and procedures. 3. The volunteers involved are more sincere and dedicated to the task of reducing the sufferings of the poor than the governmental staffs. 4. They can motivate the public to participate more effectively than the governmental agencies. And 5. The efforts carried out by such agencies are more economical than that of the governmental bodies. 6.1.5 Limitations. Though there are numerous advantages of the civil society, they do suffer from a number are limitations as follows: 1. Interference and involvement of the political parties. 2. Lack of qualified and trained professionals. 3. Presence of diverse socio-economic environment in the country, such as casteism, poverty, communalism, etc. 4. Non-cooperation and even resistance by the bureaucrats. 5. No holistic perspective, rather they have a limited narrow perspective. 267 16 hours 38 minutes and 12 seconds. 268. 6. They do not have sufficient financial resources. 7. They lack adequate and proper information base. 8. The resistance offered by local landlords, moneylenders, etc. Assessing both the merits and other disadvantages of the voluntary sector, the World Development Report in 1997 gave the following observation: the voluntary sector not only brings its own strengths to the table, but also its own weakness. It does a lot of good work in increasing public awareness, voicing citizens' concerns, and delivering services. Local self-help organizations are sometimes the preferred providers of local public goods and services, because of their closeness to local concerns. But their concern is often for certain religious or ethnic groups and not the society as a whole. Their accountability is limited and their resources are often constrained. 6.2 People's participation. People's participation implies the participation of people in the administrative process. It means that citizens' control over the administration or the influence of the public on the machinery of administration. This is essential for smooth and effective functioning of the administration. It makes the administration more responsive to the needs of the people. The support of the people is secured, thereby making the policies and programs of the government a success. It is an important means to secure and enforce the administrative accountability. The basis of democratic government is the doctrine of popular sovereignty, which essentially means that the people are supreme in a democracy, or the final authority in a democracy is vested with its people. Hence, the administration functioning in a democracy is ultimately responsible to its people. And hence in this context, the participation of people in administration assumes significance. It transforms the representative democracy into a participatory democracy. It lays stress on the concept of bottom-up approach. The participation of people in administration can be studied under two heads as follows: 1. Participation in general administration, and 2. Participation in development administration. 6.2.1 Participation in general administration. The people do not have knowledge about the administrative process, and they are unorganized, hence, they cannot have a definite and effective influence on the administration. Therefore, the public influence on the administrative process is generally informal and indirect. However, there are certain formal modes of participation of the people in administration. They are as follows: 1. Election. The representative form of democracy is classified into two kinds: one is the presidential form and the other parliamentary form. The presidential form of government is carried out in the United States, where the president is directly elected by the people. He is the chief executive and enjoys all the powers of the executive under the government. He is not responsible to the Congress, the legislature, but to the people ultimately. Thus there is direct control by the people over the administration in such systems. In the parliamentary form, which is prevalent in India and Britain, the real executive, the cabinet, is drawn from the legislature, and hence they remain responsible to it for its 268 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance 269. Actions and functions. And the legislature in turn is responsible to the people. Thus there is indirect popular control over the administration by the people, in parliamentary form of democracy. In any form of democratic governmental systems, whether presidential or parliamentary, when the government becomes corrupt, inefficient, unresponsive, and irresponsible, it can be removed from the government by way of periodic elections. The elections are means and medium of expression of people's confidence over the elected popular government. 2. Recall. It is a device used in direct democracy. It is seen used in Switzerland and 13 states of the United States where the administrative officials are directly elected by the people. This system of recall helps the people to remove the elected officials before the end of their tenure, when they fail to represent the popular will of the people. In other words, the official has to vacate his/her office before end of his/her term if he/she is defeated in a recall poll. This device is used when the people are dissatisfied with the performance of the elected official while in office, and this process does not require any charges of illegal actions against them. The important aspect of this device is that it enables the people to hold the public administrators continuously responsible for their official acts and duties. 3. Pressure groups. This term originated in the United States. It is a group of people who are voluntarily actively organized for the purpose of promoting interest common to them. Some examples of such groups are trade unions, voluntary organizations, professional associations, student unions, etc. These groups are also known as interest groups or vested groups. They exert pressure on the administration through legitimate and legal methods, such as petitioning, propagandizing, publicity, public debating, and maintaining contact with the legislators and the administrators, etc. They act as the bridge between the administration and its members. However, these groups resort to some illegal or illegitimate methods, such as violent acts, corruption, and strikes which damages the integrity of the administration and cause public disruption. 4. Advisory committees. These are otherwise known as advisory councils or boards. They are attached to the administrative system all the way from the bottom to the top. They consist of expert members, citizens, and other representatives of special interest. They act as the link between the administration and the public. They provide advice to the agencies on how to formulate acts, policies, etc., and on how to implement them effectively. But these recommendations made by these agencies are only advisory in nature and not binding on the administration. However, they act as effective instrument identifying defects in the department and make the administration more democratic in character. 5. Public opinion. This is an informal mode of public participation in administration. This is the opinion of the public regarding the policies of the government. It is expressed through various agencies, such as the public platform, radio, political parties, press, cinema, pressure groups. 269 16 hours 38 minutes and 12 seconds. 270. Educational institutions and television, etc. And among these, independent press is the most effective agency, which acts as a mirror of public opinion. Therefore it is known as the fourth estate of democracy. The importance of public opinion, as a mode of participation by the people, is highlighted in the following points. It keeps the administration responsive and acts as a watchdog over it. It safeguards the liberty of the individual, by keeping check on the unpopular and undemocratic acts and functions of the government. It also acts as a source of law, and it facilitates implementation of the governmental policies. It mainly influences the policies and programs of the government. 6.2.2 Participation in Development Administration. People's participation in development administration means that the people are directly involved in the process of administering development programs meant for bringing socio-economic changes in the society. It has the following dimensions: I. Participation in decision-making process. 2. Participation in implementation process. 3. Participation in the evaluation and monitoring of the program. 4. Participation in sharing of the developmental benefits. People participate in development administration through various agencies, such as the Panchayati Raj institutions, farmers' associations, Mahila Mandals, cooperative institutions, Yuva Kendras, and other voluntary/non-voluntary organizations. The benefits of people's participation in administration are as follows. 1. It helps in selection of project, which is directly relevant to the people. 2. It reduces the financial burden on the government by making the program function even after the removal of its support, with help of local resources provided by the beneficiary people themselves. 3. It acts as a safeguard against the abuse of authority of administration and thus reduces the scope of corruption. 4. It makes the local people bear and accept the developmental change and other issues associated with such change. 5. It promotes the concept of esprit de corps among the people in the community and thus strengthens the democracy at the grassroots level. 6. A wealth of information is provided to the administration regarding the local economic, socio-cultural, ecological, and technical conditions. This information is highly useful in the process of programming, planning and implementation of the development programs. 7. It increases the capability and competence of the people to take up responsibility and solve the problems on their own. It develops the spirit of self-reliance, leadership and initiative among the people. 270 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance. 271. 8. It helps in the facilitation of mobilization of local resources in the form of labor, cash, and materials, etc., which are essential for the successful implementation of the program. 9. It helps in prevention of hijacking of the projects by the richer and powerful sections of the society, as there is involvement of all section, especially the poor and weaker section in the development process. Thus it leads to equitable sharing and distribution of the benefits in the society. However, there are a number of factors which act as impediment for effective participation of the people in the administration. These are as follows: I. Negative political involvement and interference. 2. Improper administrative procedure. 3. Lack of culture of participation. 4. Aristocratic and mechanical bureaucracy. V. Role played by the middlemen. 6. Time constraints, that is, time-bound nature of the activities. 7. Unfavorable socio-economic environment like presence of communalism, casteism, regionalism, illiteracy, and poverty, etc. 8. Presence of corruption and low standards of conduct in administration. 6.3 Why citizens' participation has to be strengthened. Citizen participation in local governance means involvement of the common man in assessing their own needs and also participating in local project planning and budget monitoring. This is important as it improves the public resource management and reduces corruption, by making the public administrators and the politicians accountable to the people. In order for the citizens' participation to work, transparency in providing the government information is needed. Those people whose needs are assessed and for whom the policies are formulated should be involved in the decision-making process. Exclusion of such weak and powerless from this process is one of the cause of poverty, as it denies them rights and creates unequal power relationships in the system. The human rights include civil and political rights, including access to information and freedom of expression. These also form basis for political participation of the people. The citizen participation requires the following: trust in their co-participants and others. Belief that such participation can make some difference. Wholeness, to feel the social inclusiveness. In order to make a strong impact and better participation of the citizens in local governance, they need to understand and involve themselves and participate in local political issues. They should be confident and should have information on where and how to participate. And the local institutions should also be prepared to facilitate such engagement of citizens. 271 16 hours 38 minutes and 12 seconds. 272. Engaging and involving the citizens in local governance can improve accountability, improve ability of the local authority to solve problems, create more inclusive and cohesive communities. There is growth in number and quality of initiatives made by the communities. One of the means to improve such participation and empowerment of citizen is through increasing their access to technology and in particular the social media. Number of grassroots level application has shown the potential of social media in improving and widening the participation of citizens in governance. 6.4 Theories of management related to good governance. A number of theories have been suggested linking management and economics with that of good governance, centering on people's participation. Some of the most important theories suggesting this are as follows: New Public Management, NPM, Total Quality Management, TQM, Public Choice Theory, PCT, Public Value Theory, PVT. All these theories have had impact on the introduction and implementation of the good governance strategies. These theories are explained in brief in the succeeding paragraphs. 6.4.1 Theory of New Public Management. The theory of New Public Management, NPM, emerged around late 1970s and 1980s as the key reform agenda in the OECD countries. The initial aim was to improve the efficiency and effectiveness of the public sector institutions. The philosophical foundation of NPM laid emphasis on locals' participation through the private sector. This loss led to emergence of new organizational economics and managerialism, which is sponsoring new professional management and self-motivation in the center to improved institutional performance. This is regarded as a paradigm shift as the old rules-driven and highly processed management style is replaced by a new strategy which attempts to combine modern management practices with the logic of economics, while retaining the core public values. Researchers generally recognize 8 core elements of NPM, which are as follows: cost effectiveness, greater transparency in service delivery, resource allocation. Traditional institutions are to be decentralized, management efficiency within public sector agencies, disaggregating public service functions from their purchase, introducing stakeholder approaches, performance-based management system, contractual services and performance-based appraisal, increasing the emphasis on service quality, standard setting and public responsiveness. 272 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance. 273. Thus all these elements have transformed the role of the local government into a more active, independent, and economic organization. It has also been said that the present traditional public administration will, in the future, inevitably be managerial, both in theory and in practice. Thus all these aspects of NPM drive the public management to the doors of the local stakeholder and use their local knowledge and expertise to make more effective and sustainable development. In the traditional bureaucratic system, the people were considered to be clients. And now NPM has changed this view by considering them to be customers, and thus use their knowledge to bring about effective development. The client was considered to a passive recipient who obtained services without any exchange, while the customer is understood to be an active recipient who obtains services by exchanging local knowledge. Therefore, the customer poses more rights than the client. Hence, NPM creates an environment that is more transparent, accountable, and predictable, and this in consequence leads to promote and develop good governance at local levels. Other important and essential foundations for NPM in practice as identified by the researchers are as follows: establishing democratic political governance frameworks, bottom-up accountability, local stakeholders, acceptable performance. And today the public value is the principle of NPM, which is in forefront of political agendas of many developed countries. There is also an alternate view that NPM is a threat to participatory work and it obstructs good governance. This is because this approach in improving performance creates a silo mentality which works against networking and partnership. On the other hand, there are other scholars who argue that NPM helps in good governance. In developing countries, the International Development Agencies, IDAs, included this NPM as on the vital preconditions for obtaining the foreign assistance. These IDAs have argued that NPM-based reforms in the country will increase the accountability and efficiency in public service delivery, which will therefore result in reaping maximum benefits out of the aid assistance. Several other scholars have also argued that traditional bureaucratic system has to be replaced by people-oriented NPM to make such reforms effective. Some scholars view good governance and NPM as mutually supportive, since both reinforce each other to enhance accountability and efficiency in public institutions. In order for establishment of good governance, the mentality and attitude of the government officials and the people's representatives should be changed, and NPM can help change the management style to foster good governance. Some of the other scholars indicated that the scope of application of NPM in the developing countries is less encouraging because of inadequate economic, technical, and socio-political institutions. But indeed, NPM has brought quite some changes and reforms in the Western countries. The reforms which were carried out under NPM can be broadly classified into the following heads: marketization, accountability, decentralization, and efficiency. By contrasting the main features of good governance and NPM, a shared dimension between them can be drawn. This can be seen from the following diagram. 273 16 hours 38 minutes and 12 seconds. 274. Some scholars do call for training of the sustainable development managers to effectively survey and engage local people, collect data, and translate those findings into meaningful statements which can be used to support informed discussion, which is possible by introducing NPM. World Bank calls for the government and the elected officials to be transformed as change agent for the implementation of good governance. The World Bank also viewed the public managers as agents of development. They must be resourced and equipped for such role. When governments move beyond NPM, new avenues involving community and local knowledge enter the public administration with consequences of changes in skills needed for the administrators. From the above analysis, it can be seen that NPM envisions rule for the people while good governance calls for rule with the people. While NPM helps bring the officers themselves to open the door, good governance equips and empowers the local communities to open the door for the officials. This means that NPM teaches the officials to treat people as customers and open the door to invite them in. In contrast, good governance is for empowering the people as citizens of the society to open the door. Hence both these acts are required at the same time for creating a congenial and non-conflicting situation for establishing good governance. Efficiency. Managerialism. Business process reengineering. Local-based strategy. Locally sustainable programs. Accountability and transparency. Performance management. Program budgeting. Local business focused. Shared dimension with good Governance. Performance-based management. Sharing local knowledge. Reinventing government. Enhancing accountability. Customer focus management. Decentralization. Reallocation of responsibilities from central to local authorities being local devolution, sharing views with local stakeholders, marketization. Competitive and best practice. Contracting local partners. Participatory monitoring. Risk sharing. Local market-based decision. 274 16 hours 38 minutes and 12 seconds. 6 Citizens' participation in governance 275. NPM has indeed brought in potential for changing the traditional governing process. Through implementation of NPM, the governing process has become multifunctional opposed to the traditional unifactorial state that runs services to the people. This might open up new avenues for the local people to envision governance process at local levels. 6.4.2 Total Quality Management. The fundamental philosophy of Total Quality Management, TQM, is to in all activities concerned in an institution maintain professionalism and perfection in them. It gained prominence among the scholars and practitioners during the 1990s. Since then, this theory has got established itself as a system for improving the performance of the institutions and raising the satisfaction of the customers. TQM is said to have both internal and external focus on an institution's business management. The core values of TQM identified by the scholars are as follows: management commitment, local-based decision, customer focus, process focus, continuous improvement in delivering of services. Though the concept of TQM is generally exercised within the enterprises, it can also be used in public sector as well. The important suggestion of the TQM experts is knowing and understanding the local people first for improving quality of services in the public sector. According to the external customers, the management activities related to the delivering of the public services should be improved. And today, the aim of a good public management is to effectively design the services that makes sense to citizens, business, and international clients. TQM has internal focus too, as in, it is focused on improving the internal management to effectively deliver customer service. Today both customers and employees are central to the governance phenomena. And hence any strategy to improve the service delivery should read the society and local places. The TQM is focused on its internal employees, as it believes that if the quality of employees is improved, then customers automatically receive quality service. And hence when performance of employees are improved, the performance of service delivery is also simultaneously improved. Hence the common element of TQM and good governance are to recognize the importance of the local people for the development of the institution. The important elements are as follows: overcome barriers in networking with the external customers, that is, local people, improve relationship between the institution and its beneficiaries, restructuring of the administrative functions and process and motoring the performance of the officials, making them accountable to the beneficiaries. Thus, idea underlying the concept of TQM influence is good governance. 6.4.3 Public choice theory. This theory originated within the economics arena. It basically focused on people's choice in selecting the public service. This theory considers the public as buyer of the best product and hence conceptualizes market-like competition in public service delivery. The public choice. 275 16 hours 38 minutes and 12 seconds. 276. Theorists argue that monopolistic production of goods by both private and public sector leads to inefficiency in service delivery management. The application of strategies elaborated by the public choice theory, PCT, makes the institutions provide innovative, cost-effective, and locally sustainable products. In order to follow this strategy, the public institutions have undergone more decentralization and the public service delivery has been outsourced. It is suggested based on evidence that better efficiency comes from competition rather than public or private nature of the organization. Implementation of this theory thus is advantageous to the local people and other beneficiaries over that delivered by the public officials. PCT has also introduced participatory implementation and monitoring of the local public service delivery mechanisms. Thus the core concept of good governance matches with the central element of participation in PCT. Therefore it can be seen clearly that PCT matches with the concept of good governance because of having the following characteristics: management functions has to be decentralized to local levels, and it has to be shared with the local stakeholders to provide services according to choice of the local people. The role of central government in providing public service has to be reduced and local people should be influenced to create best innovative local institution. The traditional management has to be re-engineered to make it more people-focused. Civil, private, and the NGOs should be increasingly involved to make the service delivery locally sustainable and more efficient. Local knowledge and resources should be used to get cost-effective and best alternative choices for service deliberation. 6.4.4 Public Value Theory. The basic and fundamental assumption of the public value theory, PVT, is to provide services according to the interest of the public. Public interest is defined as what people would choose if they thought sensibly, saw clearly, and acted generously and disinterestedly. Thus this theory calls for desired outcomes of public programs and participation of the expected beneficiaries to see the outcome of the public services when delivered by the government bodies. The concept of PVT operates at the highest levels, such as in the philosophical discourses about the public interest, or at the operational levels, whereby focus is on the desired outcomes. Thus this theory persuades the public institutions to recognize the public value of goods, resources, and services and to effectuate the procedure under what is the public best served. The concept of public interest was seen a few decades ago as too vague, too value-loaded, too conflicting and too ambitious with the policies of group accommodation, but today, even in the developing countries, the public programs and policies are leveled as for the public interest. This idea of embracing the people and their interests makes the government to introduce good governance, which is transparent and conceivable by the people, especially when such program is introduced by the development agencies. Recently researchers have suggested to move beyond the NPM's framework towards new and alternative paradigms, such as public value management, a way of thinking which is both post-competitive and post-bureaucratic. 276 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance. 277. Theory of public values states that public sector can stay alive and effective by creating public value through proper and successful practice of public management. It is also said that this concept turned the old bureaucratic practice of service delivery towards a new way of thinking, by incorporating people's interest and choice for the services rendered. PVT envisages a more proactive and political role for the public sector managers. The role of public sector managers included managing up to authorizing level and also managing to the citizen level. Thus this theory included that public officials and other representatives should include people at the center of making decisions for service delivery. And, thus, it also pursues the ideal of good governance as it both focuses on the people. 6.5 Contextualizing people's participation. Traditionally, people in a democracy use their right to elect their representatives who then hold the public administrators accountable for implementing any decisions that affect the people. This is the common practice followed in any representative democracy or representative local governance, where the people elect those who rule them. This means that people should participate in the governing process through their representatives to get services from the government. This scenario is changing as people do want themselves to be considered as clients in the representative form of democracy. Today, especially in developed societies, the citizens want to put forth their opinion regarding any decision that has effect over them in the future. It is identified by many scholars that representative democracy is not working as expected to meet the needs and aspirations of the people. They call for direct democracy, where the people will be directly consulted to recognize and implement their desired programs. This form of direct democracy is in consonance with the concept of good governance, which supports the view that involved citizens become more informed and eager to dedicate their time in pursuit of finding a solution. Hence today, many academicians, politicians, civil societies, and donor agencies call for direct participation of the people in the governing process. It is believed that people are entitled to participate in all such public affairs which have effect on their lives, and such participation will remain at the heart of today's governance. Presently there is also increasing awareness among the people in matters of public affairs which, therefore, has forced the government to share their authority with the people. Hence the best outcome of this process has forced all concerned institutions to place the people at the center of governance. Thus the term governance has been defined as not only working with the people but also being accountable to the people, being transparent to the people and following laws of the local people. The attributes of good governance, as pointed out by the international development agencies, indicate a growing emphasis on economic development through effective people-oriented government process, that is, governance. The governance indicators, such as the accountability, efficiency, transparency, participation, effectiveness, etc., need to meet the public belief of good governance. 277 16 hours 38 minutes and 12 seconds. 278. Even though all the four elements of good governance are mutually supportive of each other, we can find that people's participation is central element among these. That is, a people participatory government ensures more transparency, is more accountable, and ensures predictability governance to its people. Therefore good governance is considered to be not just pro-people of people-centered, it has to be owned by the people themselves. Good governance is also otherwise described as government for the people, transparent to the people, accountable to the people, stand by rule of people and for the betterment of the people. This is similar to the Gettysburg Address by Abraham Lincoln, where he called the democratic government as government of the people, by the people and for the people. This means that the people are at the heart of true democracy. Thus a true democracy should ensure the participation of its citizens not just at the central level, but also at the local level. In 1989, the Organization for Economic Cooperation and Development, OECD, released a policy statement on development cooperation in the 1990s which stated that the participatory development is the most important issue on development aid agenda for the years to come. Governance means that involvement of number of actors in the decision-making process brings together multiple actors, for example, state, corporate, private sector and the civil society. In process of governance, the state is only one of the actor, and the others being the civil society, which is the people, the beneficiaries of the decisions. This is understood that people become inseparable part of the decision-making process and in the implementation of the decided programs. Through proper and effective policies and regulations, government can open the door to let people in to take part in the decision-making process that has an effect on them. And this does not mean that people will come forward immediately to take part in such processes. What needs to be done is that the people have to be empowered enough to make them come forward and take active control to make decisions for themselves. And when people are empowered, even if the government is unwilling to let the people in, they themselves will force it to open the doors for them. Empowered people will come forward and participate and protest against any anti-people decisions. Hence, particularly in developing societies, where people are illiterate, not united and not aware about their rights, they need to be empowered more with more participation. In fact, in developing countries, good governance would not be attained unless participation of the people is ensured at the local level. It is argued that it is logical that development should start with people, as development is about improving the lives of the people. World Bank defines participation as a process through which people share and effect control over the development initiatives and the decisions and resources which affect them. It is also defined as the process by which the members of the society share power with the public officials in taking important decisions and actions related to the community. Most scholars consider participation as central to sustainable development programs, even though it might cause some delay, or increase in cost or raise some conflicts. Participation is considered to be a social transformation mechanism, where the power is transferred from the implementing agency to the civil society. 278 16 hours 38 minutes and 12 seconds. 6. Citizens' participation in governance 279. The following is the World Bank report, which described 4 categories of people's participation for different kinds of programs. Their 4 categories are follows. 1. Information sharing. Service providers like the project designers and managers inform the local people in order to facilitate action by them. Information helps the locals to understand and perform their tasks better. In family planning and nutritional programs, such information sharing works better. 2. Consultation. The local people are consulted at every key stage in a project cycle. There is opportunity for the people here to interact and provide feedback to the service providers, which could be included in the design and implementation stages. If the farmers are consulted during the extension programs and arrangements, the project outcomes are likely to be better than that when they were merely informed. 3. Decision-making. This happens when the beneficiaries have a decision-making role in matters of program design and implementation. Decisions can be made jointly with the service providers on certain issues related to the project. Thus, slum dwellers may be involved in the process of upgrading their house together with the project staff on the design. 4. Initiating action. In this category, the beneficiaries are able to take initiative in terms of actions/decisions pertaining to the project. This implies a proactive capacity and confidence to get the services on their own. The beneficiary group identifies a new need and decides to respond on its own. They are thus taking initiative for their own development. However, other researchers argue that people's participation is a continuous process, and it passes through a number of stages. Accordingly, people are first informed, and then they reach control position of a decision through continuous participation process. People therefore should participate from or before the beginning of a project so that they can take effective control over the project for the sustainable use of the outcomes. The following are the various stages of people's participation as identified by number of studies and scholars. 1. As per the International Association of People's Participation, A. Inform, one-way communication. B. Consult, two-way communication. C. Involve, participatory process. D. Collaborate, partnership. E. Empower, implementing what public decides. 2. A metaphoric 8-rung ladder of participation as developed by Arnstein. A. Manipulation. B. Therapy. C. Informing. D. Consultation. E. Placation. F. Partnership. G. Delegated power. H. Citizen control. 279 16 hours 38 minutes and 13 seconds. 280. 3. A study carried out by Wilcox identified the following 5 stages. A. Informing. B. Consulting. C. Deciding together. D. Acting together. E. Supporting independent community interests. 6.6 Use of tools for people's participation. Governments use different type of instruments to create awareness for different levels of engagement to develop awareness in the local community. Here the term instrument means the device used by the organizations to sustain and organize people's participation. In the World Bank report in 1987, Samuel Paul described the following 3 instruments used for people's participation. 1. Field workers of the project agency. A project may use its field staff to mobilize and interact with beneficiary groups. They operate at the grassroots level and yet are part of the project agency. In agricultural and irrigation projects, field workers are often used to organize and interact with farmer groups. Field workers' orientation and commitment to citizen participation are key determinants of their effectiveness as instruments of citizen participation. Training can be used to influence their community mobilization skills and attitudes. If they see themselves primarily as agents of the government or donor, their ability to promote and sustain citizen participation is likely to suffer. If this perception is also shared by beneficiaries, the chances are that field workers will not be able to facilitate citizen participation except at a relatively low level of intensity. 2. Community workers/committees. A project agency may draw upon workers or volunteers from among beneficiaries to act as community mobilizers. Such persons may or may not be paid by the agency. However, in all cases, the community may have had a say in their selection and the roles they play. If they are selected through a community consensus or a consultative process, they are likely to identify better with the community's problems and feelings and facilitate citizen participation more effectively. Instead of community workers, committees which represent beneficiaries may be organized as an instrument of citizen participation. Where large numbers of people are involved, committees are a useful device for beneficiaries to reach higher levels of citizen participation intensity, provided they truly represent the community's interests. Committees have acted as a citizen participation instrument in several primary healthcare projects. 3. User groups, where the number of beneficiaries is manageable either because of the local nature of a project or the specialized nature of the group, farmers, mothers with small children, etc., it is possible to organize viable groups of users as an instrument of citizen participation. This instrument has the potential to reach the highest level of citizen participation, though its creation and sustenance are the most complex. User groups may operate at any level of intensity and, over time, may rise from one level to another. Of all the instruments, user groups are likely to involve the maximum number of relevant beneficiaries in a given project context. The use of one instrument, however, does not preclude the use of others. User groups may coexist with community volunteers or committees. 280 16 hours 38 minutes and 13 seconds. 6. Citizens' participation in governance 281. Unlike field workers, who by definition can be organized only through external intervention, e.g., by the project agency, it is conceivable that user groups could be created through the medium of internal leadership or external intervention. Where user groups are energized by local leadership, the intensity of citizen participation is likely to be high. Intermediary organizations, such as NGOs, can also be a medium for the use of any of these instruments. Needless to say, it will take a highly committed NGO to create and sustain user groups at a high level of citizen participation intensity. 6.7 Relationship between people's participation and good governance. The level of good governance increase through effective participation by the people in development programs. The Japan International Cooperation Agency in 1995 reported that good governance is the foundation for the participatory development inasmuch as it provides the government methods needed to encourage the people's participation and create environment where they can participate effectively. Such effective participation by the people can enhance the transparency of the developmental works, increase the accountability of the implementing authority, compliance with the local law, and which therefore consequently establishes good governance. Thus, this indicates that people's participation and good governance are inseparable from each other. The Japan International Cooperation Agency, JICA, in 1995 developed a diagram showing the link between the participatory development and good governance, which thereby can enhance democracy in the country. This is presented as in Fig 6.1. There are various other models of governance developed by number of scholars, on the basis of interaction between the citizen and the government. They can be seen as follows. 1. Managerial model. The people here are seen as passive recipients of information. The governing bodies unilaterally deliver message to the people. This is a top-down approach of implementation. 2. Consultative model. This model is direct contrast to the managerial model. In this, the governing body uses information to inform people, which therefore facilitates communication between the government and the people. This model is also called as the pull model as it reduces the gap between the citizens and the government. 3. Participatory model. In this model, the proper information is provided to the people, which facilitates their involvement in the government programs. There are no practical barriers to the involvement of the people. The power of this information helps people to form civil society. Almost all sections of the society are involved in the decision-making process. Mutual understanding and assistance helps to achieve the goal. 4. Disciplinary model. In this model, people when they are fully empowered may initiate collective social programs. This model imposes responsibility the local governing bodies to provide for better policy to the people. 281 16 hours 38 minutes and 13 seconds. 282. 5 Network model. In this model, the reciprocal communication between the parties develop trust in each other. The collaboration and networking between the service providers and the receivers evolve in a friendly environment. 6 Community empowerment model. It is a bottom-up approach. It happens because of extensive participation from the community. Figure 6.1 Relationship between participatory development and good governance. Development aimed at self-reliant, sustainable development and social justice. Participatory development. Good governance as the basis for participatory development and as the ideal orientation of government services supporting participatory development. Efficient government functioning, or the process of making government functioning more effective through the process of efficient policy making and administration. Democratization. Good governance. Good governance as conceptual elements of state aspiring to democratization. Legitimacy. The concept of state embodied in administrative functions/services supporting participatory development. Aims at self-reliant, sustainable development through active participation in development activities by the people who, in a variety of development aspects, are most enhanced by the process of development and by participation in development as agents and beneficiaries. Accountability. Securing of human rights. Local autonomy and devolution of power. Civilian control. Legislative and institutional building. Ensuring administrative capability and transparency. Decentralization. Enhancement of the market environment. 282 16 hours 38 minutes and 13 seconds. 6 Citizens' participation in governance. 283. From the above we can draw the correlation between the various stages of participation and the model of governance associated with it. This is depicted in the table below. Stage of participation model of governance. Stage 1, inform. It is a one-way process, where the governing agency tells the people the decision it takes before or during the implementation of programs. Authoritarian model. In this model, the decision is taken from the top and it trickles down. It is mostly implemented by the bureaucrats. This program process is not transparent, predictable, or accountable. State 2, consult. It is a two-way communication, but, here the engagement of the people is limited in the decision-making process. The feedback is got from the people, but the governing agency unilaterally makes decisions and implements them. Bureaucratic model. In this model, people's participation is not enough to transfer of the power. The program process is less transparent and less predictable. The implementing agency is accountable not to the people but to its superiors. State 3. Involve. In this model, the view of the participants are not only listened, but they are also engaged during the implementation stage. They are also engaged during the budget discussion and program implementation. But the entire community is not involved in this process. Political model. In this model, the people's participation is sought and they are engaged. But here the participation is carried out only by certain segment in the society, which leads to raise in tension and conflicts between different interest groups. The governing body is transparent and accountable not to the whole community, but rather to a section of the populace. Stage 4. Empower. At this stage, the governing body allows the people themselves to directly get involved in the decision-making process. They are encouraged to come up with their own decisions and resources to implement the development programs together. Here the governing body works as a facilitator. Democratic model. This model allows for developing partnerships between people and the governing body. The authority is delegated to the people to take decisions and to implement program by sharing of local knowledge. The entire process is completely transparent, predictable, and accountable. 6.8 Models of good governance on the basis of participation levels. The following are the models of good governance based on the basis of people's participation. 1. Authoritarian model. This model evolves when the people's participation is at the information level. Here the decisions and the resources come from the top. The implementation of the project is carried out by the bureaucrats of the local agency, by following traditional, rigid processes and where the people are treated as passive recipients of the services. Authorities use local representatives or some display board or snail mail to inform the people regarding the development programs. The entire process is not transparent or accountable. It therefore has low accountability, low transparency, low predictability, low participation. 283 16 hours 38 minutes and 13 seconds. 284. 2. Bureaucratic model. This is the model which develops when the people's participation is at consultation level. In this model, the governing agencies consult with the people and use resources of the people. But they do not share power with them in making decisions or policy. The participation is not complete/full enough to allow people have knowledge about the resources, hence, this leaves scope for corruption. A public meeting is usually conducted for consultation. The authorities treat the people here as either customer or clients as they do not share the whole process of project implementation. Despite the governing body remaining accountable to the people, it is still less transparent and less predictable. Therefore this has accountability, less transparency, less predictable participation. 3. Political model. This model evolves when the participation is at the stage of involvement. Here the governing agency shares knowledge, authority, and resources with the local people in order to take decision to implement the project. Moreover, the important aspect of this model is that the people and the governing body jointly form a kind of coalition where both these parties share histories, values, rituals, and other common interests, and thereby establish a more cooperative network to develop any program. And the problem arises when only a particular faction of people are engaged in such consultation process. The people here are treated as partners, players, but the trust between the governing body and the locals remain weak as the only a segment of population is involved in consultation process. Thus predictability, transparency, and accountability are high in this model, albeit only for a section of the society. Therefore this has high accountability, high transparency, high predictability, segmented participation. 4. Democratic model. This model evolves gradually as people attain empowerment. This model calls for developing partnership with people, implementing programs, delegating authority to make decision, by sharing the local knowledge, resources, and values. Participatory planning and strategic decision-making, which enable the development of a common vision, effective, efficient and transparent management which create a positive joint working environment. Predictability, transparency, and accountability are relatively high. This is the most rational model, as the people here are considered as stewards or navigators. But the authorities here should be open, flexible, and encourage the development of such a model. Therefore this has high accountability, high transparency, high predictability, high participation. 284 16 hours 38 minutes and 13 seconds. 6 Citizens' participation in governance 285. Hence democratic good governance can be achieved by proper cooperation between governing agencies and the local people. On the one hand, the governing agencies should come closer to the local people by extending and smoothing the pro-people systems and approaches. On the other hand, to make effective joint decisions, the local people have to be empowered enough. Only through such reciprocal activities, people's participation can be made effective enough to achieve good governance. 6.9 Effective participation for good governance. World Bank defines effective participation as a process through which people influence and share control over the development initiatives. Thus the word effective means situations where the participation of the people makes a difference within the decision-making process or the policy outcome of the government. Thus it means more empowerment of the local people, and when people are more empowered, there is more accountable, more predictable, and transparent government. And this makes the people's participation in the local development more effective. But empowering people alone will not be enough to achieve good governance. The governing agents at the local level, the officials have to change their attitudes to welcome people to the decision-making process. As the term good governance means, creating a bridge between the governed and the government, hence both officials and the local people need to cooperate with each other to uphold the value of direct people's participation. On the one hand, an effective, robust participatory system and laws complementing them should be made to build the capacity of the local governing agencies. And on the other hand, high social capital and strong civil society groups are required for the empowerment of the local people. Thus the effective network between the governed and the governing bodies depend on fulfillment of some normative elements in the society, such as the equity, empowerment, and power balance and social capital. The two major aspects of developing social capital are social norms and trust, which help people in networking with each other. People share values, concerns with help of such networks, and this consequently transforms into group energy. This group energy then helps to hold the local authority accountable for delivering of services and development. In this way, social capital can be used to achieve good governance. Both the people and the governing agencies should act mutually to develop trust and norms, that is, social capital. Effective participation in a society is not possible if its normative values are not adhered to. Local stakeholders, those who are in networks with the social capital, have to be included in consultations for the development of policies of the government that can ensure effective participation of the people. For a long time, governments in various countries have been following technocratic policy analyses for making the public management systems more effective. This meant that the governmental agencies did not include the local people, or did not use the knowledge of the local people, for making decisions that would have effect on the local people. In contrast to this approach, scholars have suggested that local elements and knowledge have to be considered. 285 16 hours 38 minutes and 13 seconds. 286. In making a public system sustainable. The participatory policy analysis helps to find out the actual problem and identifies ways to overcome them. Therefore, local knowledge and normative elements should be considered when planning on how to make local government more sustainable by warranting effective people's participation. 6.10 Citizen and administration welfare orientation is the characteristic of a modern democratic state. Hence, the government has come to play a significant role in socio-economic development of the nation. This has resulted in the expansion and growth of the bureaucracy and multiplication of the administrative process, which has resulted in increased administrative discretion and power enjoyed by the civil servants at various levels of government. Such discretionary power might result in harassment, malpractices, maladministration, and corruption. Hence, such a situation gives rise to citizens' grievances against the administration. The success of a democracy and realization of socio-economic development lies in the fact that grievances of the citizens are effectively addressed. Hence, the following institutions have been created across the world in order to effectively address the citizens' grievances: the Ombudsman system, the Administrative Courts system, the Procurator system. The Scandinavian Ombudsman is the earliest of the institution in the world, which was created to address the grievance of the citizens. Ombudsman is called to be a unique institution which is appropriate for dealing with the complaints of ordinary citizens about the unfair actions taken by the administration. 6.10.1 Ombudsman system. The first institution of Ombudsman was created in Sweden in 1809. The term ombud is of Swedish origin, which refer to a person who acts as a representative of another person. The ombudsman also refers to an officer who is appointed by the legislature to handle complaints against the administrators and the judiciary. The following matters are dealt by the Swedish ombudsman: maladministration, that is, inefficiency in achieving the targets; nepotism, supporting one's own kith and kin for employment and various other purposes; administrative discretion is abused; official power and authority is misused; discourtesy, use of abusive language and misbehaving with the people; and corruption in administration, asking for bribe for doing official work. The ombudsman is appointed for a term of 4 years by the Parliament. He/she can only be removed by the Parliament on the grounds of loss of confidence in him/her. The annual report is submitted to the Parliament, hence he/she is also termed as Parliamentary Ombudsman. But he/she is independent of all the 3 institutions: legislature, executive, and the judiciary. It is a constitutional authority, which enjoys power to supervise the compliance of rules and regulations by the administrators, and verify whether they are performing their job properly. Hence, in other words, we can say that the ombudsman keeps a watch over the civil. 286 16 hours 38 minutes and 13 seconds. 6. Citizens' participation in governance. 287. Judicial, military officials, so that they function objectively, impartially, and legally in accordance with the law of the land. But he/she does not have the power to reverse or quash a decision, and he/she has no direct control over the administration and the judiciary. The ombudsman acts either on the complaints received from the citizen or on his/her own, that is, suo moto. He/she has the power to persecute any official, including the judges. But he/she has no power to impose any punishment. He/she can report to the higher authorities to take necessary action against the erring officials. The following are the characteristics of the Swedish ombudsman: impartial and unbiased inquiry into the complaints received, unlimited and uninterrupted to all files related to administration, a very wide publicity is given for its functioning in the media, it has suo moto power to initiate investigation, it is a very direct, cheap, informal, and speedy method of handling the complaints, its action is independent from the executive, and the report is submitted to the Parliament and not the executive. The institution of ombudsman is based on doctrine of administrative accountability to the legislature. From Sweden, this institution spread to other Scandinavian countries, such as Finland, 1919, Denmark, 1955, and finally Norway, 1962. The country of New Zealand was the first from the Commonwealth nations to adopt this system in the form of appointment of a parliamentary commissioner for administration in 1967. And nearly 40 countries have adopted this system of ombudsman in one form or the other with different nomenclature and functions. In India, this system is called as Lokpal and Lokayukta. The system of ombudsman is the bulwark against the official tyranny by the democratic government. It is considered to be institutionalized form of public conscience. The administrative court, which was first developed in France, also acts as an important instrument for redressal of grievances of the citizens. Because of its successful functioning in France, this system has been adopted in a number of countries around the world, such as in European countries like Belgium, Greece, etc., and other African countries. The procurator system operated in socialist countries like former USSR, Hungary, Poland, China, Czechoslovakia, and Romania, etc. This was the system used to address the grievances of the citizens. The office or Procurator General is still operational in Russia. He/she is appointed to office for a tenure of 7 years. 6.10.2 Institutions in India. The following are the existing legal and institutional framework to address the grievances of citizens in India. Special Police Establishment, 1941 Delhi Police Establishment Act, 1946 Central Bureau of Investigation, 1963 State Vigilance Commission, 1964 Lokayukta in States Divisional Vigilance Boards National Consumer Disputes Redressal Commission Commission for SCS and STS. 287 16 hours 38 minutes and 13 seconds. 288. Directorate of Public Grievances in the Cabinet Secretariat, 1988 Anti-Corruption Bureau in States Public Servants, Inquiries, Act, 1850 All India Services, Conduct, Rules, 1954 Prevention of Corruption Act, 1947 Supreme Court and High Courts in States Central Civil Services, Conduct, Rules, 1954 Administrative Tribunals Parliament and its committees Vigilance Organizations in the Ministries/Departments, Attached, Subordinate Offices and Public Undertakings Indian Penal Code, 1860 Railway Services Conduct Rules, 1956 File to Field Innovative programs operate in some states, e.g., Kerala, where administration goes to the village and hears the grievances of the people directly in the field, and take immediate action. 288 16 hours 38 minutes and 13 seconds. In this, you will learn about British Constitution, American Constitution, Chinese Constitution, Swiss Constitution, Japanese Constitution, French Constitution. 7.1 British Constitution. 7.1.1 Introduction. The Constitution of present United Kingdom has evolved from the past, which contained smaller states, and has been continuing till the present. The defining feature of the British Constitution is its unwritten form. Absence of a constitution does not mean Britain does not have one, it does, but it is unwritten, and other elements, such as statutes, judicial precedents, conventions, treaties, etc., collectively form together the essence of constitution. Hence it is termed as uncodified constitution rather than unwritten constitution. According to Monroe, the British Constitution is a complex amalgam of institutions, principles, and practices. It is a composite of charters and statutes, of judicial decisions, of common law, of precedents, usages, and traditions. It is not one document but hundreds of them. It is not derived from one source but from several. It is a child of wisdom and chance. Comparison of Indian constitutional scheme with that of other countries. 7. 289 16 hours 38 minutes and 28 seconds. 290. 7.1.2 Sources of the British Constitution. A. Conventions. British Constitution is based generally on the traditions and conventions of the English society. Without these conventions, it is difficult work with it and they are considered to be sacred. Most of the fundamental features of the Constitution is based on the conventions only. Therefore, the conventions are called as the living soul of the British Constitution. Let us now look at some of the important conventions. I. Collective responsibility of the Cabinet to the Parliament. 2. Appointment of leader of largest party as the Prime Minister. 3. King or Queen should accept the advice of the Cabinet. B. Charters. The great charters and agreements provide the source for constitution defining the powers of the Crown, rights of the citizen, etc. These charters have gained historic importance and hence act as guide to the Constitution. Some of the important charters are as follows. I. Magna Carta, 1215. 2. Bill of Rights, 1689. 3. Act of Union with Scotland, 1707. C. Statutes. The statutes or laws are passed by the Parliament from time to time and hence act as important source for the Constitution. The British Parliament has full power to amend and/or remove these statutes any time it wishes. Some of the important statutes are as follows. I. Parliament Act, 1911. 2. Representation of Peoples Act, 1918. 3. Indian Independence Act, 1947. D. Judicial decisions. Judgments and interpretations of British courts act as another important source of constitution. These judgments, interpretations, etc., define the validity, scope of the statutes, charters and the common law. These judiciary act as vanguard on upholding the constitutional values, hence Dicey termed the British Constitution to be a judge-made constitution. E. Eminent works. Eminent works of great scholars too serve as basis for constitution. Dicey's Law and Constitution, Blackstone's Commentaries of English Constitution, etc., are some of them. F. Common law. The common law exists apart from the statutes and the charters. These are generally not in written form but have evolved from historical growth of the British society. These are important rules and regulation which are based upon the customs and traditions of the English society and which are later validated by the courts. The right of trial by jury, right of freedom of speech and assembly, etc., are some of the important common laws. 290 16 hours 38 minutes and 28 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 291. 7.1.3 Salient features of the British Constitution. Let us now look at some of the fundamental aspects of the British Constitution. A. Partially written and partially unwritten Constitution. The British Constitution is mostly in unwritten form. The written form consists of important parts like the Magna Carta, Bill of Rights, etc., but the unwritten form is more remarkable and noticeable. What unwritten here means is that unwritten part of the Constitution is larger than the written part. The written part of the Constitution was not created at a single instance. Whenever statutes, laws were enacted, it was not for improving the Constitution, they indirectly helped in identifying the values of the Constitution. Thus the British Constitution is largely based on traditions and conventions of the English society. B. Evolutionary. The British Constitution is the oldest of the written constitutions. It has been in continuous usage without any change for the past few centuries. British society also has not faced any drastic revolutions like the French or the Russian. The basic idea of the Constitution has grown like an organism from period to period. It has been evolutionary and gradually the constitutional values and ideals were incorporated in various statutes, laws, conventions, and traditions. C. Difference in theory and reality. Many features which exists as constitutional features are not practiced in actual practice. In theory, All power of government rests with the Crown. All laws should receive consent of the Crown. King is the commander-in-chief of all forces and only he can declare war and conclude peace treaties. Thus in theory, British government is an absolute monarchy and in actual reality it is democratic republic. The King presently is just a figurehead and no real power is vested in him. The people via the Parliament are more powerful than the Crown. d. Parliamentary sovereignty. Legally, the British Parliament can do anything, save just make man a woman or woman a man. There is no law which the Parliament can make. Everything comes under the purview of the Parliament and changes can be brought by simple act. It can abolish monarchy, abolish House of Lords, prevent someone from attaining the throne and deprive all powers of the Crown and many more. The important aspect is that no court can question the legality of such acts. Laws cannot be struck down like in India or America for being ultra vires of the Constitution. The British Parliament is both the law-making and the constituent authority, and there is no legal difference between them. Unitary constitution in India and America. Some of the powers are vested with the regional governments, and it is shared between the centre and the states. But Britain is not a federation or union of states, and hence it has a unified constitution. Powers, thus, are completely appropriated by the government with its head at London. Though local governments exists, they derive power from the Union, which can give greater or deprive of the present powers of the local governments. Thus, British Constitution is unitary in essence and practice. 291 16 hours 38 minutes and 28 seconds. 292. F. Flexible Constitution. There is no separate procedure for amendment of constitutional provisions, it is passed like any other bill requiring simple majority. Constitutional law is thus treated like any other law, making it flexible. Thus British Constitution can adapt itself to new conditions easily. G. Rule of law. Though it is not explicitly stated, rule of law is inherently present in the British Constitution. We may see that British Constitution does not contain defined provisions for protection of its citizens unlike in America or India, but the British citizens are well protected and their rights are derived from the presence of rule of law. All institutions, the King, Parliament, courts, even the citizens are subject to it. Tradition and public opinion upholds the ideal from any infringement by the Parliament. H. Parliamentary form of government. Unlike America's presidential style, England follows a parliamentary form of government. The King Crown is the nominal head of the state and the Prime Minister acts as the head of the government. The King listens and adheres to the advice of the ministers. And the ministers are collectively responsible to the Parliament. Being themselves the member of the Parliament, there is less conflict between the executive and the legislature, leading to smooth functioning of the government. I. Separation of powers combined with concentration of responsibility. There is strict separation of power between the executive, legislature, and the judiciary. Each institution performs its function separately without encroaching on another. But the cabinet in England has come to play a very prominent role. It controls the agenda of the Parliament and to an extent even influences the judiciary, thus cabinet is called as the steering wheel, which steers the ship called the government. J. Blend of monarchy, aristocracy, and democracy. The British Constitution is a balance between monarchy, aristocracy and democracy. The Crown King represents the monarchy, the House of Lords, the upper house, represents the aristocracy, and the House of Commons represents the lower house, giving representation to the common man, thus upholding the ideals of democracy. Though the powers of monarch and aristocrats have been drastically reduced, they have not been scrapped. These institutions serve as remnants of the bygone era, serving little purpose in the present. K. Bicameral legislature. British has a bicameral parliament. The House of Lords, having hereditary membership, is the upper house and the House of Commons is the lower house. House of Commons is more powerful than the upper house. It is elected by people having universal adult franchise. 7.1.4 Executive Cabinet is the real executive. The Crown obeys the advice of the Cabinet. Thus, the Cabinet is central to the functioning of the government. However, there is difference between the Ministry and the Cabinet. The Ministry has larger composition and they do not meet as a body and hence do not have collective function. Whereas Cabinet consists of members of the Ministry, it the circle within the circle of the Ministry. The Prime Minister appoints his inner circle consisting of most important members to advise him, to formulate policies and to implement them. 292 16 hours 38 minutes and 28 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 293. The important feature of the Cabinet is the exclusion of the King from the Cabinet. The King does not preside over it. Since the Cabinet members come from the Parliament, and Prime Minister is the leader of a majority party, there is complete cooperation and harmony between the Parliament and the Cabinet. Ministerial responsibility is the inherent feature of the Cabinet system. There are two kinds of responsibilities, legal and political. Legal responsibility comes from the fact that every law that is passed is first signed by the King and the minister responsible for it countersigns it. Hence, in case of illegality, the minister is held responsible and not the Crown. Political responsibility comes with the collective responsibility of the Cabinet to the Parliament. They either sail or sink together. Prime Minister is the leader of the Cabinet, and the ministers work under him. Being from same party gives the Cabinet political homogeneity, which helps its smooth functioning. The Cabinet has both individual and collective functions. As individuals, the ministers are in charge of departments and carry out its functions. Collectively, the Cabinet is responsible for final determination of policy which is to be submitted to the Parliament. It exercises complete control over the national executives, and Cabinet also helps in cooperation and coordination between various departments, thus helping in effective functioning of the government. Prime Minister is the leader of the largest party of the Parliament. He is called upon by the King to form the government. Prime Minister recommends the names of the members to be appointed as ministers and as the Cabinet. He is free to choose whom to be included in the Cabinet. He allocates each minister his/her portfolio. He can also reshuffle/remove any minister as it comes under his discretion, as he is the head of the government. He coordinates the work between the Cabinet members. As chairman of the Cabinet, he summons and prepares agenda of the meeting. Prime Minister is thus called as the keystone of the Cabinet, without whom the structure would cease to exist. Apart from his important role in the Cabinet, the Prime Minister acts as the leader of the House of Commons. He acts as the representative of the Cabinet in the House and presents the Parliament the agenda of the government. Another most important power of the Prime Minister is his power to dissolve the government. Only he can recommend the Crown to dissolve the House and propose a date for election. Prime Minister also acts as the important channel of communication between the Cabinet and the Crown. In his capacity as head of the government, he is the chief advisor to the Crown. In the international stage, the Prime Minister represents the nation. He formulates the foreign policy. The most important part of the executive is the Crown. It has the supreme executive authority. It can declare war or peace, appoints all the executives, supreme command over the armed forces, conducts the foreign relations. But in reality, the Cabinet exercises all these powers. The Crown acts per the advice of the Prime Minister and the Cabinet. Apart from this, Crown also forms part of the legislature. The King summons, prorogues sessions of the Parliament, he also dissolves the House. The King gives final assent to any bill passed by the Parliament. Even in such legislative functions, the King adheres to the voice of the Cabinet and acts accordingly. In no place does the king have discretion to act on his own except is case where there is no party having majority, king decides on whom to call to form the government. Though it may seem the king is mere ceremonial head, but he does have some inherent rights, right to be consulted, right to warn and right to encourage. Prime Minister has to keep the king informed and should consult him in important cases of public interest. The king also renders warning and advice whenever such situation arises, and the cabinet cannot ignore such messages. 293 16 hours 38 minutes and 28 seconds. 294. 7.1.5 Legislature. The Parliament is the ultimate sovereign institution, and it has very wide powers. It has the right to make or unmake any law, and there is no authority which can question or declare it is ultra vires of the Constitution. Also there is no distinction between common law and the constitutional law. In reality, there are other factors which play important role limiting the extreme sovereign powers of the Parliament. The Parliament is bound by moral limitations, rule of law is fundamental feature governing the land, public opinion too play an important role as limiting the sovereign powers of the Parliament, judicial precedents and judge-made laws also become important conventions. The Parliament is at present overburdened with work, hence it cannot take up all the matters on its own. Delegated legislation has thus come to play an important role. This also limits the sovereign powers of the Parliament. The House of Commons or the lower house is the elected body. When the king dissolves the Parliament, it is the House of Commons which is dissolved, hence we can say Parliament is nothing but the House of Commons. It enjoys highest power in law-making, control of the executive and financial administration. Being the popular chamber, the House of Commons takes up the law-making and has been given enormous power. Though House of Lords, the upper house, is present, its powers has been curtailed and been made subordinate to the House of Commons. It has the final say in all the legislative actions. Decision regarding all non-monetary bills now rests with the Commons. Thus House of Commons supremacy is well established and functional. All money bills should originate in the House of Commons. House of Lords have very limited power regarding the money bill, at most it can delay it only for a month. House of Commons can get the assent of the king without support from the Lords, thus its control over money bills is complete and decisive. It also controls the purse of the nation. Budget making is an important instrument to keep check over the executive. Raising taxes or expenditure needs its seal of approval. In the parliamentary setup, the Council of Ministers are responsible to the popular chamber. The Council has a collective responsibility towards the Commons. So long as the Council of Ministers enjoy confidence of the House, they can continue to run the government, and when they lose it they have to render their resignation. The House of Commons keep check over the executive by seeking information about the functions and actions of the government and by criticizing it. Ministers are obliged to reply to questions asking in the House. Question hour helps the House to scrutinize the working of the government. Apart from lawmaking, the House debates the policies and actions of the government. The House of Lords is the oldest functioning second chamber in the world. Unlike the House of Commons, it consists of hereditary members, lords, nobles. Since 1911, its powers have been very much curtailed. A bill can originate in any house, and it has to be approved by both the houses for it to be passed. Being a historical institution, the House of Lords maintains the tradition and custom of English way of life. It helps prevent drastic deviation in laws made by the Commons. Private member bill arising from the House helps in saving time of the Commons. The second chamber upholds the ideals of bicameralism, and it helps in detailed scrutiny of the bills, creates an atmosphere for free and fair discussion. It acts as the revisory chamber for bills originating from the House of Commons. The House of Lords is also bestowed with important judicial functions. 294 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 295. 7.1.6 Judiciary. There is no single judicial system followed throughout entire United Kingdom. England and Wales follow a system, Scotland follows a different system, and Northern Ireland follows yet another system. Hence there is no uniform judicial courts throughout the country. Rule of law is supreme in England, and hence there are no separate administrative courts. Everyone is treated equally before the law. But there is no concept of judicial review. No law can be declared to be ultra vires of the Constitution. Parliament is thus supreme, and no authority can question the validity of a law. Unlike courts of America, where a law has to pass the judicial scrutiny, English courts do not scrutinize the laws. Important aspect of the British judiciary is its quality and quickness. The procedures are simple, and hence cases move faster, unlike courts in India. Fairness and speed are the essential features English courts. English judges enjoy high degree of independence. The judges are appointed for life and can be removed only by elaborate procedure in the Parliament. The trial is open to all, and anyone can attend it. The judges are impartial and people trust the system to deliver justice. Trial by jury is an essential feature which can be demanded by the accused. The courts uphold the human rights, helping in upholding civil rights, freedom of speech, movement, freedom of press, etc. Free legal aid is provided to those who cannot afford it from a financial point of view. 7.2 American Constitution. 7.2.1 Introduction. Philadelphia Convention held in 1787 forms the basis for the American Constitution. It came into force in 1789 after ratification of required number of states. It is one of the briefest constitution in the world, consisting of originally 7 articles. Around 26 amendments have been carried out exposing the rigid character of the Constitution. The concept of Montesquieu's separation of power has found ideal application in the American system. All the institutions are separate and it has checks and balances to prevent overreach. Though constitutionally the federal government is weak, judicial interpretation by the Supreme Court has strengthened its position. 7.2.2 Salient features of the American Constitution. The following are the salient features of the American Constitution. A. Written form. Like any other federal constitution, it is in written character. It is simple and elegant, consisting of only 7 articles. It was created as a skeleton constitution where the framers created just the important broad outlines, where rest of the details will be filled by the acts of the Congress. Thus, Constitution is just the starting point. Other than the written character, there are elements like conventions, customs, legislative measures, and judicial decisions which form the unwritten part, forming a vital part of the constitutional provisions. Though election of president as per the Constitution is indirect in character, present convention is that it is a direct contest between the individuals. B. Rigidity. It is the most rigid constitution in the world. Though amendment is possible, it is very lengthy and cumbersome, and it requires ratification of 3/4 of the states. Hence any proposed amendment takes years before it is implemented. The rigidity can be seen from the fact that 295 16 hours 38 minutes and 29 seconds. 296. Only 26 amendments have been carried out in all these years of existence of the Constitution. Though it seems rigid, the Constitution has adapted well to changing circumstances, from the Industrial Revolution to the present technological revolution. C. Federal nature. Originally it was a federation of 13 states, which is now expanded into 50 states. There is constitutional division of powers between Union and the states. The Constitution has elaborated the powers of the center and has left all the residual powers to the states. Thus Constitution has created a weak center and strong federal states. But in practice, this is not followed. The powers of center has increased manifold due to the concept of implied powers as propounded by the Supreme Court of America. D. Supremacy of the Constitution. The Constitution is supreme law of the land. Neither the center nor the states can override the Constitution. Any law passed by state or center can be declared ultra vires of the Constitution if it is in violation by the Supreme Court. E. Separation of powers. Though there is no direct statement in Constitution regarding separation of powers, the concept is implied and seen from the fact that the constitutional makers have attempted to keep separate executive, legislature, and judiciary as much as possible. The President is the head of the executive. He is indirectly elected and he has nothing to do with the Congress. The Congress is thus only the legislative body. President is not responsible to the Congress and thus cannot be removed by vote of no confidence. He also does not participate in its debates. Both the organs are independent of each other. Supreme Court enjoys enormous freedom and independence of function. In actual practice, there is no complete separation of powers between the institutions. Today the President controls the legislative policy of the Congress. There is coordination between the executive and the legislature. Thus in practice, there is overlap and sharing of powers between different institutions. F. Checks and balances. Power of each institution is checked by another, and thus balance of power is maintained. President can veto the bills of the Congress. International treaty needs approval from the Senate. Internal appointments too need ratification from the Senate, thus Senate checks the power of the President. Organization of judiciary is determined by the Congress, and the President has the power to appoint the judges of the Supreme Court, subject to the approval by the Senate. The Supreme Court has powers to strike down bills of both center and states if is in violation of the constitutional provisions. G. Bill of Rights. The basic fundamental rights of life, property, and liberty was not incorporated into the original Constitution. By subsequent first 10 amendments, these rights got approval and made as part of the Constitution. The citizens can take a recourse to courts if their fundamental rights are violated. These rights can only be modified or suspended by another constitutional amendment. Thus citizens of America enjoy freedom of speech, habeas corpus, freedom of worship, freedom from unreasonable seizure, etc., as they have been made as fundamental feature of the Constitution. 296 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 297. H. Judicial review. The judicial review is sometimes called as the judicial veto, as this keeps in check the powers of the legislature and the executive. The courts thus act as custodian and guardian of the constitutional rights. Any bill which violates it will be struck down. Judiciary has also expanded the power of the center with its doctrine of implied powers, hence Constitution is what judiciary interprets. The judiciary interprets the Constitution according to the changing circumstances of the society. This has made the Constitution relevant to any period in the time scale. I. Republican form of government. Unlike monarchical form followed in the United Kingdom, the United States has adopted a republican form. The head of the state, the president, is elected. The people drive the Constitution. The Constitution makes it binding to adopt republican form of government. J. Presidential government. President is head of the state and government. He is vested with all the executive powers. Unlike parliamentary form followed in the United Kingdom and India, the President is not responsible to the Congress. He does not attend any session, not directly introduce any legislation, nor participates in the debates. The Congress too cannot remove the President by no confidence motion. He enjoys problem-free 4-year tenure. Also, the President cannot dissolve the Congress. The cabinet of the President consists of members of his own selection, and they need not be from the Congress. K. Dual citizenship. The Constitution provides for dual citizenship. The individual is thus citizen of both the state and the country. L. Popular sovereignty. The people are the ultimate sovereign. The preamble of the Constitution establishes this idea. Rest of the government and its institutions are subjected to sovereignty of the people. M. Spoils system. The spoils system is an important part of the Constitution. The Pendleton Act, 1883, has curtailed and made only 20% of the offices subject to patronage of the President. Previously, all the offices were considered to be the spoils of victory of election of the President. He appointed his followers and supporters in the key posts. They worked not for the government but for the President and to help in his re-election. And when a new President is elected, the previous members resign and he appoints his own supporters to the posts. This system created numerous problems and inefficiency. This was rectified by the Pendleton Act, though not completely removing the spoils system. N. Bicameral legislature. Like United Kingdom and India, the United States, too, follows a bicameral system. Its lower house is called as the House of Representatives and upper house the Senate. Its upper house is the most powerful upper house in the world. Senate, thus, has more powers than the House of Representatives. It has executive, legislative and judicial powers. It has compact membership of 100 having a tenure of 6 years, whereas the lower house has 2-year tenure consisting of 435 members. 297 16 hours 38 minutes and 29 seconds. 298. 7.2.3 Executive. United States follow the presidential form of government, hence the President here is not mere head of the state, and he is also the head of the government. He appoints the cabinet, carries out functioning of the government independent of the Congress, he is neither responsible nor is controlled by the Congress, and Congress too cannot remove him. The President is supported by a Vice President who succeeds him in case the chair falls vacant for any reason. The President of America is considered to be the most powerful office in the world, comparable to none. But the powers is limited by the constitutional checks and balances by giving powers to the legislature and judiciary. The presidential powers and functions can be studied under his executive, legislative, financial, judicial and emergency powers. As the chief executive, the President is responsible for implementation and overseeing of the policies. He is responsible for the execution of constitutional provisions, laws made by the Congress and decrees given by the Supreme Court. He is given power to make appointments and also removal of the high executives like the ambassador, ministers, and federal judges. President is the brain behind the formulation of the national policy which bears his stamp. He also negotiates and concludes agreement with foreign countries. Executive agreements skirt the approval from the Senate, thus helping the President securely uphold the treaties. Though the President is not the part of the legislature, he still has been given powers to legislate. The President can send messages to the Congress or even personally read them. Though it is not compulsory to adopt such messages, it carries weight of the office of the President which cannot be ignored. He can also call upon extraordinary session of the Congress to legislate on some important issue. He can also give ordinances which has to be later taken up by the Congress. The other important role played by the President is in exercising his veto powers. He can either give assent or send back the bill to the Congress with some recommendations. He has to approve the bill within 10 days. And if the Congress is adjourned within the 10 days, the bill dies. Thus the President is given pocket veto in this case, where he can delay unwanted bills without giving assent and waiting for the Congress to adjourn. Any bill sent again for review, if passed by 2/3 majority of the Congress, the President has to approve it. Thus, the President has absolute, qualified and pocket veto powers. The President has been given powers to grant reprieve, pardon, or amnesty. His power to do so is confined to federal matters and does not apply in case of state laws. Budget making and giving annual financial statement to the Congress is the prerogative of the President. Thus, maintaining healthy financial environment is one of the responsibilities of the President. Though he cannot directly declare war, only the Congress can do so. He can create situation where it is inevitable for the Congress but to declare war. The President makes appointment of the heads of armed forces. During emergency situations, the powers of President increase enormously. The Cabinet is called as the extension of the shadow of the President. Unlike cabinets in the United Kingdom and India, which leads an independent existence with respect to its leader and is responsible to their parliaments, the American Cabinet is neither independent of and nor responsible to the Congress. All the appointments of the Cabinet is the personal wish of the President. Hence it is also called as the Kitchen Cabinet. 7.2.4 Legislature. The federal legislature consists of two bodies, the Upper Senate and the Lower House of Representatives. The Senate consists of 100 members where each state sends 2 members each. The lower house is composed of 435 members elected based on territorial representation on 298 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 299. Demographic basis. There is also significant difference in life of each house. Lower house is shorter, having 2-year tenure, and upper house having a 6-year time period. The Houses of American legislature is not a sovereign body like the British Parliament, hence it has to act according to the boundaries prescribed by the Constitution. Also, the President has veto power over the bills, and if he sends the bill again for reconsideration, it has to be passed by 2/3 majority in the House. The judiciary also strikes down any law which is ultra vires of the Constitution, that is, law which violates the constitutional provisions. There is also the underlying concept of separation of powers, where each institution is independent of each other. The Constitution has granted set of powers on which Congress can make laws. Rest of the residual powers fall under the purview of the states. But the power of the Congress has expanded under the doctrine of implied powers as given by the Supreme Court. Under this, the powers of the Congress has been widened to cover areas where state is responsible. The Constitution also provide for the concurrent powers shared by Congress and the state, but the Congress can override the state in case of conflict. Apart from the legislative powers, the Congress has other powers which comes under electoral, constituent, executive, financial, judicial, inquisitorial, directing and supervisory. The constitutional amendment bill can be passed by the Congress with 2/3 majority. It can also call for constitutional convention if 2/3 of the state requests it. The electoral powers of the Congress is important. If the presidential candidates fail to secure majority in the Electoral College, it the duty of the lower house to select the president from the top 3 securing the majority, and Senate chooses the vice president. Apart from this, the lower house elects its speaker and Senate its president pro tempore. Senate confirms all the appointments and the foreign treaties. Congress approves the resolution of war and peace. The House can set up investigative committee to check into complaints regarding alleged misappropriation of funds or a scandal. The lower house has power of initiating impeachment proceedings against the President, Vice President, and other high-ranking public servants in the Senate. Impeachment is passed if 2/3 of the House vote for it. The Constitution grants the financial supremacy of the Constitution. The Congress thus controls the purse of the nation. No amount of money can be appropriated without its approval. Though budget is prepared and presented by the President, it is Congress that approves it. Thus Congress plays decisive role in functioning of the government. 7.2.5 Judiciary. Federal judiciary was considered to be the important organ of the state. Its key role was to maintain the checks and balances on the legislature and executive. It was considered to be the guardian and protector of the constitutional principles. Any law which is in violation of the Constitution is struck down. Constitution does not provide for the qualification and the appointment process of the judges of the court, hence the President is free to appoint anyone. The judges are appointed for life. It is their prerogative to retire at either 65 after completing 15 years of service or at 70 after completing 10 years of service. With good behavior, the judge can continue his service. The lower house can initiate impeachment proceeding based on allegation of treason, bribery, or other high crime of misdemeanor, and it goes to the Senate where a resolution is passed by 2/3 majority supporting the removal. The Supreme Court has both original and appellate jurisdiction. The original jurisdiction covers action by the center against a state, action by one state against another, in cases involving high-ranking public servants and ambassadors, and in cases where state act against citizen. 299 16 hours 38 minutes and 29 seconds. 300. Belonging to another state or alien. Appeals lie to the Supreme Court from the lower district courts, and from state courts where federal question is involved. The important aspect of American Supreme Court is that it does not exercise advisory jurisdiction. Two important aspects of the judiciary is the concept of judicial review, which has made the courts the guardian of the Constitution, and the concept of due process of law, which is the safeguard against the arbitrary executive action. 7.3 Chinese Constitution. 7.3.1 Introduction. The first Constitution of People's Republic of China was promulgated in 1954. Its main objective was to build socialism step by step. It did not follow the socialism of Soviet but rather developed its own version under the influence of Mao Zedong, came to be known as Maoism. This constitution was in force till 1975 when it subjected to revision. The new constitution was a brief document, and it enumerated the achievements of the previous constitution. There was no major deviation and it followed the path laid by the chairman Mao. Once again this constitution was subjected to revision soon in 1978. This constitution was fairly liberal than the earlier ones, but it did not affect any major changes to the old setup. This was old wine in new bottle. Under the leadership of Deng Xiaoping, the constitution was again revised in the year 1982, and it has been continuing till the present. The preamble elaborates the achievements of the communist state till then. It took major deviation in Mao's views. Economy was given precedence. 7.3.2 Salient features of Chinese Constitution. The important aspects of the 1982 Constitution are as follows. A. Written character. Like the previous other constitutions, it is also a written document. It presently consists of 138 articles. Hence it is not so brief like the 1975 Constitution and even bigger than the 1954 Constitution, which contained 116 articles. B. Flexible. It is fairly easier to amend the Constitution. The amendment can be moved either by the Standing Committee or by 1/5 of the members of the Congress. Once approved, it is deemed passed if 2/3 of the members of the Congress give approval. Since it is a one-party, communist-dominated Congress, it is easy for the amendment to be approved and passed. C. Unitary state. The Constitution provides for a strong unitary state where people of all nationality come under single state. There is no provision of creation of autonomous provinces or states in the style of India or Canada, though limited powers to provinces has been envisaged. There are 21 provinces, 5 autonomous regions and 2 cities, but all these are mere names as the central government has complete control over them. The government in the provinces act as agents of the center. D. Power to the people. Constitution is based on the power of the people. All power belongs to them. The National People's Congress and the local People's Congress are elected directly by the people. All organs of the state maintain close contact with the people to fulfill their wishes and heed to their opinions. 316 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 301. The feudal lords and the capitalists have been stripped of all political rights. And thus ordinary people are considered to be the foundation of the Chinese Communist state. Planned economy like its Russian counterpart, China, too, adopted the planned growth of the economy. It is vital and important aspect for a socialist state. Revolutionary changes have been brought about in agriculture and in industries. Most of the industries were brought under the control of the state. The planning is carried out to provide better living condition for the people, thus it is both social and economic planning which is carried out. People's democratic dictatorship. China cannot be categorized either as a parliamentary form or a presidential form, even though it has some of the features of both. It is a republic state headed by the president, who is just a nominal head performing ceremonial functions. The real executive power lies with the Prime Minister, who heads the State Council, which is responsible to the National People's Congress, which is an elected body. The democratic character comes from the fact that the Prime Minister cannot become a dictator, as he is given only 2 terms of totally 10 years. But the dictatorship character arises because the State Council is ultimately controlled by the Communist Party of China. The chairman of the party holds all the power. Democratic centralism. All organs of the state follow this principle of democratic centralism. National People's Congress is an elected body, some organs of the state too is elected, hence they are responsible and accountable to the people. This reflects the democratic character of the state. All policy making is centralized. It is controlled by the State Committee of National People's Congress and State Council. The Communist Party is the highest decision-making authority. This policy of democratic centralism was adopted from the erstwhile Soviet Union. Fundamental rights. The citizens are guaranteed economic, social, political, cultural, civil, and personal rights and liberties. They also enjoy equality before law and equal protection from it. Right to education, right to get elected, freedom of speech and expression, association, freedom of religion, etc., are guaranteed to the people. There is also no discrimination based on sex. But all these rights are curtailed by Article 51, which says all these rights should not violate principles of the state, community, and of other citizens. This article thus gives blanket power to the state to control the fundamental freedom of the citizens. Apart from rights, there is also set of important duties like joining the militia, pay tax, practice family planning, etc., which has to be carried out by every single person. Socialist state. Article 1 declares that China is a socialist state. This is interpreted ideology of Marx, Engels, and Lenin by Mao. The Chinese society is led by working class, which is comprised of alliance of both workers and peasants. This alliance is against the enemies, the feudalists, the imperialists, and the bureau capitalists. All power is given to the people, which is exercised under the guidance of the Communist Party of China. Unicameral legislature. The National People's Congress forms the legislature of the Chinese state. NPC, along with the Standing Committee, carries out the legislative functions of the state. It is elected for a period of 5 years, and it is the sole lawmaking body in the country. It has power to appoint all important 316 hours 38 minutes and 29 seconds. 302. Positions from Prime Minister, President, and to judicial officers, etc., it has also been given power to remove these persons. Though it may sound impressive, all these are only formal power. In practice, the NPC acts according to the direction of the Communist Party. Provision of Standing Committee. This Standing Committee is elected by the members of the NPC. It is the executive body of the Congress. It has life till the Congress is functioning. The power of the Standing Committee has been very much curtailed at the present. Judiciary. The judiciary is completely different from the Western systems. The Supreme People's Court is the apex court which guarantees the socialist legality. It has both appellate and original jurisdiction. The judicial structure is basically pyramidal, where the local People's Court forms the base and the Supreme Court sits at the apex. These courts too come under the democratic dictatorship system and is controlled by the dictates of the Communist Party of China. 7.3.3 Executive. The President is elected for a 5-year term by the National People's Congress. The President can continue for another term, thus he has maximum period of 10 years. The office is for ceremonial reasons and his functions are formal. The Prime Minister, here called as the Premier, is appointed by the President. Other officers too are appointed by him based on the recommendation from the NPC of the Standing Committee. Those appointed by him are also removed by him on basis of recommendation from the NPC or the Standing Committee. State of war and martial law are declared by him. He is also given special pardoning powers. He receives the foreign ambassadors and other dignitaries on behalf of the state. He also ratifies the foreign treaties and other agreements signed by the government. All these functions are carried out on the recommendation and guidance of the Standing Committee of the NPC. Thus, the President is a ceremonial figure having no power on his own. The State Council is the real government. It is equivalent to the cabinet system in other countries. Premier is the head of the council and NPC selects other members based on his recommendation. The office runs till the term of the NPC, that is for 5 years. The President has the power to remove the members based on the recommendation from the NPC. The important power of the State Council are it is the central government, thus it forms all the policies and implements them, it carries out the administration of the country, it sends various legislative proposals for the consideration of the NPC, it lays down responsibilities and functions of each ministry, it also supervises the functioning of the provinces, autonomous regions, and other areas, they all fall under the direct control of the central government, it ensures the country is defended effectively, it recruits, trains and appoints the civil servants to various administrative posts and it prepares the budget document to get approved from the NPC. Though the position of the Premier is not as equivalent to that of British or Indian Prime Minister, he does enjoy enough powers. The Premier does not create or destroy the State Council. He can only select those members he wants to get appointed to the Council and the NPC makes such recommendation to the President who finally appoints them. He is just the head of the State Council, hence the government. He plays the role of coordinating between the various ministries and controlling their functions. 302 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 303. 7.3.4 Legislature. The National People's Congress is the unicameral legislature. Since China follows a unitary form of government, secondary chamber to represent the interests of the states were not needed. Thus, NPC forms the highest instrument of state to form the laws and the sole authority to approve and pass them. The time period is of 5 years and the periodic elections are conducted by the State Council. The functions of the NPC are, they can ask questions to the State Council or the ministers. All the members have to abide by the Constitution and protect its secrets. NPC is the one and only lawmaking body. Standing Committee does this function when the NPC is in recess. The other important function of the NPC is to supervise the working of the Constitution. Apart from these, the NPC elects all major important institutions, the President, Vice President, the Prime Minister and his Council of Ministers, the Auditor and Secretary General of the State Council, the Chairman of the Central Military Commission. It also elects the President of Supreme People's Court, and the Procurator General of the Supreme People's Procuratorate. The NPC has the power to amend the Constitution. The proposal for amendment is submitted by the Standing Committee or 1/5 of the deputies of the NPC. It takes care of the development and the social planning of the country. It first examines such plans, approves them and finally submit report of their implementation. The budget of the government is approved by the NPC. It has power to alter the boundaries of the provinces, autonomous regions, etc. Apart from electing people, it has power to remove or recall them. It has power to take decisions on matters which are not specified in the Constitution. Thus, NPC has been given enormous powers. But all these exist in paper and the real power lies with the Communist Party of China. NPC cannot take all decisions on its own. Thus in reality, the Communist Party of China is the power center and all other institutions function in relation to it. The Standing Committee of NPC is the smaller version of the Congress. The whole NPC is very large and meets only once a year, thus the Standing Committee only takes care of the day-to-day functions and working of the government. It is headed by a chairman, followed by a vice-chairman, the Secretary General and members. It has the lifetime of the NPC, and when new NPC is constituted, a new Standing Committee is elected. The legislative function of the Standing Committee are, it can summon the NPC, it enacts the legislation when NPC is not in session, it supervises the working of all major state organs like the State Council, Central Military Commission, etc. It has been delegated the power to legislate on behalf of the NPC. Its elective functions are, when NPC is not in session, it decides on the choice of ministers, the Auditor General and the Secretary General. It has the power to appoint and remove the Vice Presidents and Judges of Supreme People's Court, the Deputy Procurators General and Procurator of the Supreme People's Procuratorate. The following are its executive functions, though the ambassadors and diplomatic personals are appointed by the President, they are removed by the Standing Committee. Ratification of treaties are also decided by the committee. The decision to pardon criminals, though approved by the President, he is advised to do so by the Standing Committee. It has also been given power to declare war when NPC is not in session. The Standing Council interprets the law, which is generally the function of the Supreme Courts, United States and India. It also interprets the Constitution and helps in its implementation. It supervises the function of the State Council and can even reject its decisions. 303 16 hours 38 minutes and 29 seconds. 304. The Standing Committees play a minor role in proposing amendment to the Constitution. But the power to amend rests with the NPC. 7.3.5 Judiciary. The structure of judiciary is simple and is in form of a pyramid. The local People's Court constitute the base and the Supreme People's Court is at the apex. Every province too has its set of courts which has entire jurisdiction over it. The Constitution does not provide the functions of the Supreme People's Court. But some of its important functions are, to supervise the courts below it. The NPC has the power to widen the powers of this court. It has original jurisdiction over cases of national importance. It also hears appeals against the decisions of the high courts in the provinces. China also has a unique procuratorate system. Starting from the local procuratorates, it goes till the apex, the Supreme People's Procuratorate. Each procuratorate is managed by the one above it. These bodies are elected by the local organ of the state authority and hence are responsible only to it. The main function of these procuratorates are, to prosecute people who violate the socialist principles of the state. It also advises the government on legal matters. The Supreme People's Procuratorate acts as the chief public prosecutor of the government. apart from citizens it can also take action against the government and its officials, and finally they act as the protector of the socialist legacy of China. Some of the important features of the Chinese judiciary are: it has a single well-integrated judicial system unlike in the United States where state and federal courts are separated. The judiciary is not completely independent as at all levels the judicial officials are elected by the government. The Constitution moreover does not specify the tenure and qualification of the judges, thus everything falls under the discretion of the NPC and other government bodies. Generally trials are conducted in open and only few exceptions are there for closed trials. Unlike in major democracies, the Supreme Court of China has no power to declare any law made by the legislature as ultra vires of the Constitution. Even the judiciary has no power to question the action of the executives, since all actions of either legislature or the executive comes only after the blessing from the Communist Party. They can never be violation of the Constitution. Thus the Chinese judiciary is a committed judiciary, the one which is committed to the communist ideology, the Communist Party, and to the communist government. 7.4 Swiss Constitution. 7.4.1 Introduction. The Swiss Constitution was first adopted in the year 1848. Loose organizations of small states called cantons came together to create this constitution. The most important feature of this constitution is the tilt towards strong and unified government based on federalism. It terminated the system of cantons and created confederation of states. This constitution of 1848 underwent two revisions, one in 1874 and another in 1999, and the present Swiss system is governed by this constitution. It gave more powers to the federal government in controlling the military. The new constitution was ratified by the people and came into force on January 1, 2000. It consists of 197 articles. The structure has more or less remained the same. It makes Switzerland a social welfare, democratic and a republican state. 304 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 305. 7.4.2 Salient features of the Swiss Constitution. The following are the salient features of the Swiss Constitution. A. Written and enacted document like American Constitution, it is also a written document consisting of 197 articles. The Constitution is the supreme law of the land. It creates a balance between federal government and the cantons. It seeks to prevent friction and internal strife. It is also voluminous. B. Rigid. It is difficult to carry out amendments to the Constitution, but it is not so rigid like the American Constitution. Any amendment has to be passed by the Parliament, and it has to be ratified by majority of the cantonal governments and also by majority of people in the referendum. It is flexible in the sense that people have more powers through instruments of initiative and referendum. Thus it widens the democratic powers of the people. And in each instance, it is passed by a simple majority. C. Plural executive. Switzerland has unique system of plural executive, also known as collegial or plural presidency. 7 members or ministers are all designated as the presidents. Usual practice is power is vested with one individual, either prime ministers or president, and he controls the government. Here all the 7 members have equal powers. To carry out ceremonial functions, the senior member is elected as the president of the federation and another the vice president for a year. Each canton gets its representation in the presidency, and no 2 presidents should belong to the same political party. Hence there is wide diversity and is always a coalition government. D. Federal system. The Constitution declares Switzerland to be a confederation. The powers are shared between the center and the cantons. Certain subjects which are of national importance like foreign affairs, military affairs, declaration of war, etc., comes under the center, there are some concurrent powers shared both by center and the cantons, such as control of press, regulation of industries, etc., and rest of the residuary power lies with the canton. The federal court has been set up to interpret the provisions of the Constitution and help settle legal disputes arising between center and the cantons. Like United States, the federal states have been given enough autonomy and hence can be considered as a true federation. Direct democracy. Modern democracy is called as representative government because people do not rule themselves directly, they elect their representatives to rule on their behalf. Though Switzerland has such kind of representative structure, it also has three important concepts which widens the power of democracy. They are initiative, referendum, and Landsgemeinde. Initiative refers to initiative of at least 1 lakh voters to send proposal to the parliament to adopt it as a bill or send it back to the people as referendum. Constitutional amendment bills and some urgent bill of public importance should be placed before the people after passed by the parliament. 8 cantonal governments or at least 50,000 voters can demand referendum on any other bill. Thus, referendum places the final veto power in the hands of the people. The system of town parliament in the 5 small cantons is called as the Landsgemeinde. Each adult member is the member of the town assembly and hence cantonal elections do not take place here. 305 16 hours 38 minutes and 29 seconds. 306. F. Social welfare state. Each person is insured social security and health care by the government. It is the responsibility of the center and cantonal government to ensure everyone are economically protected, shielded against illness, old age issues and maternity, and against widowhood, etc. The Constitution thus has created a social welfare state which strives to protect its members. G. Fundamental rights. It is so expansive that it covers social, economic, and political sphere. And it is much wider than the provisions contained in the Universal Declaration of Human Rights adopted by the General Assembly of the United Nations in 1948. Economic rights include right to free choice of vocation, formation of union, people have right over their property and they have to be fully compensated if such property is acquired by the state. Political freedom ensures free press, print and electronic, editorial secrecy is guaranteed, freedom to form opinion and express it, arbitrary arrest and detention are prevented. But all these political rights are tied to citizenship, that is only a Swiss national enjoys all these freedoms. H. Republican Constitution. Republicanism is not just at the center but every canton also follows it. Swiss equality is for everyone in the society, hence it had abolished the aristocratic and oligarchic privileges. All political institutions are elective in character. The principle of republicanism is the fortification of Swiss democracy. Secondary position of judiciary. The apex judicial body has no power to review the laws made by the center. The Constitution has made it secondary to the legislative body, unlike in countries like the United States or India. The judiciary can only review laws made by the cantons and declare it unconstitutional if it is in violation. The judges too are elected by the Federal Assembly. Thus the Swiss Federal Tribunal has only limited judicial review powers. J. Bicameral system. It has upper house known as the Council of States representing the cantons on equal basis like American Senate. It is a small body consisting of 46 members. The lower body is larger, having 200 members elected by the people. The lower body is called the National Council. Both the bodies have equal power and one does not dominate over the other. K. Dynamic constitution. The Swiss constitution is very dynamic. It has adapted well according to changing situations. Growing aspirations of the people have been addressed by widening their rights. The state too intervenes whenever rights of the citizens are threatened and laws have been made subsequently to protect it. 7.4.3 Executive. The Swiss executive is headed by a ceremonial office of the president. Senior most member of the 7 ministers is elected president for 1-year tenure. He is neither primus inter pares or does he enjoy precedence over his colleagues. Since some jobs cannot be performed as a group, an individual is appointed to the role of the president. He receives envoys, appoints ambassadors 306 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries 307. And represents the country at international fora. Thus, the Swiss executive is plural or a collegial system. No single individual enjoys the power. And after expiration of 1 year, he returns back to his membership and other persons are elected based on rotation of seniority. The Swiss executive is also very stable and cannot be easily dismissed before its end of tenure. As per the constitution, the executive is subordinate to the legislature. The executive cannot act independently of the assembly. The Swiss executive is not like the cabinet system of the British. The members here are from different political parties, and hence bring unity in diversity. They are not the members of the legislature but are elected by the National Assembly. They are also neither individually nor collectively responsible to the legislature. But ministers take part in deliberations of the legislature to get approval. Hence it is not like the American system where the executive is completely separated from the legislature. The function of the executive is to oversee the working of the cantons. It checks whether canton is functioning on basis of the constitution. It also helps in resolving dispute between two cantons. It carries out foreign relations, signs treaties, and protects independence and sovereignty of the nation. It also looks after the law and order situation, and if any cantonal government fails to uphold it, it can intervene on behalf of the legislature. It controls the federal army and has power to deploy troops in case of emergency when Parliament is not in session. The executive submits the draft of the bill to the legislature for deliberation. Thus the government initiates debate in the Parliament, and the Parliament can pass the bill with or without amendments. It periodically submits report to the Parliament on functioning of the cantons, internal condition of the country and its foreign relation. It also submits set of recommendations to promote welfare of the citizens to be adopted by the Parliament. Though they are not members of the legislature, they are allowed to participate, debate, deliberate and answer question. They also attend meetings of the Parliament committees discussing the bills and influence it with their knowledge and experience. The executive submits the budget and it collects revenue and supervises the expenditure. It has some powers of judicial nature. It hears appeals of private individuals against decisions of various departments and Federal Railway Authority. It also has appellate jurisdiction over decisions of cantonal government in some discrimination cases. Thus the Swiss system is neither parliamentary nor presidential. It is unique by itself. It is non-partisan and has high integration and cooperation among its members. 7.4.4 Legislature. The federal parliament is of bicameral nature. It represents the federal nature of Indian and American system. The similarity ends there. The Swiss constitution provides equal power to both the houses, and thus no house is subordinate to the other. It is also one of the other unique feature of the Swiss system. The Senate is similar to American Senate. Each full canton has 2 members and each half canton 1 member. Thus all cantons receive equal representation. These members are elected by the cantons themselves based on their own system, thus each canton can have their own system of electing, determining the tenure, salary, etc. The cantons have also the power to recall or replace their representatives. The members of House of Representatives are elected by the people directly based on proportional representation with list system and secret ballot. Population and size of the canton determine the number of representatives sent by it. The President acts as the chairman of the House. He regulates the business, protect the privilege and dignity of the House. 307 16 hours 38 minutes and 29 seconds. 308. The legislative powers include passing of federal laws, approval of treaties, passing of constitutional amendment and approval of budgets, etc. It can demand information from the executive and question it. It elects the 7 members of the government and appoints one of them as the president. It also elects members of the federal judiciary, appoint commander-in-chief of the armed forces, etc. It has the power to declare war or peace. It has judicial power to grant amnesty and pardon. It also hears appeal against the government in administrative cases. The constitutional amendment power is subject to people's verdict. Any such amendment has to be ratified by the Parliament first and then approved in a referendum by the people and the cantons. 7.4.5 Judiciary. It is the youngest institution in the Swiss system. It consists of 26 judges elected by the Parliament. One of them is appointed as its president and another vice president. The judges represent all the linguistic background. It covers both civil and criminal cases and also other issues of public law. Its civil jurisdiction covers all suits between Federation and the cantons and also between cantons themselves. It also takes up cases between individual and the Federation. It decides cases relating to loss of nationality or citizenship dispute between communes of different cantons. The final appeal from the cantonal courts lie to the federal court. 7.5 Japanese Constitution. 7.5.1 Introduction. The present constitution, also known as MacArthur Constitution, is mostly continuation of the older Meiji Constitution. It differs from the older in some crucial important aspects. The Japanese Constitution is the only document to be called the peace document of the world. Though it was a post-war gift by the Americans, it makes Japan a demilitarized state and a democracy. 7.5.2 Salient features of the Japanese Constitution. The following are the salient features of the Japanese Constitution. A. Document of peace. It openly renounces war. It also says Japan will not maintain any standing armed forces. The preamble declares that Japan is a peace-loving country and strives for peace in the world. Though there is no armed forces, the Constitution provides for setting up self-defense forces to protect national interest. B. Sovereignty of people. The older Constitution vested the power on the monarch. It held imperial sovereignty and people had no power. The present Constitution restores democracy and gives back power to the people. The people are thus made sovereign and they elect their representatives to the Diet to voice their concerns. The emperor is made symbolic and has no power. The government derives power from the people as stated in the preamble. C. Unitary system. Unlike the United States, it is not a federal state. All powers are held by the central government and there is no distribution of powers between the center and the provinces. Though there are 308 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 309. Separate local, provincial assemblies. They all derive power from the laws passed by the Parliament and not from the Constitution. D. Rigid. Like the United States, it is difficult to amend the Constitution. Apart from 2/3 majority in the Parliament, it has also to be ratified by the people in a special referendum. Japanese Constitution has not been amended even once. E. Limited judicial review. The Supreme Court is the last resort to validate the law against the violation of the Constitution. The Constitution thus has specifically provided for judicial review. But the Supreme Court has not used this power like its counterpart in the United States. It is due to the fact that the conduct of the judges is subject to review after 10 years by the people. The rights and liberties of the people are thus protected by the Constitution by keeping judicial review as a check on the executive and legislature. F. Parliamentary form of government. Japan follows British type of system, where the monarch is simply a figurehead and the actual power is vested in the Prime Minister and his cabinet. The Parliament can pass a no-confidence motion to remove the government. The Prime Minister and his cabinet are responsible to the Diet. G. Fundamental Rights and Duties. A detailed Bill of Fundamental Rights and Duties are important feature of the new Constitution. It is a comprehensive document covering all areas of social, economic, and political rights of the citizens. Apart from rights to citizens, it also speaks about duties by the citizens. Some of the fundamental rights are equality and equal protection before the law, freedom of religion is guaranteed to all, bonded labor is abolished, right to life has been guaranteed to all, etc. These rights are also protected by the courts. H. Separation of powers and checks and balances. Previous Meiji constitution had given enormous power to the monarch and relegated the institutions of parliament and judiciary to a secondary position. Thus the new constitution explicitly separates and protects the independence of each institutions. The people are made the new sovereign from whom the power is derived. The judiciary is independent and powerful to keep check on the other democratic institutions. 7.5.3 Executive. In the Meiji Constitution, the emperor was accorded the status of divine. He ran the government and all the powers were bestowed upon him. The Diet was merely there to approve the wishes of the emperor. After the World War II, the scenario changed and the powers of the emperor was stripped down and was made a nominal head of the state. He now acts on the advice of the Prime Minister and his cabinet. The emperor has been given power to appoint the Prime Minister as designated by the Diet. He attests the final ratification of law, international treaties, and appointment of ambassadors. All laws, amendments, etc., are promulgated by the President. He convenes and dissolves the Diet. The emperor has also the power to grant amnesty, reprieve, commutation of punishment, etc. He appoints the Chief Judge of Supreme Court on the advice of the Cabinet. Thus all 309 16 hours 38 minutes and 29 seconds. 310. Powers of the Emperor are merely formal, and he acts as the figurehead of the state. He cannot veto or send back any bills back to the Diet unlike his counterpart, the British monarch. The cabinet headed by the Prime Minister takes care of the functioning of the government. It takes all important political and administrative decisions. It submits law to be promulgated by the Diet. It prepares the budget and gets financial approval from the Diet. It designates who will be the Chief Justice of the Supreme Court and makes appointments of the other judges. The cabinet controls and administers the civil service. It submits to the emperor who can be granted amnesty, reprieve, and commutation of sentence. The cabinet is made responsible to the Diet by the Constitution. The Prime Minister is considered to be the keystone and performs some important functions. He selects members of his cabinet and forms the government. He can also remove, reshuffle the cabinet whenever he wants. Being chairman of the cabinet, he supervises its function or chairs any committee. He is also the leader of Diet in general and the lower house of representatives in particular. He makes appointments of all important positions in the government. He also selects the date of election for the Diet, which is then approved by the Emperor. The Prime Minister and his cabinet continue as long as they enjoy confidence of the Diet. The lower house can pass a motion of no confidence. 7.5.4 Legislature. The Parliament is called as Diet in Japan. It consists of two houses, the upper house of councillors and the lower house of representatives. This type of system existed even in the Meiji Constitution, but the Parliament has no power then. The House of Representatives play a crucial role and considered to be more powerful than the upper chamber. The House enjoys wide powers in matter of legislature. Bills rejected or amended by the upper house can be passed by the lower house as it was earlier with a two-third majority. And it can pass the bill if the upper house fails to take action on any bill for more than 60 days. Though the House of Councillors can delay the bill, the power to pass the bill lies with the lower house. The lower house of representative controls the executive. The Prime Minister and his cabinet are made responsible to it by the Constitution. If the House passes the no confidence motion, the government has to resign. The executive has to submit periodic reports to the House. The House can also set up committees to investigate in any wrongdoings. And without the approval from the Diet, no treaty can be implemented. The parliamentary control of the executive is also carried out by asking questions, debating, etc. The Prime Minister is generally the choice of the lower house, even the minister mostly belong to the lower house of representatives. The purse of the nation is controlled by the lower house. The budget has to be introduced before it. No tax can be added or increased without the approval from the House. The upper house can only delay passing of the financial bill, thus even in financial matters, the lower house overrides the upper chamber. The Diet acts as the final court of impeachment of the judges of Supreme Court. Both the chambers have equal number of members in the court of impeachment. The Constitution provides the lower house to amend the electoral law of the country. Thus there should be no discrimination between race, sex, creed, family origin, education, income, property, or social status. Both houses participate to elect the Prime Minister. But in such elections, the lower house has upper hand. 310 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries. 311. Both the houses can initiate amendments to the constitution and it has to be passed by 2/3 majority by each. After it is passed, it is sent to people for ratification in a special referendum. Once majority of people approve it, it is considered to have amended the constitution and thus becomes a part of it. The upper house, though comparatively weaker than the lower house of representative, carries out the important function of giving stability and continuity to the Diet as it is a permanent house which cannot be dissolved. It also moderates and restrains extreme views of the lower house. Thus it is not so powerful like the second chambers of England or the United States. 7.5.5 Judiciary. The doctrine of separation of powers is followed. Thus the judiciary is separated from the executive and the legislature. The Supreme Court controls all the lower courts. The Constitution has also provided for the power of judicial review to strike down any law which is ultra vires of the Constitution. The judges can only be removed by the process of impeachment, thus maintaining the independence and integrity of the judiciary. Every 10 years, people review the appointment and working of the judges. If the people disapprove any judge, he is then dismissed. Constitution thus provides review of appointment of the judges for every 10 years. There is no separate administrative tribunal appointed by the executive as everything is taken up by the courts themselves. Open trials are conducted, only the judges can issue warrants for arresting a person. Every lawyer, judge, or a public prosecutor has to pass from the Legal Research and Training Institute which is under the control of the Supreme Court. Thus, those practicing law in Japan are very few as compared with other countries. 7.6 French Constitution. 7.6.1 Introduction. French Constitution is different from various others in the world. From the French Revolution in 1789, it has undergone numerous changes, from becoming a republic to directorate under Napoleon and once again ruled by Bourbons, and now finally a democratic republic. In these years, France has seen 12 regime changes and 13 constitutions. Thus extreme political changes has given France a new constitution. The First Republic was inaugurated in 1792. It was comparable to the traditional American or the British system of government having a cabinet system. The powers were separated between the institutions. The powers of monarchy was also severely cut down. A new constitution was adopted in 1793, giving more powers to the assembly, which was to be elected directly by the people. This constitution was once again replaced in 1799 with Constitution of the Consulate, giving powers to Napoleon Bonaparte. He once again issued another constitutional charter of 1814, restoring divine rights of the monarch. Napoleon's regime was replaced by monarchy of Louis Philippe, and new constitutional charter of 1830 was adopted. This gave limited powers to the monarch. People were not satisfied and rose against this regime and overthrew it. The National Assembly adopted a new constitution in 1848, making France a republic once again. This period from 1848 till fall of the regime Indiana 1870 is called as the Second Republic. 311 16 hours 38 minutes and 29 seconds. 312. Once again, effort was taken to form a new constitution. This constitution was very rigid. It created a republic, and made sure that this form of government could not be changed even by constitutional amendment. This Third Republic, which lasted till 1940, is considered to be the longest in the French Republican government history. President Pétain assumed despotic powers, bring the Third Republic to an end. The new constitution, called the Fourth Republic, was adopted in 1946 and did not last more than 12 years. This gave enormous powers to the parliament and made the president weaker and subject to control by the parliament. The final and present Fifth Republic was created under the leadership of Charles de Gaulle. The National Cabinet was assembled and the new constitution was drafted by Debré. It was presented to the people, who gave acceptance to the constitution in the referendum. 7.6.2 Salient features of the French Constitution. The following are the salient features of the Fifth Republic Constitution. A. Written and endorsed constitution. It is a brief, written document presently having 92 articles. It was written by a constituent committee headed by de Gaulle. It was first endorsed by the cabinet, then by the parliament. Finally, people overwhelmingly adopted the constitution in the referendum. The constitution has given immense power to the president, who is elected by the people. He is vested with the powers of the state and can deal with any crisis within the country or abroad. Thus, president is the actual head of the government as well as the formal head of the state. B. Rigid. Unlike Indian constitution, which has provision to amend the constitution easily, amending French constitution is quite a task. It does have provision to amend the constitution, but certain conditions have to be met. The bill will be proposed by the President to the Premier and to the members of the Parliament. Both houses of the Parliament should pass the bill identically, and the bill becomes definitive after the approval from a referendum. The President, if so wishes, can cancel the referendum and instead submit the bill to the joint session of the Parliament in which it has to be passed. And no amendment is possible when integrity of the territory is in question. Also, the republican nature of the Constitution cannot be amended. C. Unitary system. French Constitution creates a unitary system. This is rooted in the French constitutional history, where power is biased towards the centre. The centre is more powerful than the British Union. There does exist local governments at various levels in France. The territory is divided into departments, and these are further divided into cantons, arrondissements and communes. They have restricted powers, and this comes from acts of parliaments and not from the constitution. These local governments are nothing but the agents of the centre and are subjected to its control. Thus, French system is more rigid and centralized than its British counterpart. D. Separation of powers. The most important aspect of the Fifth Republic is that it has separated the executive and legislative institutions, but has made the executive accountable to the legislature through the concept of ministerial responsibility. The cabinet functions under the Prime Minister, but the President has the overall control. The cabinet members cannot be members of the legislature, and if so 312 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries 313. They should resign to enter into the government. Though the cabinet is not from the parliament, it is accountable to it. Though the president has overall control, he is not directly accountable to the parliament, only the cabinet headed by the prime minister is accountable to it. The legislature may pass a vote of no confidence in the government, and in such case the government has to resign. Quasi-presidential government against the quasi-parliamentary form. French system is more of a quasi-presidential type since authority of the president is far wider than of the prime minister. He is not a titular head like his British counterpart, rather he is more like the American president. The French president appoints the prime minister and other ministers on recommendation of the prime minister. He chairs the cabinet meetings and thus makes his wishes get adopted by the government. But he is not responsible, only the prime minister and his cabinet are accountable to the parliament. The president has also been given wide veto powers. His position is strengthened by his 5-year-long tenure and his election by the people. His removal too is a difficult process to be followed. Syncretism. The Fifth Republic has introduced some set of principles which are together called a syncretism by the French people. Some of the principles are: President has been given vast powers in determining and promulgating emergency. The Parliament is bicameral system where both Upper Senate and Lower National Assembly has coordinate powers. Though the Prime Minister and the Cabinet are not from the Parliament, they are responsible to it. In theory the President is the head of the state and Prime Minister head of the government. In practice the President assumes both the role when he wills and the Prime Minister is subordinate to powers of the President. The President can refer bills of public importance for referendum by the people. Thus these basic principles guide and form basis of the French Constitution. Constitutional Council. It is a unique institution having 9 members, 3 nominated by the President, 3 nominated by the President of the National Assembly, and 3 nominated by the President of the Senate. The members enjoy 9-year tenure and are not eligible for reappointment. The former presidents are ex officio members of the Council. This institution is neither a cabinet, nor a judicial body and neither a legislative organ, but it is a fusion of all 3. It has controlling, adjudicatory and consultative powers. Its important functions are: to oversee the presidential and parliamentary elections. It also declares the result of the referendum. It verifies the constitutional validity of act made by the executive or by the parliament. The President has to consult the body before declaring the state of emergency. Though it was not envisaged such kind of powers, it has come to play dominant and restraining role on the executive and the legislature. Economic and Social Council. The Constitution provides for creation of such body. It renders advice and opinion of the bills submitted before it. Generally it is consulted on economic and social issues by the government. Recognition of political parties in India and the United States. The Constitution does not recognize the political parties. The important feature of the French Constitution is its recognition of political parties and the role played by them. Political parties which is not loyal to France and respect democracy can be banned. 313 16 hours 38 minutes and 29 seconds. 314. Administrative law. Though all citizens are equal before law, France provides separate courts for trying of public servants. Citizens have ordinary courts and the civil servants have specially constituted administrative courts following administrative law. Popular sovereignty. The people are the ultimate sovereign. The Constitution provides of equality, liberty, and fraternity. The Constitution also declares France to be an indivisible secular, democratic, and social republic. The people exercise their sovereignty through their representatives and by the referendum process. The Constitution provide for universal adult suffrage. Anyone who is a major is allowed to exercise their right to vote. 7.6.3 Executive French President is different from his counterparts in Britain and the United States. He is head of the state like the British monarch, and he also heads the government like the American president. The tilt is more towards the American system, even though he has some symbolic powers. This is an important feature of the Fifth Republic, which sought to make the position of the president stronger compared to the previous constitution, the Fourth Republic. The president has the following executive powers: he appoints the prime minister and on his recommendation appoints other members and removes them. He presides over the meeting of the Council of Ministers. He negotiates and ratifies the treaties with foreign nations. He is the commander-in-chief of the armed forces and makes appoints to all civil and military posts. He also appoints 3 members of the Constitutional Council. He also does the symbolic job of receiving and accrediting foreign ambassadors and envoys. His legislative powers includes: he is given power to send back any bill for reconsideration to the Parliament if certain conditions are met. He can summon extraordinary sessions of the Parliament when he wishes. He signs the ordinance and orders decided by the Council of Ministers. He can dissolve the National Assembly in consultation with the Prime Minister and the President of the Assemblies. The President can also submit bills of enormous public importance for referendum and thus ratifies it, if it is accepted by majority of the people. The following are his judicial powers. He has the power to grant pardon. He also presides over the High Council of Judges, to which he nominates some members, and upon President is the responsibility to guarantee the independence of the judiciary. President has also been given unlimited powers during the emergency. Thus the President can declare emergency and take necessary action to defend the independence and integrity of France. Also, only the President can decide when to withdraw the emergency. He can prolong it for any period. President has thus been given sweeping powers in this case. The President is the arbiter of the Constitution. He has the right to interpret the Constitution. He should oversee the effective observation of the Constitution. The Prime Minister is appointed by the President. The Prime Minister then selects his ministers, who are also appointed by the President. He cannot shuffle the cabinet as he wishes. The Prime Minister is responsible for the conduct of the government affairs. He should ensure the legislations are implemented properly. The Prime Minister is the important link between the executive and the legislation. Though he is not a member of the legislature, he is responsible for that. Legislature too has the power to remove the Prime Minister by passing a no-confidence 314 16 hours 38 minutes and 29 seconds. 7. Comparison of Indian constitutional scheme with that of other countries 315. Motion. Unlike other democracies, the Prime Minister cannot claim to be the head of the Council of Ministers. It is the President who presides over them. The Council of Ministers have the power to enact ordinances. This is one form of delegated legislative powers given to the Council of Ministers by the legislature. The Council of Ministers can also declare martial law. The Council, though not from the Parliament, is responsible to it. The Council, with President as its head, determine and conduct the policy of the nation. The Council of Ministers can also promulgate finance bill as an ordinance if the Parliament fails to ratify it within the given time frame. Like the Prime Minister, the Council too is responsible to the National Assembly. Its powers are limited due to the presence of President and their responsibility to the Prime Minister, who appoints and removes them, to the constitutional responsibility to the National Assembly. 7.6.4 Legislature. The French Parliament has 2 houses, the Upper Senate and the Lower National Assembly. Unlike the British system, the President is not part of the legislature. The Parliament is bound to meet twice a year. The lower house is elected by direct universal adult suffrage and the upper house by indirect election. The Parliament is basically a legislative body. and its important function lie in passing laws and approving bills. The Parliament is given wide powers to make law in various areas like civil rights and fundamental guarantees given to the citizens, national defense, criminal procedure, amnesty, creation of new jurisdiction, tax rates, etc. The Prime Minister and his Council of Ministers are responsible to the National Assembly. The National Assembly can pass a censure motion to challenge the responsibility of the ministers. The other ways of controlling the executives is through commissions, oral or written questions, resolutions, debates and not passing the budget. The Parliament has the power to impeach the President for high treason, but it will be investigated by the High Court of Justice. The Parliament controls the purse of the nation. Both National Assembly and the Senate enjoy co-equal power in approving the finance bill. The Parliament can only delay passing of the budget, and it cannot be more than 70 days after which the government can pass the ordinance. It cannot outrightly reject the budget but can propose amendments. The President of National Assembly and the Senate nominate 3 members each to the Constitutional Council. Equal members are elected from both National Assembly and the Senate to the High Court of Justice from amongst its members. Some of the other powers are: wars can be declared only after the approval by the Parliament, martial law can be extended beyond 7 days after the approval by the Parliament, any constitutional amendment bill has to be passed by the Parliament, any international treaty need approval of the Parliament, and it can also set up commissions to carry out inquiry. Except in few instances, the Senate acts subordinate to the National Assembly, which has been given more powers in the Fifth Republic. 7.6.5 Judiciary. The French judiciary is unique and different from the British system. It has codified law for both criminal and civil cases. The judge does not depend upon precedents and is free to give his own judgment, unlike England and USA where precedents play important. French system assigns insignificant role to it. The important features are unity, symmetry, and authority. 315 16 hours 38 minutes and 29 seconds. 316. The judges are not elected but are appointed by High Council of Judges and by other bodies like the President. The French system follows dual hierarchy. It has a separate ordinary courts to try civil and criminal cases. Its appeal lies to the Court of Cassation. The other entity is the administrative courts, which take up issues concerning the administrative authorities and also public grievances against them. The topmost court is the Council d'État, the Council of State. There is separate court of conflict to deal with disputes between these two separate courts. French court, unlike in the United States, derive powers from the Parliament and not the Constitution. Thus they do not have power to declare any law passed by the Parliament as unconstitutional. They, thus, do not possess the power of judicial review. The Constitutional Council determines the validity of a law on request by either President or Prime Minister or the Presidents of both Houses of the Parliament. The office of Parquet is similar to the public prosecutor. They are agents of state who cannot be removed. Both criminal and some civil cases are handled by them. They also monitor the execution of the judgments and decrees. The French system guarantees independence of judiciary by keeping the executive out from the appointment process. The President is the guarantor for this independence to the judiciary. At lower level, judges are appointed through competitive exams. They are also given training, making the French judges competent and of high caliber. The Constitution guarantees protection against arbitrary arrest and detention. Judiciary thus acts to protect individual liberty. Unlike in the United States, which adopts the fundamental feature of separation of powers, the French system has made judiciary subversive to executive and the legislature. The judges are made to work under a minister of the judicial department. All judgments are delivered by collegiality of judges. This is to ensure judgments are not corrupted. Only at higher level, there is a separate court to hear appeals of criminal and civil side, in lower levels, there are no separate courts. Thus a court can preside over both civil and criminal cases. There is also provision to create separate courts for issues like industrial disputes, commercial tribunals, etc. Apart from these, the French Constitution provides for 3 new courts. They are the Supreme Council of Judges, High Court of Justice and the Constitutional Council. The Supreme Council of Judges is headed by the President of the Republic. Apart from him there are other members appointed by him. The function of this body is to make appointments to the higher courts like Court of Cassation, etc. It also acts as the disciplinary council for the judges. The High Court of Justice consists of equal number of members appointed by the National Assembly and the Senate. The President is tried by this body if he is indicted for high treason. Other government officials are tried for conspiracy against the security of the state. The Constitutional Council decides the constitutionality and validity of an act or law before even passed by the Parliament. Unlike the United States, India, where judicial review is a fundamental feature, French courts have not been given the power to declare any law to be unconstitutional. Apart from this, they also ensure that election of president is held regularly, examine complaints regarding the election to the president and declare the results of the presidential election and of the referendums. Though the president is not bound by the advice of council, it is important for him to seek its advice as the council is considered to be the pulse of the French people. Short and medium-term loans, loans for food parks and food processing unit, loans to cold storage, warehouses, and cold chain infrastructure, credit facilities to market federations, rural infrastructure development fund, direct finance to cooperative banks, financing and supporting producer organizations, NABARD, infrastructures development assistance. Long-term loans. Eligible schemes for refinance under non. In this, you will learn about fundamental concepts regarding Indian election, the Election Commission of India, powers and functions, the Representation of People Act, an introduction, background of the Representation of Peoples Acts, an overview of Representation of Peoples Acts 1950 and 1951, important provisions of Representative of Peoples Acts 1950 and 1951, criminalization of politics, electoral reforms, recent landmark judgments of the Supreme Court Q&A regarding elections and process associated with it, conclusion. The only way in which you can establish democracy by the will of the people is by the conduct of free and fair elections. Former Chief Election Commissioner Shri T.N. Shin in his A Heart Full of Burden. 9.1 Fundamental concepts regarding Indian election. The following are the fundamental bases which are important in order to understand the electoral system in the country. The Representation of the Peoples Act deals with all the points mentioned in the following list, and understanding these fundamentals will better help the readers grasp its provisions. 9.1.1 Indian election scenario. India is a constitutional democracy with a parliamentary system of government, and at the heart of the system is a commitment to hold regular, free, and fair elections. These elections determine representation of people, the composition of the government, the membership of the 2 houses of parliament, the state and union territory legislative assemblies, and the presidency and vice presidency elections are conducted according to the constitutional provisions, supplemented by laws made by the parliament. The major laws are Representation of the People Act, 1950, which mainly deals with the preparation and revision of electoral rolls, and the Representation of the People Act, 1951, which deals, in detail, with all aspects of conduct of elections and post-election disputes. The Supreme Court of India has held that where the enacted laws are silent or make insufficient provision to deal with a given situation in the conduct of elections, the Election Commission has the residuary powers under the Constitution to act in an appropriate manner. 9.1.2 Indian elections. Scale of operation. Elections in India are events involving political mobilization and organizational complexity on an amazing scale. In the 2004 election to Lok Sabha there were 1,351 candidates from 6 national parties, 801 candidates from 36 state parties, 898 candidates from officially recognized parties and 2,385 independent candidates. A total number of 38,99,48,330 people voted out of total electorate size of 67,14,87,930. The Election Commission employed almost 4 million people to run the election. A vast number of civilian police and security forces were deployed to ensure that the elections were carried out peacefully. Conduct of general elections in India for electing a new lower house of parliament, Lok Sabha, involves management of the largest event in the world. The electorate exceeds 670 million electors in about 7,00,000 polling stations spread across widely varying geographic and climatic zones. Polling stations are located in the snow-clad mountains in the Himalayas, the deserts of the Rajasthan and in sparsely populated islands in the Indian Ocean. 9.1.3 Constituencies and reservation of seats. The country has been divided into 543 parliamentary constituencies, each of which sends one MP to the Lok Sabha, the lower house of the parliament. The size and shape of the parliamentary constituencies are determined by an independent delimitation commission, which aims to create constituencies which have roughly the same population, subject to geographical considerations and the boundaries of the states and administrative areas. 9.1.4 How constituency boundaries are drawn up. Delimitation is the redrawing of the boundaries of parliamentary or assembly constituencies to make sure that there are, as near as practicable, the same number of people in each constituency. In India, boundaries are meant to be examined after the 10-year census to reflect changes in population, for which Parliament by law establishes an independent delimitation commission, made up of the Chief Election Commissioner and 2 judges or ex-judges from the Supreme Court or High Court. However, under a constitutional amendment of 1976, delimitation was suspended until after the census of 2001, ostensibly so that state family planning programs would not affect their political representation in the Lok Sabha and Vidhan Sabhas. This has led to wide discrepancies in the size of constituencies, with the largest having over 25,000,000 electors, and the smallest less than 50,000. Delimitation exercise, with 2001 census data released on December 31, 2003, has been completed. 9.1.5 Reservation of seats. The Constitution puts a limit on the size of the Lok Sabha of 550 elected members, apart from 2 members who can be nominated by the President to represent the Anglo-Indian community. 440 17 hours 42 minutes and 21 seconds. 9. Representation of People Act 441. There are also provisions to ensure the representation of scheduled castes and scheduled tribes, with reserved constituencies where only candidates from these communities can stand for election. 9.1.6 System of election. Elections to the Lok Sabha are carried out using a first-past-the-post electoral system. The country is split up into separate geographical areas, known as constituencies, and the electors can cast 1 vote each for a candidate. Although most candidates stand as independents, most successful candidates stand as members of political parties, the winner being the candidate who gets maximum votes. 9.1.7 Parliament. The Parliament of the Union consists of the President, the Lok Sabha, House of People, and the Rajya Sabha, Council of States. The President is the head of the state, and he appoints the Prime Minister, who runs the government, according to the political composition of the Lok Sabha. Although the government is headed by a Prime Minister, the Cabinet is the central decision-making body of the government. Members of more than one party can make up a government, and although the governing parties may be a minority in the Lok Sabha, they can only govern as long as they have the confidence of a majority of MPs, the members of the Lok Sabha. As well as being the body, which determines whom makes up the government, the Lok Sabha is the main legislative body, along with the Rajya Sabha. 9.1.8 Rajya Sabha. The Council of the States. The members of the Rajya Sabha are elected indirectly, rather than by the citizens at large. Rajya Sabha members are elected by each state Vidhan Sabha using the single transferable vote system. Unlike most federal systems, the number of members returned by each state is roughly in proportion to their population. At present there are 233 members of the Rajya Sabha elected by the Vidhan Sabhas, and there are also 12 members nominated by the President as representatives of literature, science, art, and social services. Rajya Sabha members can serve for 6 years, and elections are staggered, with 1/3 of the assembly being elected every 2 years. 9.1.9 Nominated members. The President can nominate 2 members of the Lok Sabha if it is felt that the representation of the Anglo-Indian community is inadequate, and 12 members of the Rajya Sabha, to represent literature, science, art, and the social services. September 1, 10 state assemblies. India is a federal country, and the constitution gives the states and union territories significant control over their own government. The Vidhan Sabhas, legislative assemblies, are directly elected bodies set up to carry out the administration of the government in the 28 states of India. In some states there is a bicameral organization of legislatures, with both an upper and lower house. 2 of the 7 union territories, viz., the National Capital Territory of Delhi and Pondicherry, also have legislative assemblies. 441 17 hours 42 minutes and 21 seconds. 442. Elections to the Vidhan Sabhas are carried out in the same manner as for the Lok Sabha election, with the states and union territories divided into single-member constituencies, and the first past the post-electoral system used. The assemblies range in size, according to population. The largest Vidhan Sabha is for Uttar Pradesh, with 403 members, the smallest Pondicherry, with 30 members. September 1, 11 President and Vice President. The President is elected by the elected members of the Vidhan Sabha, Lok Sabha, and Rajya Sabha, and serves for a period of 5 years, although they can stand for re-election. A formula is used to allocate votes so there is a balance between the population of each state and the number of votes assembly members from a state can cast, and to give an equal balance between state assembly members and national parliament members. If no candidate receives a majority of votes, there is a system by which losing candidates are eliminated from the contest and votes for them transferred to other candidates, until one gains a majority. The Vice President is elected by a direct vote of all members elected and nominated, of the Lok Sabha and Rajya Sabha. September 1, 12 Who can vote? The democratic system in India is based on the principle of universal adult suffrage, that any citizen over the age of 18 can vote in an election. Before 1989 the age limit was 21. The right to vote is irrespective of caste, creed, religion, or gender. Those who are deemed unsound of mind, and people convicted of certain criminal offences are not allowed to vote. September 1, 13 The electoral roll. The electoral roll is a list of all people in the constituency who are registered to vote in Indian elections. Only those people with their names on the electoral roll are allowed to vote. The electoral roll is normally revised every year to add the names of those who are to turn 18 on the January 1 of that year or have moved into a constituency, and to remove the names of those who have died or moved out of a constituency. If one is eligible to vote and is not on the electoral roll, they can apply to the electoral registration officer of the constituency, who will update the register. The updation of the electoral roll stops only during an election campaign, after the nominations for candidates are closed. September 1, 14 Computerization of rolls. In 1998 the Commission took a historic decision to computerize the entire electoral rolls of 620 million voters. This work has been completed and now well-printed electoral rolls are available. The photo identity card number of the voter has also been printed in the electoral rolls, for cross-linking. The printed electoral rolls as well as CDs containing these rolls are available for sale to general public. National and state parties are provided these free of cost after every revision of electoral rolls. Entire countries' rolls are also available on Election Commission's website. September 1, 15 electors' photo identity cards in an attempt to improve the accuracy of the electoral roll and prevent electoral fraud. The Election Commission ordered the making of photo identity cards for all voters in the country in August 1993. To take advantage of latest technological innovations, the Commission issues 442 17 hours 42 minutes and 21 seconds. 9 Representation of People Act 443. Revised Guidelines for EPIC program in May 2000. More than 450 million identity cards have been distributed till now. Electoral Photo Identity Card, EPIC, is an identity document issued by the Electoral Registration Officer. The EPIC contains details of the elector like name, father's/mother's/husband's name, date of birth/age on the qualifying date, sex, address and most importantly, the photograph of the elector. EPIC is a permanent document for an elector. It is to be used by the elector to establish one's identity at the time of polls. It is compulsory for an elector who has been issued an EPIC to produce the EPIC at the time of polling to enable voting. Every EPIC is issued under a unique EPIC number. EPIC number is an alphanumeric string with 3 alphabetical codes followed by a 7-digit number. While the first 3 alphabetical codes, called the Functional Unique Serial Number, FUSN, code is unique for every assembly constituency and is provided by the Election Commission. The numeric code that follows the FUSN code is a 6-digit running serial number followed by 1-digit checksum making a total of 7 digits. September 1, 16 When do elections take place? Elections for the Lok Sabha and every state legislative assembly have to take place every 5 years, unless called earlier. The President can dissolve Lok Sabha and call a general election before 5 years is up, if the government can no longer command the confidence of the Lok Sabha, and if there is no alternative government available to take over. Governments have found it increasingly difficult to stay in power for the full term of a Lok Sabha in recent times, and so elections have often been held before the 5-year limit. A constitutional amendment passed in 1975, as part of the government-declared emergency, postponed the election due to be held in 1976. This amendment was later rescinded, and regular elections resumed in 1977. Holding of regular elections can only be stopped by means of a constitutional amendment and in consultation with the Election Commission, and it is recognized that interruptions of regular elections are acceptable only in extraordinary circumstances.